Yep, that's all I know.
Absolutely, with all the records.
Yes, okay with that. Yes. Okay. And what we
The Honorable Humphrey Cower presiding.
Okay, please be seated, everybody. Mike, if you're listening in, you've got the echo again. Hey, sir, I need Mike. We've got the echo again. I need Mike. The echo is back. Sure, it'll just be a moment. I don't hear the echo. Great. Okay, thank you, Mike. This is case number 2018 CA 5321, Jack Kowalski, etc. versus Johns Hopkins All Children's Hospital. Let's take appearances starting with the plaintiffs, please.
Greg Anderson, Nick Whitney on behalf of the Kowalski family.
Ethan Shapiro, Howard Hunter, Pat Crowells, David Hughes for All Children's Hospital.
I've been handed an exhibit list. I see that there are very few stipulations. Are the ones that are marked yes, are they able to come in at this time?
That's fine, Judge. They actually left off some of my Ys. If you look, number 2687, 2688, and 2408, pages 1738 to 1739 had a Y.
Thank you. At this time, the court receives into evidence Exhibit 2019, 2687, 2688. I'm sorry, these aren't in order, Madam Clerk, but the list isn't in order. 2408, pages 1738 to 1739. Court also receives 2417, 2418. Guess that's it. What's next? I guess we've got a lot of exhibits to go over.
Judge, we'd like to talk about the texts between
Help
Dr.
me out.
D's.
Just give me a document number. Let's start with that always.
2106.
2106.
Okay. Can you bring it up so we can know what we're talking about? You may continue, Mr. Anderson.
Thank you, Judge. All right, this is an exchange of emails which occurred on October 18th, 2015, and they reference the 48-hour video, the court notes. We are moving to admit them as a statement of a party opponent, and the defense has actually, we move to admit.
How many pages is this?
One or two.
6.
6 pages.
6 pages of all that? We're putting the whole thing in? All right, we're putting the whole thing in, 6 pages.
And these are all between Dr. Sally Smith and Dr. Dees?
Yes, Your Honor.
Your Honor, I believe there's also some later text message between Dr. Sally Smith and Dr. Catherine Major, also a hospitalist at the hospital.
Yeah, I didn't know we were putting that part in, Judge. But yes.
Can I see the next page? Okay, keep going, please. Next. Okay, next. Next. Defense, what's your position?
Our position is, first, these aren't the actual texts. They are retyped by somebody. So we object because best evidence rule and hearsay. The next exhibit, 2116, are the actual messages, although they have a lot of issues with them, I will grant you, because they've got somebody typed things on it, they have phone numbers on it, but anyway, that's our objection, Judge.
Okay, so what you're telling me is 2106 is just a clean version, condensed perhaps, of what's on 2116?
Yes, and the doctors are not parties. They're not corporate representatives of the hospital, so they're not admissions of the hospital.
Well, they're still agents of the hospital. Perhaps Dr. Sally Smith isn't.
Correct.
Arguably. But now, I'm going to overrule the hearsay, but let's talk about the format of these.
Yes, Your Honor. So the version you're looking at here was produced by Sally Smith's counsel back at the time. As Ms. Krause mentioned, 2116 is the records from the cell phone carrier, which are even more difficult to decipher. And we have also prepared a demonstrative aid that's been provided to the defense that is something more akin to what you see here. It's the clean text messages attributed to the doctor, and it's in the format that everyone would be used to seeing, with text bubbles going back and forth. Wow. So whichever one we admit, we have a demonstrative aid that will be clean.
Well, Judge Mike, so if you look at,
May I see 2116, please?
if you look at the, I'm sorry, Judge, yeah, if you look at number 2 there, was not sure about court, guess I better find out about that. And compare it to the one they did, there's a smirky smiley face on the one on 2106. I don't see that on number 2, so I'm not sure how that arrived.
Wait a second. So can you make 2116 a little bit bigger for me, please? What is this red comment?
This is our follow-up to production from Sally Smith, and that appears to be a statement by her counsel explaining why the first disclosure didn't have that message.
Now, Ms. Crowell, what are you saying is not correct? I'm not.
So number 2 on 2116 has the statement, the text. If you look at 2106, they added a smirky face.
That's the wrong.
That's not it.
Where's the 1508? You say it's number 2?
Number timestamp 20, yeah, it's from 10/18/16.
2:08 p.m.
You see the text.
15:08.
Not sure about court. I guess I better find out about that, is the last comment.
Well, Mr. Whitney, Ms. Crowell is correct that your summary sheet has an emoji that.
Yes, Your Honor, I see the discrepancy, but that's not, just to be clear, that's not our summary sheet. That is from Smith's counsel. We did not create the emoji.
Well,
Here's, I hate to say this, but if you're going to use a summary, it's got to be accurate. And if not, we're going to use the original, but you then need to redact the comments.
and the personal phone numbers, Judge.
We're prepared with redactions, I'm sure. We have the redactions prepared to the one you're looking at on the left, Your Honor.
Okay, so have you shown that to the other side so they've had an opportunity?
Have we sent that to you? It was sent to them this morning with the redaction. I'm sorry?
This morning to add to the system. I don't know who's sent.
How in the world are they supposed to, I mean, I had them here at 8:15. If you sent it to them this morning, how are they supposed to have time to compare what you sent to the original?
What I'm answering for.
How many problems, Ms. Crowell, are there with the 2106? Is it just that one where there's?
No, there's another one at 0804, 10/19/16. There's another emoji. I didn't honestly, Judge, I didn't do side by side every line comparison because I just didn't. But that's what stood out to me just looking at it now. And, yeah, I didn't do it line by line.
Fastest way to address this would be to fix 2106. However, you're correct that technically the better one, the best evidence is this other one, which I guess is 2116. So,
Can I suggest, I don't know what witnesses would possibly be used with today.
Mr. Kowalski.
Well, Judge, I don't know how they.
to comment on texts between two doctors that weren't sent to Mr. Kowalski?
To comment on the concealment of the videotaping of his daughter and how he was not advised that his daughter was being put in a room for 48 hours.
Well, Judge, they can ask them that without.
Yeah, I don't see how you're using a text message between one doctor to another doctor with Mr. Kowalski. I agree that you're going to be able to use these text messages, but the format you've got them right this second isn't ready.
Understood.
There's really only about 5 lines out of this whole thing that we,
The exhibit is not ready. That's on you. The exhibit's not ready. So let's go on to the next one.
and can we get on the record exactly what we need to do to
You need to make sure that the summary is identical to the content of the original, or the original needs to be redacted to remove Mr. Haskell's comments
And the personal phone numbers, Judge.
and the phone numbers.
understood?
Well, it needs to be redacted for part of the phone number, but they need to be able to show. Can you pull it back up, because I don't remember if the name.
It says the name, Judge. It says
does.
Sally Smith, Qualities. It says the names, and then it has their phone numbers after that.
Okay, so long as there is no doubt who it is. Okay. So,
We will get them the accurate copy and address it another time.
what's next?
What's our next exhibit that we need to worry about?
Explain us what's next.
Well, we're not calling Kirkpatrick or Hannah, so hold on.
I guess we should get, Mr. Whitney is locating the exhibits, and I'll explain why. Last night, I had the chance to see Dr. Kirkpatrick in person, and he is definitely not well and in no condition to go on the stand. I texted counsel earlier this morning on that. There's nothing I could really do about it. I had Dr. Henschke coming in at the same time, and so we made a judgment call that we are not going to call Dr. Kirkpatrick today. We are going to continue with Jack Kowalski, and then we want to play the deposition of Rebecca Johnson, and then the deposition of Kathy Beatty. And then we would like to put Dr. Henschke on, since she is here for her timing, and we had notified counsel before. However, again, as we expressed to the court and to counsel, we are running, just because of the way things go, we're running about a day late, or earlier, excuse me. And so we are moving people up and deciding who to call and not to call for 2 reasons, Judge. First, the people flying into town, example, Dr. Cantu today for tomorrow morning, which counsel knows about. Dr. Henschke had originally been scheduled to go on.
Can you just tell me what you're asking me?
To move Dr. Henschke from later tomorrow afternoon, up to later this afternoon.
And the issue is they weren't told about it until when?
They were told about it this morning,
No.
so she goes tomorrow.
Well, I don't know when she's going, but she's not going today.
All right, well, she's scheduled, but okay.
If you didn't tell them until today, we have to give some minimum level of due process here. So let's please, I appreciate that scheduling is a nightmare, but you can't just drop a doctor on them the morning of.
I understand, Your Honor. Had I been able to ascertain the facts and make a decision, I would have texted them, but it really wouldn't have made any difference because it was 11:30 and 12 at night, and I didn't think that they were still up and intending on, even if they could, they would want to stay up and prepare for Henschke. So I kind of figured this would happen, but I have to ask because I don't want any holes in our case.
Well, I have ruled on about, 12 or 13 depositions by now, even maybe more. Hopefully some of them are cut and ready to go.
We've got Beatty and we have Rebecca Johnson. We're going to play Rebecca Johnson first. As to Kathy Beatty, it is recut. The only thing that's left after the court's notations and sustaining of objections is for counsel to review it to ensure on those highlighted portions that the court had concerns with that we had properly edited it. I don't anticipate, just having flipped through it, that would take longer than a half hour. If counsel can spare one of their many attorneys to flip through that over the course of the next hour or two, then Beatty will be ready as well, and that'll take up most of our afternoon.
Judge,
Could I
go ahead.
So neither Dr. Kirkpatrick or Dr. Hanna are coming today?
I have not been able to finish preparing Dr. Hanna because of all the hijinks yesterday, and I do not intend to put a witness on the stand until I've had the opportunity to do so. You know, we're already working 18-hour days, so there's only so much we can do, and these doctors take a long time. We started prepping them before trial, obviously, going through the records, doing everything we're supposed to do, but this is reality.
Okay.
You know?
So what you're telling me is you got Jack Kowalski and then a whole bunch of videos.
Yes.
Now,
2 videos.
2 videos. That's fine, but with the videos, probably some paralegal could be looking at because there's rulings and it should be a.
We've looked at the Rebecca Johnson one, Judge. That's ready to go, is my understanding. We have not, didn't know until this morning that they didn't get us Kathy Beatty's. Did you give it to us?
I don't know, do we have?
The actual, we can't view it unless you've sent it to us.
I can get it to you.
Okay, so we haven't had the video to view, but they're gonna get it to us this morning, so maybe over lunch. It's a little difficult to do it during the court, but at lunchtime, we will look at Kathy Beatty.
I can understand that, but perhaps somebody can go into one of those witness rooms and watch it this morning and just compare it to
Right, that will.
the court's rulings.
Yes, we'll make sure that happens, Judge.
I think that's a fair request.
Yes.
Okay, so we're going to finish Mr. Kowalski, and then we'll have a couple of videos today. Tomorrow is Cantu
Yes, sir.
and whom?
Henschke.
Henschke.
They've both been planned for a long time. We've informed counsel.
Well, the only reason I mentioned this is because they had asked for Dr. Jennifer Katzenstein tomorrow. I need to tell her now if they're not planning on calling her.
Is she the one coming from the Panhandle?
No, she's local at All Children's, but she booked her schedule off. If they don't plan on calling her, I'd like to let her know now that she's released.
Okay, well, that's dependent on what the court decides on doing with Maya Kowalski's disclosure. Because she wrote the psychological note in the hospital that shows it's in their record. So it doesn't make sense. We were told also in the motion that she's on a Disney cruise, so.
She came back from the Disney cruise Monday morning. She is planning on being here tomorrow to testify at their request.
And
As far as we're hearing that.
Okay, so do you want to deal with the motion now with respect to Maya Kowalski's?
Yes, Your Honor. Sure.
yes, Your Honor.
Okay.
We also, there are, and we can speak to them, mentions of this in Dr. Henschke's file as well. And have we provided the court with that yet?
We can pull it up.
All right. And we can show the court in just a moment what they are. When Dr. Henschke came in last night, we started at least to talk to her and let her know what was going on, and made her aware of this, and that's how she brought to our attention that she had some notations of a similar type in hers, if the court wants to see them.
Well, I I'm not sure just seeing more of the same is an issue that we need to deal with right this second. Okay. I have read the motions and the response. Do the parties wish to add any further argument?
On behalf of plaintiff, Your Honor, there is no signs or indications, and nor would I as an officer of the court ever misrepresent my knowledge of this. That it is a well-known psychological phenomenon, the court's familiar with that children often suppress these things. It was revealed in two ways. One, to Dr. Katzenstein, and now I learned there's a similar type of comment in the Jackie Henschke records. As soon as we knew about it, we did the right thing, which was to confirm, before we raised something like that there was confirmatory testimony and knowledge, which we did with Jack Bertram. In this instance, I think the goal should be the truth, and that the jury should have all of the information. This case has been about Maya being assaulted or battered since the very start of it, and there have been allegations raised. I would point out, Your Honor, that upon receipt of the response, we did the timing upon receipt of the response to our subpoena ducis tecum for the Henschke records. The defense began, from our notes, really pushing in earnest for any mention of sexual misconduct to be excluded. And I'd like to know from counsel whether they had identified something that I candidly did not, because I didn't even expect to call her, if the court recalls. But I'd like to know from them whether they had spotted back in response to subpoena ducis tecum those notations as well. I have the belief, although I'm not accusing counsel of anything, but I have the belief that their knowledge was far earlier than this, and the hope was that Maya would keep it in, or that we wouldn't notice some of these notations, which admittedly are oblique in some circumstances, though Henschke's is much clearer. And so if in fact they had this knowledge from the ducis tecum and otherwise, then they had advance notice of this, and the fact that they have pursued so aggressively, excluding any type of reference whatsoever, with Beatty as the focus, is curious to me. In this instance, I would think that if you need, we've got the Katzenstein record is already in as a joint exhibit, so there is some evidence within the record without objection to that. So in this instance, having Maya Kowalski expand on what we already know, which is her belief that some of the actions of Kathy Beatty were of a unusual nature towards her, we believe that there was more than adequate notice and that it should go in. Typically, the final thing I'll say is typically in trials, new facts come up in every big trial. And typically the pleadings collapse into the proof at trial because it's impossible to plead every single fact in the complaint, nor even in an ultimate fact pleading state is it required to plead every fact. So we would move the court pursuant to our motion to allow that in.
Judge, I'm only going to address the comment about the accusation regarding the defense attempts to remove the spurious allegation of sexual abuse by Kathy Beatty, since I was the one that was addressing that. The only allegations in the complaint regarding any type of, quote, sexual battery, end quote, were against Kathy Beatty as her former counsel when she was a member of this case. I immediately began trying to address that because there were no factual allegations to support that Kathy Beatty, anything Kathy Beatty did was of any type of sexual connotation. And that was the basis for all of those motions to try to get that stricken, which the court granted as far as motion in limine in regard to those type of unfounded accusations regarding Kathy Beatty.
And the motion, Your Honor, is basically a motion on an issue of law, whether they're entitled to bring this up in a situation where they have already admitted they didn't plead this. in the effort to try to specify better what the false imprisonment claim was and what the battery claim was, that they've laid it out. And their battery claim deals with Ms. Beatty in various places in the hospital and with other nurses and social workers in and around the 2-day period involving the EEG room. That's the battery that we came here prepared to try as a matter of due process. And now they're wanting to bring this in. The notion that they can bring this in as something under Rule 1.19.190B, this has not been tried already by express or implied consent, and this is otherwise something that simply cannot be brought up at this time on these pleadings. So if you have additional questions about what we've submitted, that's fine. I don't think we need to go into the facts, but I know that Dr. Katzenstein has a very different explanation for her note.
The court has before, or Mr. Anderson, were you going to say something else?
Typically, we're talking about one incident here, Your Honor, and typically this is handled through cross-examination by pointing out that some of the incidents that the plaintiff testifies to in trial are different than those in the deposition, and they're impeached on that basis if that ends up being the case. I would finally point out that the Katzenstein records went in without objection, and if we are in fact true, if our allegations are true, then there was no objection, and that allegation went in without any effort to clarify that or otherwise. So there's no prejudice here if, and as it appears from at least 2 independent sources of records, that there was any true prejudice.
The court has before it plaintiff's motion to admit newly discovered evidence or alternatively to amend the complaint, which is at docket identification number or DIN 3444. The response actually was docketed before at DIN 3443. That has to do with how the clerk docketed when those were filed over the weekend. The genesis of plaintiff's motion has to do with what is clearly a late disclosure by Maya Kowalski. That disclosure became known to the court and to the defense counsel during the trial. That was after the jury had already been sworn. We had already conducted oral argument, opening statements, and started with witnesses. The court will assume, for the sake of ruling on this motion, that Maya Kowalski's statements are correct, that there was some type of sexual incident that occurred while she was at Johns Hopkins All Children's Hospital in October. The question is, given where we are right now in this trial, what are we able to do, if anything, about it? The plaintiffs reference the Binger case, but Binger really is talking about undisclosed witnesses, not an amendment to add new claims. We also have a rule that allows for pleadings to be amended for items that were tried by express or implied consent. Clearly, the defendants are objecting to try an issue that was not part of the pleadings, and it clearly was not part of the pleadings. So we get down to a fundamental due process issue, which is notice. The whole point of having the pleadings is to explain the conduct that the plaintiffs are accusing the defendants of engaging in, so that the defendants can prepare and defend against those. And it's just a simple concept. It's notice. Here, we did not ask questions of the jurors about sexual assault. That would have been a major focus of individual voir dire by the court and the parties had we known about Maya Kowalski's disclosure. We would have asked those jurors. Some of those jurors may or may not be seated here today, but we wouldn't know and have no way of knowing because we had no opportunity to ask those questions given the late disclosure. So I do not see how we can try the issue of a alleged sexual offense, again, assuming that what Maya Kowalski says is true. The ability to amend pleadings, even if you can amend pleadings during trial, and I'm not sure you can unless there's consent. But to amend pleadings, we look at a three-pronged test. One, would it be futile? Well, clearly, if Maya Kowalski's allegations are correct, it would not be futile because, as the plaintiff suggests, they want to bring a battery and a negligent security claim. Is there an abuse of the amendment? Well, we're on number 8, so that's probably a jump ball at this point in time. But the third prong is prejudice. And here the prejudice to the defendant is more than palpable. It's extremely palpable because how are we able to try an issue when we haven't even asked the jurors who are seated on this jury about their views of sexual assault? So I don't see how we can do it. So we're now down to the question of are the plaintiffs moving for a mistrial at this point in an effort to seek to add this in? Now, before you answer that question, let's think this through, Mr. Anderson. Assume for the sake of argument you wanted a mistrial and I granted it. You added a count for battery. Assuming that the defense would be able to identify the individual, since what you're alleging is effectively criminal conduct, we're now going to be confronted with a Fifth Amendment invocation, most likely, by the individual who Maya Kowalski would be accusing of this sexual assault. With the invocation of the Fifth Amendment by that individual, that might mean this entire trial, if we granted a mistrial now, might then be suspended. I don't know if your client has made a report to the St. Petersburg Police Department for this sexual assault. I don't know if that's forthcoming. And if so, whether the state attorney would investigate it. I don't know what the statute of limitations is. I don't know what would be charged. I don't know the fact that she was a minor. So it is an entire panoply of issues that if you add a battery count for this issue is not a very neat and clean, oh, let's just bring it back. Perhaps that's why you were talking about negligent security, but at the same time, you're still going to have the same issue relative to identifying the individual who did it and possibly having a Fifth Amendment invocation that would delay. So I'm going to deny the request to admit testimony by the witnesses on an issue that was not raised in the pleadings. And again, this is not that I don't believe or do believe, because for purposes of my motion ruling, I am assuming that what Maya Kowalski is saying is true. It's just how this was presented in the middle of trial is the prejudice is so severe that there would be no way we could continue with the trial in this posture, and we would have to go to a discussion of a mistrial. So I'm denying the motion to admit the evidence, and I'm denying the alternative motion to amend the complaint. So at this point, the question is, do the plaintiffs wish to move for a mistrial?
Obviously, we would need to consider that, Judge. We have begun considering it. I believe that the court, and would ask the court to withhold final on this and allow us to at least bring in Dr. Katzenstein so that you can hear a proffer on that. And then if we can bring in Dr. Henschke and the court can hear a proffer on that. Because I understand about the prejudice. What if the court concluded from the record that after the subpoena ducis tecum to Dr. Katzenstein and receipt of those records, that the court saw a marked increase in the amount of motion practice to exclude this? And the best way to do is ask as an officer of the court to them as whether after receipt of the either review of the Katzenstein notes or after receiving the Henschke notes, which I'd like to at least show the court, then if in fact they had that notice, regardless of whether we had picked up on it or not, because our client didn't tell us about it, and frankly it wasn't something we were searching for here, if in fact they knew through this and chose tactically not to raise it, knowing that there's a possibility, as every good trial lawyer does, that things come out at trial, the court might reconsider this. I am adamant that any good trial lawyer having some notice or idea about this in reading, in particular, the Henschke records, would be aware, given our allegations against Ms. Beatty in this regard, would be aware that that issue was out there. And careful trial lawyering, both sides, careful trial lawyering on both sides is to the effect that you plan for things that could come in as well as things that you don't think are going to come in but possibly could come in. And so I beg the indulgence of the court. I know you've spent a lot of time on this, but I beg the indulgence of the court to hear us out with some of this testimony. And what that would entail would be hearing from Dr. Henschke on it, hearing from Dr. Katzenstein on it, and questions as officers of the court as to counsel about the unusual nature of the increase of motion practice about sexual misconduct after they received the Henschke records. I'm not accusing anybody of anything, but these are the facts.
The reality, though, is one, it's still not in the pleadings, which is a huge due process issue. And two, we did not ask the jurors any questions about what, and I'm telling you, having sat through many sexual assault trials, is a huge issue, and it's a fertile ground for cause challenges of jurors. And so there is no way that you can cure that prejudice by any sort of statement. Well, they knew about it even though we didn't tell them about it. So your remedy would seem, there's always, if you think there's a fraud on the court, there's remedies you can engage in for fraud on the court. But at the end of the day, there is no pleading that supports this claim, and we did not address this issue in front of the jury. And I don't see how, even if you wanted me to wait for a further evaluation of information, how those two fundamental issues would change one bit. And those things cannot be changed at this time. So we're down to the question of, is there a mistrial motion or not?
Well, I can't make that call until I have a moment to talk to my client, obviously. We weren't sure of the court's ruling. I do also want to pull the transcript of the voir dire at the start, because we wanted to ask questions about this in terms of Kathy Beatty. The defense objected vociferously on it. And so it was not a situation where the issue of that was just out of the blue. We had already raised that with Kathy Beatty, and my memory of that was that the defense was adamant that we not talk about that in front of the jurors at all. The court ultimately agreed, but that's not necessarily our fault, because we foresaw that there were possibilities at this trial that Kathy Beatty would come forward in this regard. And so again, we want to make our record. I understand the court's direction. When would you like me to ask my client, and what do you want me to do?
Well, we're about 3 minutes before having the jury come in, so obviously right this second's not. But I see no reason to spend a lot of time and energy going forward if, one, you make a mistrial motion, and two, I grant it. I'm not saying I would grant it. I'm just saying I need to understand what you are moving for, if anything. The reality is, and that's why I put it out there about what would happen if you amended the pleadings to add a battery count, because I think you're going to run square into a Fifth Amendment issue. But hey, it's not my complaint. I'm just the guy calling the balls and strikes. But I do think it needs to be said that the issue with Catherine Beatty had to do with the allegation that Maya, or that Miss Beatty placed Maya on her lap when she gave her a hug and things like that. It was not in the realm of what you're talking about in this allegation by Maya Kowalski with respect to the white slender guy with the lab coat that we see in the records that you are referring to.
As to the...
And let me, because I've been letting you talk. I see Mr. Altenburn trying to say something, so let him say whatever he needs to say.
In light of the accusations that have come from the other side here in this public courtroom, I just want to state, as I think you have just explained, that my motions addressed to the issue of battery of this context were directed solely to that of Ms. Beatty, and it was based on the fact that we had taken depositions from Maya Kowalski and done various other discovery, and there was absolutely no evidence to have based an allegation in a complaint on a claim of sexual battery under the definitions in Florida law. So nothing of this was done to hide any evidence that we knew about at any time before this came up the other day.
Are there anything else we need to address before this jury comes in?
I wanted to announce that neither Kelly Perry nor Jennifer Anderson, counsel, was concerned about their type of illness. They both took COVID tests and they're negative. Do you have any other exhibits we need to talk about?
The only question I have, Judge, is a practical one that Your Honor made reference to. If there is to be a motion for mistrial, when might we expect a decision?
Well, I'm not going to let this carry longer than today. It's going to be resolved one way or the other today now. I still think we need to cut the videos. I still think we take the testimony from Jack Kowalski. It's just we're not going to get into this newfound allegation by Maya Kowalski with respect to that alleged sexual abuse.
Very well done. Thank you.
Anything else before we bring in the jury?
I don't believe so, Your Honor.
Let's bring in the jury. Please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation, and you did not receive any information about this case. Is that all correct? And I want to confirm that since you left us last, you have not been approached by anyone about this case. Is that correct? And I want to confirm that since the last time you were with us, that you have not seen any media accounts of this proceeding. Is that correct? Okay. I have been handed a note by one of the jurors about November 2nd, and when we will know for sure. let me tell you where we're at on November 2nd. I am on a statewide committee, and that is a day that I am actually supposed to be chairing a meeting in another county. We are ahead of schedule in this case. I feel November 2nd at this point in time, we don't really, I think we can probably safely call it, saying that you will not be here on this day, because even if we slow down, I still think we can still get you plenty of time to deliberate before that November 8th date that I told you about in jury selection. So from my perspective, I'm going to make the command decision now that November 2nd will not be a jury day. So for those that need to keep their medical appointments on that day, let's go ahead and keep those medical appointments.
Thank you.
Okay. Mr. Kowalski, come on down, sir. We're going to re-swear you since it's been overnight. Ask the clerk to please swear you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Welcome back.
Thank you.
All right. When we were talking yesterday, you were attempting to, I believe, leave on that Sunday the 9th. Is that right? I don't know.
Yes.
I'd like to show you what's been marked in evidence as Exhibit 1001-0063. Permission of the court. It's in evidence. May I publish it?
If it's in evidence. I'm sorry?
It's a vote, progress note. All right. If you would, please read down through particularly the second paragraph in the top half. And we're going to highlight a couple of phrases there. As you can see, the first sentence, and I then discussed with Michelle Smith, and did you understand Dr. Smith to be a doctor there at Johns Hopkins?
Yes.
Would be a discharge against medical advice, as we have not completed a wean of therapy, and Dr. Sally Smith has not had the opportunity to evaluate the case. Do you see that?
Judge, I object to the leading, and again, this is reading of the medical records.
But I can't.
We're not reading medical records.
All right. Were you ever informed that there was a goal of keeping you there based on a statement that it would be AMA, when AMA is not a legal basis for keeping someone in Florida with in these circumstances?
Object to the leading, it also calls for a legal conclusion.
Yeah, I'm going to overrule those objections. You can answer that question.
I'm sorry, if you could repeat it.
Sure. Were you ever informed that the hospital had been considering ways of how to keep you there, you and your family there, simply on the allegation that leaving would be against medical advice?
Oh, we weren't.
Object to the leading and the speculative.
He just overruled that.
Overruled. You can answer.
Can you?
We were told if we left, we'd be arrested. So,
Did they let you know there that they had really no right to keep you?
they had no right at that time, no.
And your concern, if you left, would be, or tried to leave, what did you picture happening to you and your family?
I don't think we would have made it out the door
And why was that?
because we'd be arrested, like they said.
Now, down in the third from the bottom line there, it begins with "there is." You see that?
Mm-hmm.
And so, at this point, the best of your knowledge, was there any Department of Family and Children legal obligation or reason to be able to hold you?
No.
Again, object to the reading of the medical record. Your Honor.
That question is allowable, but you might need to re-ask it, given that.
What, if anything, did they tell you about whether DCF could hold you there or not hold you there?
They didn't tell us anything.
Did you, of your independent knowledge, know anything about the law as to DCF holds or procedures?
Not at that time, no.
Looking down there, if you look at the next paragraph, beginning I spoke with, and if you go down about, looks like 6, 7, 8, beginning throughout the ongoing administration. Okay. And so, do you see, did Maya's pain remain the same during this period of time, or was Maya's pain increasing or decreasing?
Again, Judge, he's reading from the medical record. We just like a question to the witness without, and we would ask the medical record to be taken down.
From what you...
Sustained, and let's take the medical record down at this point.
So did you believe at this point that you were being forced to keep your child in the hospital?
Absolutely.
And did you have concerns whether you yourself or your wife could stay at the hospital, would be forced to stay at the hospital?
Forced to stay? I didn't understand. That we would be forced to stay?
Or was it just simply the Maya?
Well, we wouldn't be able to leave without taking Maya. You know, they stated that we'd be arrested.
Okay. And so did it turn out then that you stayed with Maya that night, that Sunday night?
We had no choice.
And the next day, was there a treatment planned to begin to complete Maya's course of the ketamine program treatment?
Yeah, she had a scheduled appointment with Dr. Hannah in Clearwater.
Mm-hmm. All right. And so did there come a time when you met one of the doctors mentioned in here, Dr. Sally Smith, and if you could tell the jury the situation and what you saw in first meeting Dr. Smith?
The only time that I could recall meeting her was, I believe it was October 13th. Mm-hmm. I was in Maya's room. She was getting a clean out for a procedure for upper lower GI.
Where were you physically? Were you standing, sitting?
I was taking care of Maya. She was constantly had feces all over, so I was trying to clean her, trying to take her to the little portable commode. There was a nurse
doing that on her own, or did you?
Absolutely not. No.
Go ahead.
There was a nurse in there, elderly woman. She was assisting me, giving me new washcloths, things like that, sheets for the bed. Then all of a sudden, she walked out, and in walked this woman. It was a woman, black hair, cigarette voice, and she didn't say anything. She's just looking at me while I'm overwhelmed trying to clean up Maya. And she just started asking questions, and the questions really were kind of weird. During that time, it didn't pertain to what I was doing. She's looking around the room.
Were there any introductions from the nurse?
No introductions. And I thought it was kind of rude, because here I'm overwhelmed trying to take care of Maya, and there was no help.
Was she wearing a Johns Hopkins? First, do you recognize what a Johns Hopkins All Children's Hospital?
It's a lab coat.
And do you recognize the little signature that
they had the lab coat on? Yes.
Can you tell the jury whether she was wearing that at the time?
Yes, there was a lab coat.
And what was your impression from the way that she was introduced or not introduced, from wearing that lab coat and starting to ask you questions? What role did you think she was in at that point?
She's a doctor or medical person within the hospital.
And so what happened after that? You were...
So it seemed like it was coordinated, because when the nurse walked out, the doctor walked in. Doctor left about 10 minutes, if that. And then in walked the nurse again. The nurse said, "You have to leave. Your daughter's under custody, protective custody."
All right, so this was on the 13th?
That was the 13th.
So from the time that you came in on the 7th through the 13th, did the state, to the best of your knowledge, or the hospital have any right to hold you there?
Objection calls for a legal conclusion.
Overruled on that one.
No. We have our right to go wherever we want.
And did you reinforce over that stay that you wanted your daughter out of there?
Many times.
And what was the response when you would say, "Look, we're leaving, we're out of here"?
I think there was a stall tactic at one time. They gave Beata some hope, and that never happened. But then, if you leave, you're arrested.
Did they talk about a transfer?
We were talking about Nemours.
How was it presented to you?
Well, I remember Beata for the longest time wanted it as well, and then I guess the hospital was also looking at Nemours, the transfer to the Orlando area.
And what was the reason you wanted, other than just getting out of there, a transfer up to Nemours?
They treat CRPS.
And so then, were you and Beata presented with a transfer form?
Yes.
And what was it explained to you the reason would be why there would be a transfer to Nemours, verbally?
The reason was to go ahead and get her taken there. And the problem was, though, we found out by looking at the insurance codes, it wasn't for CRPS, it was for Munchausen by proxy. So we did not sign that form, because if we sign that form, we're admitting that we're.
So did the hospital ever tell you that, hey, we're going to send you over there, but we're going to start out with, in their mind, that there was child abuse going on?
No.
Do we have that form we can pull up? Judge, may we publish 3035-0024?
Is it in evidence?
It is in evidence.
Yes, it is.
Madam Clerk, is this exhibit in evidence?
Yes. Can we say it, please?
3035-0024, the Nemours transfer form from November 3rd, 2016.
The clerk says it's not in evidence.
Judge, none of the defense exhibits are yet in evidence because we haven't presented our case. Yeah.
It is or is not to? What?
Can we approach?
Sure. What, Judge? Can we approach on this?
Okay, Madam Clerk says that the document actually is in evidence. Certain pages that exhibit. Okay, you may continue, Mr. Anderson.
May we publish, Your Honor?
Absolutely.
3035-024. All right, now, a note, we get it up here. All right. Is this, it's a two-page document, 024025. Do you recognize this, or did you ever actually see this?
It just came up.
Okay, sorry.
I did not. I'm sure, if anything, Beata did.
All right. And on this record, which is in evidence, as we said, does it appear that Munchausen by proxy is the diagnosis there? Muscle atrophy, bilateral lower extremity, right, something?
Yes.
Munchausen by proxy. And who was it assigned by?
Yeah, I object to the predicate on this and the misconstruing the evidence.
Overruled.
Who was it assigned? Who assigned that? You see right there, right after the Munchausen by proxy, assigned by,
And again, I object to him reading the medical record that he hasn't
just
seen.
directing the witness.
I'm sorry, I don't see where it's
Was
at.
Dr. Dees the doctor there that's shown to have assigned that diagnosis?
Same objection, Your Honor.
Overruled.
The highlighted portion?
Yes.
Yeah. And to the best of your knowledge, Dr. Dees was not a psychologist or psychiatrist that there, was she?
I'm not aware of that.
And to the best of your knowledge, she never performed any type of psychological interview, did she?
Object to the leading.
Overruled. No, she wasn't diagnosed with Munchausen.
So this is on November 3rd. This was the form. Can you tell the jury whether the events leading up to this form began during this period of time that you were trying to leave between the 7th and the 13th?
Yes, it was.
And was this, to the best of your knowledge, the reason that they wanted you to continue to stay?
Oh, yeah. Yeah, we're being held there.
And did they also attempt to tell you that your daughter had to be weaned off of medications?
Yes, that was like the first thing
And
they stated.
And did you inform them that at no time had your daughter ever exhibited any type of withdrawal symptoms? First, are you familiar with what withdrawal symptoms are, generally?
At no time we seen withdrawal syndromes for every procedure she went through, including the one in Mexico that was the longest one.
And did you inform them of that there was no danger of that?
We never seen anything.
Okay. And so, did you or Beata talk to the insurance company about the coding on these forms?
I called the insurance company.
All right. And was this in connection with the care and treatment of your daughter?
That's correct.
And what did they tell you?
They gave me the codes and then what it was listed for.
And did that confirm in your mind what they were actually trying to transfer for?
Exactly.
So did you feel misled?
Extremely misled, yes.
Regardless of any of the other reasons, were you trying to get out of there during this period of time?
We wanted to get out, but we are not going to get out under those conditions.
Right. And if you had signed that agreeing to a Munchausen by proxy diagnosis.
You're admitting guilt or blame. So.
And what would happen to Beata's career as a nurse, if, to the best of your knowledge, if she admitted in a document to being the person behind the child abuse of Munchausen by proxy?
Objection, lack of foundation, speculation.
Overruled. You can answer.
She wouldn't have been able to do her job with that allegation against her.
And later, did you learn that had that allegation become stuck in Maya's record, medical records, what the
Yes,
effect would be on her?
It's still in there. And I mean, if something happens to Maya and there's nobody around to say what happened, she may not get the proper treatment because in her record it shows conversion disorder or fictitious disorder. Somebody could take that right away and think, oh, this girl's faking and not get the proper treatment. And that is disgusting that we have to live that way with that in her record.
All right, so how was it in terms of the stress on you and your wife, knowing, as you've just testified, that you needed to get your daughter out for treatment and you were being kept in, that she was being kept in?
It was extremely stressful. Extremely.
And what was the fear there in terms of Maya's condition as she lay there without
Fear
you?
was that she's going to deteriorate, which she did.
And so now I'd like to talk about, from what you saw, the times when you had to let Maya know that you couldn't leave. She could not leave that place.
The worst time I could remember is when I was told I had to leave. That was on the 13th. I looked at Maya, and she looked at me, and that is burned into my head, that picture. Having to leave your daughter that was in need of their parent. I wish it was like an Etch-a-Sketch where I could tip it over and erase that picture, but it's burned in my head forever. And I see that all the time. And I just wonder how she felt on the other side, seeing her dad walk away. And not knowing if she's ever going to see us again.
Did you feel as though you'd betrayed her in some way?
No, I didn't betray her.
Did you feel a concern about her medical, what could happen to her medically without you and Beata there to guide her and to assist her and protect her?
I was worried about that, and I seen it deteriorate when I visited her.
All right, so
Not only did I see her deteriorate, I seen my wife. I go to the hospital, I see my child deteriorating. I go home, I see my wife deteriorating.
and in one event, did Beata in fact lose consciousness, fall to the floor upon finding out she wasn't going to be able
We
to see
had
her
a
child?
dependency
All right,
hearing.
don't tell us about the context. Just tell us, did that happen in an event?
Pardon me? I'm sorry.
Don't worry about the context where you
Okay.
were. Just
Yeah,
tell
she
us.
fell and struck her head on the floor.
And so through this period of time, as you were kept away from your daughter, can you tell the jury, did Beata's condition remain the same from what you saw as a husband, or did it continue to deteriorate?
I was asked by Dr. Duncan, why is Beata so upset? And why can she not calm down? And I thought about that, and I remember, I'll say this real quick, but my nephew and I were fishing, and he accidentally caught a baby alligator. And he was reeling in, and the mother came out of the water and chased us on a picnic table. And I told Dr. Duncan, I said, that's Beata. Her child is on the 7th floor, and she wants her child back. And she realized, at that time.
And so as time went on, did Beata become accustomed to this, or did she continue to have these emotional, I guess, slide down?
It was all downhill.
And so I guess from that story, did Beata have a strong protective instinct, maternal instinct?
The strength was weakening, and she's just losing hope.
Yep. Now, after this point, you find out that the there had been a petition or whatever, and, but you were granted visitation, is that right?
I was.
And can you tell the jury whether this was just you being able to come and see your daughter, or whether you had to have someone with you?
It was arranged to be supervised visitation at first. I did take Kyle. I took Kyle with me the first time. That was on the 14th, I believe. And we drove from Venice to St. Pete to see Maya.
How often were you able to go?
Well, it was the drive there was an hour drive. And then when we got there, I called and I spoke with the nurse, and the nurse said that it has to go through the social worker. So she said she'd call me back. And then I was talking with the social worker, and I was disconnected. I'm not blaming somebody for hanging up or anything.
Did you oh, sorry, continue.
But we were denied that day to see Maya. So instead of getting mad or anything like that, bit my lip and drove home.
Was there a feeling on your part at that time that if you started to raise a lot of noise about it, for lack of a better term, it might get worse?
Objection, and we need to apologize, but we do need to approach on this, Your Honor.
Okay. Approach. Objection overruled.
All right, so I think we're in a...
You're going to have to repeat it.
Go ahead, tell the jury.
I'm sorry, you're going to have to repeat the question.
Oh. Well, that's going to be interesting because I can't remember it. I believe at this time then you were trying to see your daughter, and then...
Yeah, the first time I was denied, so we drove home.
So what happened the next time, or what happened next?
I spoke with Kathy Beatty, and she stated that they will not supervise the visitations. It has to be by a third party.
Now, so was she saying that they were bowing out of this?
Objection calls for speculation.
Sustained.
Denied by whom? Who is Kathy Beatty?
Kathy Beatty's the social worker at the hospital.
Right. From your view, was Kathy Beatty more or less assigned to your daughter?
She followed Maya from the first floor and up to the PICU, yes.
Was Maya kept in just one room when you would visit, or were there multiple rooms?
It was multiple rooms, but, it would be a certain time frame in a room.
And when you came up to those rooms, did you notice whether or not they would put Maya's name on the door?
No, there would be no marking on the door. Most of the children had their name on the door, next to the door, I'm sorry.
Artwork.
And it's a little slate or something like that. Most of them had their names on, but Maya did not.
Ever
And
on any of them?
also, her name was not downstairs at the lobby if you're checking in. Her name was not there.
So if visitors came in to ask for Maya Kowalski, what happens?
She's not listed as a patient.
She became a non-entity? So tell us about after Ms. Beatty tells you they're not supervising anymore. How'd you manage to see or talk to your daughter?
We had to do a list of potential supervise or certain people, and never got anything back on that. But then it started out with a third party doing the supervised visitation on their schedule.
On their schedule?
Yes.
And were there times when you simply could not get in to see Maya?
Depending on the time, yeah, that's correct.
But throughout all of this, you were legally allowed to see Maya, were you not?
I was allowed.
Objection calls for a legal conclusion.
Sustained.
There was no prohibition, as far as you knew, on you seeing your daughter other than the practical.
Same objection, Your Honor.
That one he can answer.
I'm sorry.
There was no restriction on you seeing Maya other than the practical considerations of getting cooperation from the hospital.
Same objection.
Well, you changed the question, so I'm going to sustain that question.
All right. Let's just continue on. I'll come back to that.
Okay.
Tell the jury then about how you had to complete the list to get people in.
There was a list of family members, and then it was going to be, they'd do a background or whatever. I don't know what they were going to do with it, but I had to give them their name, address, social security number, everything. There was the only one that I know of for sure that's questioned was my brother Bobby. He questioned.
The same one that testified first?
Yes.
And was he a former police officer?
He was a former police officer.
Did they know that?
Springs. Yes.
So what happened?
They said they didn't want family members to do the supervise visitations.
Okay. So now, the list then, was it a list for visitors or was it just for supervised visitors?
That one was for just supervise, and then there was no list for, or they didn't state that we had to have a list for visitors. No visitors were allowed at that time.
All right, but that's important now.
Other than the teachers.
All right, I want you to explain to the jury a little bit more about this. So there's a list for the supervised visitors that were going to supervise where you were, but in terms of people that just wanted to come see Maya, like Father, the priest that came in, or Father Jack, or
No, the immediate family, we had the list, and that was intended as well as for the supervised visitation, but there was
Anyone
no list for just visitors.
and yet were other visitors turned away or told once they arrived in the room they had to go away?
Nobody could, if they went there to visit, she's not in the computer as a patient, so there would have been no way for them to go see her.
From what you saw, did Maya feel as though she was being isolated?
Oh, definitely.
So let me show you Exhibit 1081. I got it. Which is the 1081, and then we're going to go to 1082-0003, if we could. So that's 1082-0003. 0003. May we publish, Your Honor? It's in evidence.
It's in evidence, yes.
It took a long time, but one of her friends eventually did get to visit, one of her girlfriends.
And as we're pulling this up, her statement of rights, then your statement of rights, you were allowed visitation generally,
Yes,
and you were allowed to, for instance, practice cultural values and spiritual beliefs as long as they don't interfere with the well-being of others and are within the limits of hospital policy and the law. So was there anything that you, or to your knowledge, any of the visitors did that was disruptive?
Objection, lack of foundation, and misstates the evidence.
Overruled on that one.
anybody interfere with that visited? No.
Yeah, did the hospital, yeah, okay, that's what I'm getting at. From the best of your knowledge, did you or anyone else do anything that was against the hospital's rules?
No, we brought holy water. She had her wafers. She had her cross or the rosary, and a lot of that was not allowed to be in her room.
And so you brought it up, and was it then taken away?
It was taken away.
And did you ever learn the reason why it was taken away?
One thing that I remember is they were worried that the host was going to be poisoned.
That the body and blood was going to be poisoned with what?
With what?
Yeah, what was supposed to be in it? That was...
I have no clue what they were worried about.
Okay. Well, did you ever learn through the course of this that they believed that somehow Beata was slipping ketamine to her daughter through the holy water and wafers?
Object, lack of foundation.
No.
Overruled.
I know it didn't happen, but did you learn?
It didn't happen. No, it did not happen. But yes, they had all different ideas of
theories.
Theories, yes.
All right. And so, were you allowed by this rule to talk with another doctor or specialist to get a second opinion?
Objection, again, in terms of the time frame that this has been discussed.
Generally.
Well, I think Mr. Shapiro is correct. Are you talking about before or after the entry of the order?
This is after the entry of the order. Were they allowed to talk to another doctor?
I think you need to approach on that one.
the objection to the last question.
Reporter, could you read that back, please, the last question? Make sure I get it straight.
Question, all right, so were you allowed by this rule to talk with another doctor or specialist to get a second opinion? Mr. Shapiro, objection in terms of the time frame?
Just the questions only.
Discuss, and Mr. Anderson said generally.
There was a doctor that was under a court order to come evaluate Maya. And that was Dr. Hannah.
What happened there?
Dr. Hannah was refused to see her by Johns Hopkins All Children's Hospital.
Now, in terms of the restrictions as you knew them, did you understand that you retained your rights to participate in, be involved in, and advise and consent in the medical treatment of your daughter?
We had rights. We still had rights at that time, yes.
And so through all of this, did the hospital, any of them, actually involve you in any of their decisions on
No.
treatment?
No.
So were you under the patient rights thing? Here we have the 1082003. It states the third from the bottom of the first row to be told by your healthcare provider. Do you see that?
To be told of medical choices for
Yes.
care of treatment.
Okay. And so were you ever allowed that right?
No.
And were you ever allowed during the period of time that you were there with Maya to consult with any doctor outside of the hospital doctors?
I'm sorry, repeat that.
Were you allowed ever to suggest or bring in were you allowed to suggest other doctors outside of Johns Hopkins to come in and get opinions?
Predicate and foundation.
Sustained.
What, if any, knowledge did you have about the terms and conditions of why Maya was in there? Did you understand that it included anything that restricted you from participating in the health care of your...
No.
And through the course of this, did you have the opportunity, or did you request the opportunity to bring in outside non-Johns Hopkins physicians to look at Maya and provide second opinions?
Yes,
Objection, foundation, predicate, and compound.
Sustained.
What, if any, doctors outside of Johns Hopkins got to see Maya?
Dr. Hannah was refused, and then Dr. Duncan, she was able to evaluate Maya when she went to the courthouse in Sarasota.
And she testified here earlier?
Yes.
And then Dr. Chopra, was he allowed?
Dr. Chopra was after, that was in January. I went and seen, that was a court order as well. I had 48 hours to take Maya. I had to hire a nurse to go with, and I had to have a brother. And then I had a 48-hour time period. Otherwise, I'm in trouble if I'm not back in time.
And so tell us how you were treated on the times you could come in and visit by the staff, particularly Ms. Beatty.
Well, there's a time I walked in, the children were going to be visit with their lawyer. We had 4 lawyers, I believe. The children had a lawyer, Beata had a lawyer, I had a lawyer, and we had something else.
Was that by choice or by necessity?
So I brought the kids in to see their lawyer at the hospital. I walked in, and a woman behind the desk, she asked me, what am I doing there? And I said, I'm Jack Kowalski. I told her who I was and that the kids are going to visit with their lawyer. And she started screaming at me that I don't belong there, and she's gonna call the police and whoever else because I don't belong there. And I said, I'm just here to drop the children off, or Kyle off. It's not like I'm gonna pull up and tell Kyle to go inside the building and go see his lawyer. I had no intention of going upstairs with him, but to just get him to his lawyer. But she screamed at me, and I just walked out. Once again, I'm not gonna cause any interference because I do not wanna lose my privileges to see my child. That's the only basically the only one that could go see her at that time. Eventually, I found out who it was. The woman's name was Judy. After other visits, I seen her name tag. But there was another time during this whole time. There was supervised visitation. Then it was unsupervised for a while. Then they said Maya's condition's getting worse, and it's Dad's fault for visiting or interfering with her PT and things like that. So the court order changed so much, and all this information was from one side, the hospital. We had no say so that we weren't interfering. So yeah, there were so many interruptions. And then one time I got a new court order, I bring it in, and Elaine Brown, she's a social worker. I called and told her I was here because then now I have to check in with the supervisor again from the hospital. Mm-hmm. She came down finally, and she said I couldn't visit yet because she's unaware of the order, which I had in hand, and I provided her with it, the new order. She said that I could not go up there until it's reviewed by Kathy Beatty. I did have dresses for Maya for the holiday, so I asked her if she could give them to Maya. Later on, I found out those dresses never made it to her. They were in Kathy Beatty's office.
And you saw them there.
Yeah. So,
but hang on. You were giving things to the hospital staff to pass along to your daughter? Is that right?
Yes. Anytime we brought anything in, it had to go through them. They had to look through the bags. They had to check everything. Envelopes to whatever.
What about bringing in a snack for your daughter, like a brownie or?
I had to get permission of different food items. They had to be in a closed container. You couldn't bring in carrots or something Mom made. That was not allowed.
So she had to eat hospital food?
Hospital food, and then some snacks that are in a closed container, in the original package.
From what you saw, was your daughter gaining weight or losing weight in the hospital?
She was losing weight. She was deteriorating, and at the end, she was puffy, like she had a lot of fluids.
Mm-hmm. And so, were there any other times then that you had either gifts or something for Maya that was interfered with that you can think of?
Yes. Well, there was an issue with her computer, the school computer. She wasn't allowed to keep it in her room, according from Kathy Beatty. Kathy Beatty stated that she may be going online to see some sex sites.
The hearsay.
Part of admission.
And also the motion.
Were these statements made to you?
She wrote the little note.
Well, to the extent that they need to be statements to him, so I think that question is sustained.
From your overall communication with Ms. Beatty, did it become clear to you that, let me see. All right. Let's move back then and get this right. I need to know more about the details of this dress incident. What was the purpose there? Was it just a gift of a dress?
No, there was a holiday coming up. I believe Christmas is when that happened.
And was the dress a Christmas dress?
It was a dress for the holiday, yes.
And were these things important to Maya?
It was important to Maya, it was important to Beata to have her celebrate.
Did you ever come in and expect to see your daughter in the dress and learn that she never received a dress?
Well, that was the way I found out. I asked Maya if she, how she liked the dress, and she looked at me like, "What dress?" So.
And then what did you do?
Then I contacted Elaine Brown, and she goes, "Oh, it's in Kathy Beaty's office. Found it in Kathy Beaty's office."
Did you confirm that?
The dress ended up getting to her eventually.
But you had to go around Miss Beatty.
Yes.
Did it appear that Miss Beatty was operating under some kind of plan in terms of the way you and your family were being treated?
Objection leading in speculation.
Sustained.
What, if any, plan did it appear that Miss Beatty was adhering to?
Same objection.
The plan, motive,
I'm
intent.
going to overrule the leading, but the other basis I'm going to sustain.
Which basis, Your Honor?
Speculation.
Yeah, thank you. And foundation as well.
Foundation.
Okay. So, was Miss Beatty's actions towards you, did they appear to be consistent with some idea?
She was in control. I remember an incident that happened to me, and I'm not talking for Maya or anybody else.
Objection to non-responsiveness.
Overruled. He can take the answer.
One day, she walked up to me and she asked me, "Did you ever consider divorcing your wife?" And it's like, "What are you talking about?" And she goes, "Oh, forget it," and walked away. And it's just like, why would you even come up and say something like that?
Now, the jury may hear testimony from your daughter about Miss Beatty's physical contact with her. During these conversations, was Maya ever allowed to tell you about those?
By a note.
And so, what was the effect on you and your wife about knowing what Miss Beatty was doing?
It was just putting a bigger wedge in between everyone, and more anger.
Well, was Beata becoming more desperate at this point?
Yes.
And what was her concern?
Number one, Maya's health.
And were you reporting back to your wife about her health every time you visited?
Yes, and yeah, it was difficult.
Well, when you came home then, was she nonchalant about what Beata was like, or was she desperate for information for what she was like?
She would want to know. Then she would want to know how she's being treated, but I wasn't getting the answers. There's many times I seen Maya in a position or in a situation where her lesions are hurting, the dystonia, and I brought that up, and there was no answers. There was one time they said they bring an ice pack for her lesions. The ice packs are lesions and pain. The ice packs are not going to help.
And we're going to refer to some covert video on this point in a moment, but going back to the dress, who picked out the dress for Maya?
Mom.
So what was the effect when she heard that Maya couldn't even get the dress?
I crushed her.
Did it appear to you that Miss Beatty was potentially a danger or a possible means of inflicting harm on your daughter?
Objection, speculation, predicate.
Overruled. He can answer that.
I was worried from what I seen in the notes
What was your worry?
Well, I don't know if I could bring a certain thing up, so.
Okay, well, let's approach sidebar and see if we can. So now, was the incident involving Kyle, was that the October 27th incident for bringing Kyle in yourself?
No.
Was there another incident where voices were raised about you bringing your 7-year-old son in? For bringing the children to their lawyers?
I just remember the one where
All right.
having them meet with their lawyer, Mike Kelly.
All right. And so now, did there come a time when you were going to take Maya to the Fall Festival?
Yes.
What happened there? And what was the Fall Festival first? So you have
Fall
some idea?
Festival, they have an outside playground on the hospital rooftop. And they also have a rec center. The rec personnel, young girls came in and they introduced themselves, and they stated that they have a fall festival going on and they want Maya to attend. So they got the kids all excited about the fall festival, and then we were going to go to that location, and then we were told we're not allowed to leave the room. And they stated that your visitation is bedside only. And I said, well, first of all, I asked the nurse, we are not to discuss this in front of the kids. So I went out in the hallway for respect, so they don't hear what's going on. And I had the order, I showed it to her, and she said no. Right here it took a while, I had to go through different people, but finally I was able to see it on their screen. She showed me, and it was an order from Kathy Beatty that I am not allowed to take her anywhere but be in bedside with her, visitation. So I contacted my attorney at the time, Deborah Salisbury, and it took some time, and then eventually we were able to go to the Fall Festival.
And were you ever, did there come a time you learned that some covert video surveillance was being performed on your daughter?
I had no clue that was going on until many
This
years
case?
after.
And what specifically did you understand Maya was forced to do?
Objection, foundation, and predicate based on last response.
Well, I'm going to sustain that, but you can ask some foundation questions on this issue.
How did you learn about the covert video surveillance?
During the legal issues.
And were you questioned about it throughout this proceeding?
Yes.
And prior to that time, were you prior to that time, by terms of the orders and the patient's statement of rights, were you supposed to be informed of any medical procedures that your daughter was to be involved in?
Objection, compound, and foundation.
Overruled. You can answer that.
Yes.
So during this period of time, were you kept up to date about what was going on with the different attempts to, quote, treat your daughter?
No.
And so, did you subsequently learn then that there was video surveillance undertaken of Maya?
When I found out about that, I was very upset. We did not give consent to that.
Did you learn that from October 18th to October 20th, she had been put in a surveillance room?
That's what I was at quite a while after I learned of that.
I understand. Now, Maya had been videotaped at Tampa General Hospital briefly, had she not?
Yes.
Did you give consent at that time?
Yes, there was an incident where Maya fell out of the bed at Tampa General, and they notified us, and then they also wanted to do video surveillance, to make sure that it wouldn't happen again, or they could monitor her, and we gave consent to that.
Well, it would also have told them that if she got up out of the presence of anybody and walked around rather than standing in her wheelchair, right?
Objection deleting her.
Sustained.
What, if any, other benefit would it have been?
To see her condition and,
To see if she
that
could.
she's safe as well.
Yeah. And also, was it also, to the best of your knowledge, to see if when she was out of sight of anyone, she would actually get up and do more than she seemed to be able to do at that time?
I'm not aware of that.
Okay. So now tell us then, before October 18th, were you ever informed by the hospital that they intended to put your daughter in a room alone?
Absolutely not.
Were you informed that they planned to test her as to whether she could actually get up and walk around by placing the commode just out of reach?
Objection, predicate and foundation.
Overruled.
It was the commode and also the phone. They would ring the phone, see if she would answer the phone.
Were
Which
both
was
of
out
those,
reach.
and both of those were out of reach?
Yes.
Had you been asked about this, would you have given consent or told no?
Absolutely not.
And so I'd like to publish for the jury portions of 2703. That's 2703 A, B, C, and D.
They're in evidence.
And those are in evidence, I believe, right?
Yes.
Yes, Your Honor.
You may.
Now, in this video, go ahead. You can continue. Okay, let's freeze that for a moment. So during the time that you took care of your daughter, periods, was part of that treating the lesions?
Yes.
And did that include putting certain types of medicated lotion or salve on them?
Yeah, there was an ointment. It was a ketamine ointment that was used, prescribed by, I believe, Dr. Hannah, and that was through King's Pharmacy.
And so here, can you tell the jury what Maya's doing with that jar?
For what I heard, she was explaining to the nurse what they are, and it from the RSD, she stated, I believe, in there. So she's telling her that's what it is. Later on, the hospital was stating that she was self-inflicting herself with wounds.
And here, based on your knowledge, your daughter is actually applying a salve to the lesions?
Correct.
And do you see where the lesions were?
On her legs.
And is that typically where you saw the lesions?
She has lesions again on her legs.
Right now it does. Okay. And how is she doing right now? Just out of.
She's not. She's weak.
She still has good days and bad days.
Yeah, there's bad days right now.
All right. Now I want to show you another one, 2703. Oh, wait. While we're on this, you see the location of the commode?
Yes, I do.
Was Maya physically able to make it over there to go to the bathroom?
No, if you've seen the nurse, she assisted lifting her legs and that. She's weak.
All right. Did it come to your attention that there were times when they wouldn't come fast enough for Maya to make it over to the commode?
She wet herself several times. And I don't know if you could see on the right side there, her feet, the dystonia, they're severely turned in. The right one.
Right there?
Yeah.
Okay. Now, let's talk a little bit about the blankets over her. With the aldynia, what, if anything, is significant about the blankets versus people trying to reach out and grab her?
Well, the blankets can affect it. Just like I said, droplets of water in the shower. But a person, sometimes when it's severe, even with the person going near her, she'll retract. I don't know if you're going to show it, but there was a video of Kyle. He actually touched her legs and they spasmed. But it's all dependent on the day as well.
All right. And so,
as you see, she's in shorts. It's probably the most comfortable thing for her to have on instead of long pants where it would potentially irritate.
And I note at the end there she kept the blanket off?
Yes.
All right, let's look at 2703B. If we can. Does that keep going?
That includes it.
That's it. That's it.
Okay. All right, and so that position of the commode, again, could Maya reach that?
No, did you see her legs? She's so weak. They're so weak, there's no way that she would have been able to.
And let the record reflect that this was performed, this happened October 18th through October 20th. Now, does it appear to you, or did it appear to you, that this room was darkened?
Yes.
Do you know why what they told your daughter in terms of the reasons she needed to go into that room, as opposed to telling her that she was going to be videotaped?
They told Maya that they changed rooms after a certain time frame.
Do you recall them expressing that they were doing an EEG on her?
No.
Do you recall Maya talking about the fact that they told her that what the room was for was to put EEG, try a new type of EEG on her?
No.
So why was she in this room?
Why wasn't she in there if they were worried about her self-inflicting her, wounds? That would make more sense to have somebody under surveillance. But when that took place, she was not under surveillance when they accused her of scratching her face and that.
I see. So did they ever put her under surveillance when they started to accuse her of self-inflicted lesions?
No.
Now, from your perspective, having been through there many times, did this hospital have surveillance cameras throughout?
They're everywhere.
Hallways?
Everywhere.
Outside of the chapel area?
Yes.
Lobby?
Yes.
As you walk down the hallways, surveillance?
There's no way to go anywhere without a camera.
And in this case, have you actually seen a clip, an excerpt still from one of the surveillance cameras at this time?
Objection.
members of the jury, given the time, it probably is the best time to just take a break. So, do not discuss this case amongst yourselves. Do not do any investigation and receive no information. This is probably going to be a 15-minute break. So, we'll see you on the flip side.
All right, for the next thing.
Okay, please be seated. Mr. Kowalski, you're free to go on break. If you want to go sit at your council table, that's fine. If you want to sit there, that's fine.
Thank you, sir.
Now, Mr. Anderson, I don't recall if we're talking about the issue of spoliation. Obviously, it's not play, but there's certainly other ways to deal with spoliation. But there's almost always, I'm presented with a, look at this discovery request. They didn't produce. Let's do something about it. I don't recall there being a discovery hearing relative to this outside video surveillance. But if I'm wrong, just can you point me to the hearing or the order that I entered, if any?
There's two issues. One is the surveillance in the hallways, and the other is the surveillance the court is witnessing in this 2703. We made a request for production for any and all video, among other things, depictions of Maya Kowalski. That was not produced. They said, no, nothing. There was nothing for us to really bring to the court's attention. Further, later on in the litigation, actually fairly recently when we were going, to my knowledge, when we were going through the potential exhibits for here, and maybe a little before, but frankly I can't remember exactly when, but it was fairly recently, we saw this photo which was represented to us to be a still out of the surveillance cameras that they intended to use for some reason in their defense.
Can I see that so I have a context of what we're talking about?
Yes. Do we?
It's going to take 1 minute.
That'll take a minute.
You can keep arguing, but let's.
Sure. So DCF made a request for this specific video. And it was.
With this specific video, meaning the EEG room?
Yes.
No.
Go ahead.
First week of her admission,
Sorry.
DCF
That's
sent a
another one.
request for surveillance video of Maya Kowalski, which would include the hallway video, the video of her rooms, the video of her in the PICU. It was never produced.
To DCF.
Correct.
So there was a DCF request to Johns Hopkins in the lawsuit or during Maya's stay at Johns Hopkins?
Not in this litigation, in the underlying litigation. The dependency proceeding.
In the shelter action, DCF requested, and I got confused because there are two. DCF requested the surveillance because the entire hospital is surveyed. And so in that proceeding, they made a representation on the record that they had no such surveillance. And I believe in deposition, I also asked, do you have this surveillance? And the answer was, this is only kept for, and I'll have to dig it out, find the deposition. This is only kept so long we don't have this anymore. And so then from that followed up an entire series of questions about, well, why wasn't it preserved? But we had nothing really at that point to argue with. They had it. They should have kept it. They didn't. It's not there. It's not something that they can keep producing or that we should keep asking about. Subsequently, we got this photograph, which is a still out of one of those cameras, or so it was represented to us. That's when we came to the conclusion, well, they must have kept some of it, so where's the rest of it? And we didn't bring the matter up to the court at that point because, frankly, I think discovery was either closing or close to close. And for their representations in the court, they said there's none. So our point of view is we should be able to lay the foundations here for the fact that there was a photograph extracted from that.
In this lawsuit, 2018 CA 5321, did the plaintiffs make a discovery request for any type of video surveillance out in the hallways or outside or anything having to do outside of the EEG room?
I believe so. I think perhaps the solution is to not pursue this at the moment and allow us to provide the court with the request and the DCF request and the still frame.
And hopefully my series of questions about it.
I don't think I could address a discovery request made in the dependency court that wasn't properly addressed or responded to in the dependency court. I could only deal with a request that was made in this case, 18 CA 5321. So I am still trying to figure out what we're talking about. Can you at least show me this still,
Sure.
what we're talking about?
Do we have that?
Still looking.
And if defense counsel has it.
Hero, do you know what?
Judge, let me just say this.
3127.
I've asked of our folks, I don't remember any request to us regarding hallway or general area surveillance. We're checking to see what the situation is with respect to that. I can tell the court that during the dependency action, there was an informal request made by Deborah Salisbury for the surveillance video that is being shown here that plaintiff produced to us in pre-suit because they had it. It was provided to Ms. Salisbury. We have the FedEx receipt to show that. And the question may become, gee, if she knew to ask, how come you didn't know what was happening? Obviously, she knew to ask. But whatever the case, this surveillance that we're seeing clips of here was provided informally upon request. Now, as far as the hallway surveillance is concerned, those are running tapes that get taped over, to my knowledge. I don't know what the time frame is off the top of my head, but I'm not aware of any request for any of those things in this action, or for that matter, in the dependency action. This is nothing but gotcha.
Well, I would like to see the still photo, but the reality is there has to be a discovery request in this case that then there was some sort of follow-up on.
I can address at least the discovery request, Your Honor. It's our fourth request for production. Number 3, we asked.
Can you give me a den?
No.
What's the date of it?
I will. One moment.
What's the date?
All I have in front of me, Your Honor, is a text message from Miss Perry, who's still sick. It's our fourth request for production, request number 3. Please produce all video recordings of Maya Kowalski and her family during the relevant time period. I'll get a den and a date of that request in response.
Just very briefly, Your Honor, because I know the court wants to take a break. It's not a request for hallway surveillance, but getting to the point that this court's making, for them to pursue spoliation, they have to have a request. There has to be a showing that there was a duty, that the information no longer is available. There has to be a duty to preserve, that the court finds that the failure to preserve it violated a legal duty. They haven't even met the second step, let alone third, fourth, and fifth.
It's because we haven't had an opportunity to make our foundation and predicate for it. And I don't agree.
So we started this line of questioning spontaneously off the top of our heads?
No, this has been asked repeatedly. And this, I believe, was asked.
Well, time out. I'm going to go take a break. The reality is there's got to be a request in this particular case. And before we can do anything else.
Yes, sir.
And unless and until that has happened, then none of this is something we need to be spending any time on.
I understand.
Okay, why don't we just take 10 minutes?
All rise. Let's go as a
there anything further on the alleged spoliation issue, or are we moving on?
I believe we have found what the court was looking for. There are two things we'd like to do. First, put up Exhibit 3132, dated October. It's a, well, you'll see, clip dated October 25th, 2016, which the record reflects is while Maya was in the hospital. And I believe that the witness can identify the two people in that video, in that takeout. And then we have also the request for production. We have that.
What's the exhibit number?
Republishing 3132.
3132,
Defense exhibit.
defense.
Okay, so what is this?
This is a still frame from Johns Hopkins surveillance video, and this is Linda Brown and Joyce Sacco. You might remember the witness with the hat. She's wearing a hat here as well. And they're carrying in the statue of Mary.
Let's do that survey.
And I see handwritten something about October 25th, 2016.
Yes, Your Honor. That's described on defense exhibit list as photo of Linda Brown and Joyce Sacco from security camera at JHatch 102516.
Now, what's your discovery request?
The first we'd like to show you is at DIN 56. It's our interrogatories. I can show you, and this is the responses which were not filed, but the requests were filed. And number 7 here, we asked for anyone at the hospital who had knowledge or possession of any videotape pertaining to the issues in this case, and we were told there were none other than medical records and related imaging studies.
Was there a request for like security cameras or anything that would be more specific than this very generic
We
request?
also have DIN 433, which is the request for production mentioned earlier. We can put that up.
What
And
request number?
Number 3 here. Please produce all video recordings of Maya Kowalski and her family during the relevant time period.
That's DIN 433, Your Honor.
Right, that looks like the hospital's response, which would include the request.
Yes, sir.
Was there a request for security camera?
In the interrogatory, we asked for anyone with knowledge of any video recording. We were told there were no such thing. We did not discover that to be untrue until we were given Exhibit 3132, which we just put up for Your Honor.
And there would be no reason to bring up to the court any type of search the way we did for the cell phones, because they say they simply don't have those. It's not like there were cell phones and we had to get information off. We had nothing to get information off of.
Judge, I'd like to get that exhibit back up, because if the court noticed, that has a plaintiff bait stamp on it. I don't know where that came from. I am skeptical that it's off our surveillance camera, notwithstanding what was put in the exhibits or not. But what I do know is this: when this thing came in to begin with, there was no request for any surveillance information from the hallways or security cameras. We answered it with reference to videos and images of the Kowalski family, just like it said. And we told them that the only ones that we were aware of, besides imaging studies, were the ones that we had produced to Ms. Salisbury, that they produced to us because they're the ones that had them, and we had recorded over in the ordinary course of business those surveillance tapes. So if you notice this one in the bottom right-hand corner, it's got a plaintiff bait stamp on it. Now, I don't know where this came from off the top of my head. I do know I'm dodging gotcha all over the place, but I don't know either where it came from or who put the lettering at the bottom.
Well, let me just say this. The two requests that you showed me are not specific enough to specifically ask for security footage that might exist relative to what's in the hallways or outside or any place.
Your Honor, if we ask a question as to whether it exists and we're told none, how are we supposed to make a follow-up request? We take them at their word at that point, and we're shown later that's false.
Well, your client just testified that there's security cameras all over the place. So obviously, your client knew that there existed security cameras. So it would seem to me like if you wanted security cameras, that you would ask for security camera footage. I mean, that's what I see in slip and fall cases.
But if they tell us none exists,
Well,
why would we?
I don't see that in either of those two responses.
In the interrogatory response, we ask for anyone that has any control of any video, and they say there is none other than the medical record and the imaging studies.
Did you? And I would say that you need to ask for security. You need to kind of actually give them an idea as to what you're asking for, not just an extremely open-ended, every single possible video in the world. You needed to say, hey, security cameras, give us the security cameras.
I would point out, Judge, that they never raised an objection to this as being overbroad or vague. They simply answered it in a way that makes clear that there are none of any of those kind. And so they had every opportunity, if they felt as though we were being vague about it, to raise that and to come in now and for them to say, oh, but it's not quite enough. It says, please produce all video recordings of Maya Kowalski. That would include video surveillance, and that was the intention behind it, and everybody knew this. And so we were trying to obtain this type of information, but you don't know, especially back then before we had done our inspection at the hospital, we didn't know the extent to which every freaking place in there has a video camera. They say they didn't have it, and they had every right to tell us that we don't understand what you're looking for. They didn't do that. They said they just don't have any in their possession, custody, and control. And right now, the only question before the court, I think, is can we have the witness identify that photo as Ms. Sacco and Ms. Brown?
Judge,
Mr. Hunter. Unless the plaintiffs can show me a more specific request, that's not what you've shown me is not enough for me to walk down a spoliation path on security footage.
We'd like to show you one more thing, Your Honor.
Well, then show it to me.
2277-143.
Is that a defensive? Oh, that's 2217.
No, 2277-143. This is from the hospital's risk management file.
Okay, that's talking about in the room. It says it twice. Doesn't talk about the hallway cameras. And that's not a discovery request.
Well,
So,
it's not in this proceeding, but I think the point...
I'm done with the spoliation issue. Those two items were not enough to drill down on a spoliation issue with respect to security footage, even if that is from the defendants. So let's move on.
I'm not trying
done.
to...
Mr. Anderson, I'm done with that issue. Let's go to the next issue.
I don't know of any other issue.
Okay, then we can bring in the jury.
Yes, Your Honor.
We will have to take up the matter of the liens in terms of a stipulation.
Everyone, please be seated. At least I didn't say 5 minutes this time. Members of the jury, I want to confirm that while you were away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Is that all correct? Correct. And while you were away there for a few minutes, no one approached you about this case. Is that correct? Correct. And you did not observe any sort of media reports about this case. Is that correct? Correct. Okay, Mr. Anderson, you may continue. Oh, Mr. Kowalski, if you could come back down. And you understand, sir, you're still under oath?
Yes, sir.
Thank you. Mr. Anderson, you may continue.
Did there come a time that you began taking photographs of Maya and her different symptoms on your own?
Yes, within the hospital, yes.
All right. And why did you do that?
There was many times that we reported something and they denied or did not take care of, a lesion or her dystonia, things like that. So I started taking pictures. And then after reading some of the medical records don't even indicate that she has a lesion or so. And we have a picture on the same date where she has lesions.
Can we put up these photos, some of the photos, run through them?
Do you have an exhibit number there?
It doesn't have, I'm hoping you guys have the Kowalski photos.
Do you have an exhibit number?
That's what we're looking for right now. It's not on my outline. While we're finding those, what we're going to do is play the remaining two of these videos, if we could. One is 2703C. We can do that. Now, Maya pulling her knees up to her chest like that, what did that usually indicate to you?
Did you see her, she pulled her knees up, but did you see her use her hands to pull her legs up?
Yes.
And then also, I don't know if you noticed, she has a thing on her forehead. That's for the sensitivity of light. She has a little eye mask or something to cover her eyes if the light's bothering her. But when she got into the bed, I don't know if you've seen it or not, but she actually physically used her hand to lift up her legs.
Now, from your knowledge of CRPS, is light sensitivity one of the symptoms? Or
That is one.
Objection, predicate.
Sorry.
No, you can finish your answer, sir.
Yes, it is.
All right, let's play 2703D.
I don't like go through like $1, right?
Yeah,
or like really cheap.
$1.
Yeah.
Like normally $1 is cheap, but the more shopping the $1 is cheaper.
Oh, really?
Then she has your medicine, which should be helping a little bit. I want to try to use the walker, but the stand, pivot, get in the chair, like you did with Beth the other day. So I'm jealous that she got to see it and I did not. So I'm going to help you, but I want you to try to get your feet flat on the ground. I'll hold you up until your feet flat. Put your feet down.
You got it. Good job.
Good. Hurry. Turn the walker.
You got it.
Better than yesterday. Hey, give me a high five. That was awesome. Better than yesterday.
You got it.
I wish we had the feet video. That was awesome. Great job.
So I kind of just a little bit because you haven't put any weight on the leg in a long, long time.
Were you able to hear her moaning and crying?
Yes.
Is that similar to what you heard previously when your daughter was in significant pain?
Yes, and sometimes it could be worse, but as you could see, she was trying to use her arms as much as possible. That's not a child faking.
And does this demonstrate, based on your knowledge of your daughter and the times you were seeing her at this time, the type of shape she was in?
She was getting worse.
As she entered the hospital, was she almost to the point of getting up on a walker and maybe with just a tiny bit of assistance getting around before the relapse?
Yeah, before the relapse, she was outstanding. Upper body strength was extremely well. And like I stated earlier, there was a picture where she's actually using her arms to support her whole body off the ground. She looked like a little gymnast. But no, now we just see her going downhill again.
Did Maya report to you during this period of time that this physical therapy, as opposed to warm water therapy, was actually hurting her?
There was no warm water therapy here at the hospital.
So was this therapy painful for her?
Yes.
And she expressed
And it's usually not, that don't appear to be the proper therapy for CRPS.
What's wrong with it?
It's too quick. You got to do things at a certain pace. I don't know if Rachel explained that from agility. You have to, first of all, build up certain things. And I believe the young lady from Tampa General, she also stated that. You gotta do it in steps.
All right. Okay, so let's then jump to the photographs that you took that we alluded to just a moment ago. And I believe you've, yeah. After October 20th, Nick has reminded me, after October 20th, when you witnessed or when you visited, did anyone tell you at the hospital about the video, that is, the one that had just completed, about Maya's difficulties in the surveillance room?
Not at the hospital, no.
And had you had that complete video, would you have used it to demonstrate that your daughter actually was doing a lot worse than being represented?
This would have helped paint the picture to the judge.
Sustained.
I'm sorry.
Was that video of value to you in defending your family?
Objection calls for speculation.
Sustained.
What, if any, use would you have made of the information had they told you about this video?
Same objection.
It's not speculation.
Okay, you can answer that question.
We would have took this video to prove Maya's condition. They were, unfortunately, it was a one-sided story. And we had no, if we had this would have painted a better picture to the judge at that time. And we probably wouldn't be here today.
So let's go through the lesion photos if we can. 2571-001. And after each one, I'll ask you to just kind of tell the jury what they're already seeing.
Your Honor, I apologize.
Jury, I'm going to ask you to step out for a few minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Presence. Now, Mr. Anderson, I know we've discussed this before we even got to trial. The information was the plaintiff's attorney had this video. Was it November 6th or November 7th?
No, later. The date's important.
Okay, well, tell me the order I entered on this. Give me the DIN number on that, because I distinctly recall it was like in early November.
It was mid-November, Your Honor, you're correct.
Mid-November.
Yes. And just prior to that, there was a dependency review hearing on November 8th and November 10th. And Mr. Kowalski did not have this video or the benefit of it during the dependency review hearing. That's his testimony, that would have benefited.
It's not exactly what he said.
No, it
And
isn't
it's
what
also contrary to both the order and the implication, because the specific order from the court was the plaintiff can't contend.
Can someone give me a DIN number,
Sorry,
please?
yes, Your Honor, the DIN number is 3032.
3032.
For which now? For the actual hospital video?
This is the order limiting false imprisonment until after that date of November 16th or something.
I guess November 17th, not November 7th. I agree with the defense on this, Mr. Anderson. As of November 17th, there can be no concealment issue with respect to this video because the plaintiff's or Mr. Kowalski's attorney had it.
Judge, at that time, we did not have all of the information from Deborah Salisbury, and
Are
here's...
we all working on a curative instruction at this point?
Yeah.
Because one's coming.
I would ask that you, and we can bring Deborah Salisbury in, this is all planned, and I did not understand the limitations on this video being provided to Deborah Salisbury. Here is her testimony. We can bring her over here right now to do it. Her testimony
You
is...
didn't understand. The court grants the motion to the extent plaintiffs seek to contend there was any fraudulent concealment on or after November 17, 2016 relating to the secret video surveillance. What did you not understand about that?
I would like relief from it.
Okay, well, that's not what you just told me. You told me you didn't understand it.
Well,
So
maybe I got the...
You're asking reconsideration, or are you telling me you didn't understand the court order?
What I did, I may
Can you
not
answer
have
my
straight.
question? Please answer my question.
I think I got confused on the court order as to the dates. That's the only thing and frankly, that was not the purpose of my question. I just asked whether it would be useful for him.
So the next decretal paragraph, the court denies the motion to the extent plaintiffs seek to contend there was fraudulent concealment prior to November 17th.
Judge, that's for the count on fraudulent concealment, is it not?
So are you saying this is medical malpractice?
Yes, and I'm also saying that it's part of our intentional infliction of emotional distress.
Well, to the extent that you are saying that there's an issue in the dependency court, you got a Chapter 39 immunity problem. So you can't do that.
But I think what I can do is show the basis of what was happening there in terms of whether Ms. Salisbury actually had enough of the video. And what the evidence will show is that it was brought over to, or she was brought over to defense counsel's office not at DCF, but at Hillward and Henderson, and was shown snippets of it on the basis and telling her that this video, all this video shows is that she's in bed and we're going to use it to show that she's moving around. Miss Salisbury asked for it. She didn't get it. She finally got it. Then by the time when she got it, she couldn't open it. We've had that problem before because she didn't have the codes to open it. So during the pertinent period of time, she did not actually have the video. What she had seen were about 3 different 2 to 3 minute spots. And what they were telling her was, we're going to use this to prove that Maya Kowalski can move around easily. And so the problem is she did not have, and we did not have until this litigation, the complete video to be able to look at it and pull out the things that the court just saw. And so we intend, if the court will allow it, we intend to show through Ms. Salisbury that contrary to their representations, and insofar as this being part of the Chapter 39, Hillward and Henderson was not supposed to be a prosecutor or a defense attorney in this. They were simply supposed to be a participant. So why they had this taped and we're going to show it and make representations about this is another issue. But to the extent the court believed that Ms. Salisbury had the complete use of it, and therefore that is impugned on the plaintiff and then impugned onto our representations, that is a false statement. What Deborah Salisbury had were isolated clips under a representation. As a good counsel, she asked for it to receive it. When she first received it, it wasn't from DCF. It was from Hillward and Henderson. And so at that point, she attempted to open this thing. This is going to be her testimony. I'll bring her over right now if we need to. She attempted to open it, could not open it, had to obtain a code, a special means of showing this. Apparently it's coded some way that's difficult. And I'm not sure the timing after that, but I do know it was late in the proceedings, very late in the proceedings.
Well, one, you told me the issue that Ms. Salisbury had about 6 months ago, and I think you also talked to me about it 2 years ago. And you did not bring any testimony from Ms. Salisbury at any time. I don't recall after I entered this order on May 8th, 2023 at DIN 3032 that you filed any motion for relief from that. The time for discovery is over. Trial is not supposed to be by ambush in the state of Florida. Everyone's supposed to know, both sides are supposed to know what each side has. And I am sorry that you seem to misunderstand the court's order talking about this issue.
Only as the timing, really.
Yeah. Before and after November 17th, I don't know how more clear I can be, but be that as it may, I'll grant you that you might be confused as to the meaning of November 17th. I need you to try the case and not continue to be on discovery. We were ahead. The last couple of days have been very bumpy and we're starting to slip. We've got a jury that continues to go out to deal with issues that should have been addressed before we even selected a jury. But we're at where we're at. Discovery's over. Trial. We're going to live with the orders that were previously entered. If you don't understand an order, please let me know. Hopefully timely.
In our defense, I believe that was an order in limine.
It was an order granting and denying
Regarding summary judgment on count 20.
I believe there was a follow-up motion in limine, and what I understood from the court was that since we had, I don't know how many motions in limine in this case, going into the dozens, that if there was an issue which arose at trial, that the court would reconsider.
Outside the presence of the jury.
I didn't know he was going to say that, Judge. I just asked him if it was of value to him.
Yeah. Well, and the reality is, well, let's just go with what do you have? recommendation for the proposed
And
curative.
I'll make the record and then Mr. Aldenburn will make it. But here's the reason why this is extremely problematic. The video, as Your Honor noted in his orders, was turned over to Ms. Salisbury on November 17, 2016. After the Kowalskis received the video, there was a shelter hearing on December 5th, 2016, and there was a shelter hearing on December 13th, 2016, both of which at a minimum would have been opportunities for the Kowalskis to present whatever evidence was in that video to the DCF court. So there's been a false implication in front of the jury that video, if provided timely, would have changed everything and Maya would have been home. It's also relitigating the DCF action, which this court has instructed both parties on numerous occasions not to do. My colleague, Mr. Aldenburn, is working on an instruction, but we're very, very concerned about the last statement from Mr. Kowalski on the witness stand, that if we only turned over the video, everything would have been different. It's a clear violation of this court's order. It's a complete misstatement of the facts that the video was in the possessions of the Kowalskis for 2 subsequent hearings. And I think we have to move for a mistrial at this point, Your Honor. We would reserve on that until the close of the case, but we do have to mark for the record that we are moving for a mistrial on that case.
Well, are you moving for a mistrial or are you not moving for a mistrial?
Yes, we are moving for mistrial. We'd ask the court to reserve on that.
Joe, what, Mr. Altenburn, is your proposed language?
Your Honor, on the fly, I think from what I'm hearing that you should tell them that the jury is to ignore the testimony of Mr. Kowalski, that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court in the DCF proceeding.
Is that written out or is that?
No, I'm taking from my very bad handwriting to do that.
If you say it again, all right.
Yes.
Can you read that to me again?
Well, I'm just recite it again. Can you read it back?
me to read it?
Yes, that's probably better. You can go from there.
Your Honor, on the fly, I think what I'm hearing that you should tell the jury is to ignore the testimony of Mr. Kowalski that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court in the DCF proceeding.
One point, Your Honor.
Your thoughts, Mr. Anderson?
First, for the record, the December 5th and December 13th hearings were not on any merits of the case. They were purely procedural to deal with how Maya Kowalski was being treated and how the orders were to be modified in regard to that. So there was no opportunity at those. Our concern in this, besides the fact from the defense's perspective, it just merely highlights the testimony. Our concern is this: until the court hears Ms. Salisbury's testimony completely, which I have summarized but by no means have made complete, we believe that it's objectionable to read any instruction that would diminish the plaintiff in front of the jury. And really, the question did not call for it. I'm sorry it went farther than I anticipated, but it was not intentional in any way, shape, or form. And until the court has all of the facts in this to make a determination, we do not believe that an instruction is important. We have to put on our whole case and at least get to Ms. Salisbury's testimony. And then the court can decide what it needs to do. For the record, I'd point out the number of orders in limine in this case makes trying to examine a witness a veritable minefield. And I simply wonder, given human beings being human beings, how it's that it's going to be let me say this, it's very difficult for me up here questioning to constantly have to weave around these orders. That's the problem with trying the case in limine. So I understand the orders are there. I understood that the court was open to them. As to the summary judgment, the only thing I got mixed up on was about the November 17th versus the dates that mattered.
Here are my thoughts. In response to Mr. Anderson's point, let's just wait until we hear from Deborah Salisbury. The problem with that is, even assuming that Ms. Salisbury could not open the video, she had knowledge of the video indisputably no later than November 17th and could have sought relief in front of the dependency court if she was having trouble opening it up, and could have addressed the issue in front of the dependency court. So here's what, based on what Mr. Altenburn said, let me read kind of where I'm at, but this is not a ruling. This is, let's just listen to it. The videotape that the jury has been seeing and discussing, the videotape that the jury has been seeing most recently this morning was provided to the Kowalski family attorney on November 17th, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for court orders entered in the dependency action.
I think that's fine.
Your Honor, the second sentence there, that it would not have made a difference, implies that it could not have made a difference in the time before November 17th.
And that's our problem.
And that's our fraudulent concealment count is based on.
So would not have made it after November 17th?
Yes,
And
and
it
that's
depends on
fine.
how much evidence we want to get in on this, because I mean, there were two lengthy hearings on November 5th and December 5th and December 13th.
Procedurally.
And no one raised this then saying we want to use this to change orders or to do anything. And so then the argument's going to have to be that they would have done something in that 30-day period that they didn't do in the 30-day period after they had this, and when the hearings were also taking place. So this becomes sort of an inference on an inference kind of problem as to what a judge would have ruled if he'd known something on November 10th when they didn't give it to him on December 10th once they had the document.
I think we're now re-arguing the summary judgment. The court made its decision November 17th is the cutoff deadline. So we're allowed to pursue this up until November 17th. There were two shelter review hearings on the 8th and the 10th, lengthy, full-day hearings, where Mr. Kowalski had no knowledge of this video.
And they had a duty under their statement.
Time out. I think Mr. Whitney has a point, so the second sentence, let me read it and get everyone's thoughts. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17th, 2016 in the dependency action. To be clear, defendant J. Hatch cannot be held responsible for court orders in the dependency action.
So to be clear, does that mean I'm going to have to start arguing and having evidence on relitigating the DCF and things and bring in people about whether it would have made a difference in the 30 days earlier? Because, I mean, we're opening the can of worms that you didn't want to open.
It's a can of worms that was opened in the summary judgment orders, been read multiple times. It's been known to the
Well-
defense that this was an issue.
It's been known to me what we were going to try the case on, that we were not going to try the DCF case based on orders that were entered long before this trial began, Your Honor. And
His
now,
testimony is in the hospital.
Time out. Can we just have one at a time, please? Count 20 has been limited to the time period prior to November 17.
so the question, Your Honor, I think is, can Ms. Salisbury or some other lawyer get on the stand and opine as to what she would have done if she had been technologically capable of opening this when she claimed she couldn't, and what arguments she would have made, what arguments the DCF would have made, because John Hopkins wasn't a party, wasn't even attending those, and what ruling the judge would have made. We're stacking a whole bunch of circumstantial things together that looks to me like we're going down a black hole.
Well, I mean, anything after November 17th, we're not going there.
Yes.
That's clear. Count 20 specifically talks about the video surveillance.
Never really alleges that Ms. Salisbury would have done something different in that time period, to my recollection. It was very unclear what they were going to do, or that what they didn't do in reliance on the fact that they didn't know about this.
Well, I guess the best I can say at this point in time is count 20 prior to November 17th is a live count in this case.
I'm sorry, Nick was talking in my ear one more time.
It is a live count.
Yes.
I guess we have to wait till see whether they put her on the stand. But if we do that, it kind of changes what I visioned the scope of this to be as we were entering in it through pretrial.
I'd prefer to just take it one step at a time. If I'm understanding the court correctly, the last sentence was that the count remains alive.
Well, count 20 still is a live count to the extent it's prior to November 17th. Now, I'm going to reread the instruction one more time and see if there's any more tweaks that we need to give. The videotape that the jury has been seeing most recently this morning was provided to the Kowalski's family attorney on November 17, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17, 2016 in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for the court orders entered in the dependency action. Any other?
Yes, Judge. Technically, it would be the prior attorney, so I don't want to diminish my standing before the jury. So rather than saying her attorney, can you say her prior attorney? Or prior counsel?
Or the family's attorney at the time.
Yeah, the family's attorney at
I
the
don't-
time.
How about the Kowalski's family attorney in the dependency action?
Right.
Perfect.
But by the 17th, did they have separate lawyers? I don't know when that at one point, and I think it's before the 17th, he had a lawyer and she had a lawyer. So there were two separate, I mean, he's testified to 4 lawyers, and that's what he's talking about, is that they ended up having 2 different lawyers pretty early on.
And Ms. Salisbury represented who on the 17th?
I think Jack Kowalski.
I think that's correct. And there was new appearance for Beata Kowalski.
So,
In fact, I can,
so why don't I just say to Mr. Kowalski's family attorney in the dependency action on November 17th?
That's fine.
I think I may have the answer to this. Hang on.
Mr. Altenberg, any other?
No, Your Honor.
And Mr. Anderson, did you want to say anything on the mistrial motion?
Judge, the error, and we're not conceding there was, but if there was error here, it certainly did not go to the point where it would so prejudice the jury in their review, particularly with the instruction, which I think cures anything. I would simply point out that this case is incredibly complex and difficult to try. for anyone, and I'm sure with the court too, with the number of orders in limine and summary. We have 52 summary judgment orders, and I've lost count of the number of orders in limine. I believe in this case that there's going to be more than one incident where a question brings out something, no matter how much the plaintiff's counsel instructs witnesses, including their client, no matter how much we instruct them, they're human beings. And they don't go as programmed a lot. So my concern on these motions are that the defense wanted them entered, and now we should have some understanding of the difficulty in this case, and that really at this point there is completely insufficient problems to impress this jury to the point where they cannot receive a fair trial, particularly with the instruction.
Anything else, Mr. Shapiro?
Very briefly, the reason for the mistrial is not simply a violation of the motion in limine. It's intentionally walking a witness through questions that knowingly we're going to end with a response that if only something was given to me, the dependency action would have turned out differently, implying that All Children's is responsible for taking Maya Kowalski away. I believe this is the third time that the court has had to give a curative instruction to this jury in this short trial that we've already been through, telling this jury All Children's is not responsible for Maya being taken into state custody. And so it's the cumulative effect of all this. It's not just merely a violation of a court order, but we believe at this point the intentional walking a witness to a statement that this court's instructed multiple times is not a subject to the litigation because we do have immunity. Thank you, Your Honor.
I categorically deny.
I'm going to deny the mistrial motion. I will say, honestly, I think that the trial has been cleaner than I anticipated it was going to be by this time. Honestly, and that's a tribute to the lawyers, and I think the credit needs to go to the lawyers. The concern I had when that question was raised, which has been articulated by Mr. Shapiro, is the impression it gave to the jury that somehow this video would have caused none of this to have happened. And I think that this curative instruction specifically and directly addresses that perception that Mr. Kowalski's statement could have been given to the jury. And it's done timely, it's done right away. And so I don't see a basis, I don't see a cumulative basis for a mistrial. I'm comfortable with this curative instruction, and it will, I'm confident, will ensure that this jury does not take a false implication from Mr. Kowalski's statement. Okay.
Yes,
I'd really like to bring the jury back in.
And I really want to not get another mistrial motion, so I wanted to ask the question. The question that was coming next was this, would this video have been of value to you? And he knows not to say anything about substituting it in or reopening the proceedings. But there are two things it's good for. The first is for him to understand what was going on with his daughter, and that goes secondarily to the damages in terms of emotional distress and so forth.
Well, I'm assuming that you are restricting your question to a date range to which it applies.
Yes. Right.
And Your Honor, just to make something clear in the record, I've checked my personal notes having read the transcripts in the DCF proceedings, and it appears that on November 10th, Ms. Salberry appeared for both parents, and then on December 5th, they each had separate counsel. So sometime in between there, and I cannot tell you whether it's before or after the 17th, that there was a substituting of counsel. I can actually look at the docket on that and figure out the data.
I don't think for purposes of the curative instruction it matters.
I don't think so either. I just wanted to be honest about
Thank
that.
you. I appreciate that, Mr. Altenburn. Anything else, or can we bring in this jury?
Nothing else from
And let me ask, how much longer do you have in direct? Because you told me yesterday it was 1 hour.
Yeah, yes, Your Honor. It's been a really difficult extended hour. I would say I'll never finish by lunch.
Okay, so we're going to go to lunch while he's still on direct?
Yes, sir.
Okay.
And I can ask that would have been of assistance to him. That question.
It's going to be objectionable.
He knows. He's not touched that again in his life. but it would have been of assistance to him in knowing what he has a legal opinion.
Okay, please be seated, everybody. Okay, members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct? Correct. And that you did not look at any media coverage concerning this case while you were on break? Correct. And no one approached you about this case, is that correct? Correct. Okay. And members of the jury, I'm going to give you another instruction at this point in time. The videotape that you as the jury have been seeing most recently this morning was provided to Mr. Kowalski's family attorney in the dependency action on November 17th, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that that statement applies on or after November 17th, 2016 in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for the court orders entered in the dependency action. You may continue, Mr. Anderson.
As the court has related, the video was taken October 18th through 20th. Now, on or before that date, did they tell you in any way, shape, or form that they intended to do a video surveillance in a separate room of this nature?
No.
And if they had, would you have consented or not consented?
I would not have consented.
Did the hospital tell you at any time in October 16 that they had taken a covert video of your daughter over 48 hours in mid-October?
Objection, Ms. States have it.
Overruled.
No.
If the hospital had told you about the video before November 8th and 10th, what would you have done in terms of objection? Would you have objected to this video going outside the hospital?
Yes.
All right. So in reviewing this video, when you finally did get to view it, did it affect you emotionally to see this happen?
Yes.
And knowing your wife, would it have affected her?
Definitely yes.
Okay. Now, let's continue, if we might, on the lesion photographs. We were at 2571-001. All right, you recognize this photograph?
I do.
And what is it of?
It's a lesion.
Approximately when did you take this photograph?
There's a date on the bottom, 10/8/2016.
All right, let's go to 2571-026. All right, so 2571-026, what is this a photo of?
It's a photo of Maya. And there's some lesions. I see one on the forehead and maybe on her left knee there.
All right, let's go to 2571-030. And what do these reveal?
There's more lesions, right and left hand, and then also her forehead.
So this is as of December 24th, before Christmas?
Yeah, Christmas Eve of 2016.
2571-053. So this is of a date some, what, 2 weeks before, no, a week and a half after?
Yes,
And is this the same lesion, unhealed, that appeared in the prior photo?
that is correct.
How long would it take a lesion to heal if they did?
Attraction Foundation, call.
He can observe.
Overruled.
I honestly don't know how long it takes to heal. I think Dr. Chopra mentioned that, but I'm unaware.
And then let's look at 2603. And that one is from, looks like, well, that's date of admission. Do we have a date on this one? Yeah.
It's January 1st.
2017. It's in the handwriting.
So, there you go.
That's another lesion.
Okay. And we'll ask about that in a moment. And then 2604. And is that another lesion?
Yes, it is.
All right. So the lesions that you saw there, were they in existence, to the best of your knowledge, prior to January 7th of 2017?
Objection to the leading room.
Overruled.
There was lesions. I did document it in my notes, along with taking some pictures and also advising the staff.
Okay. I'm informed 2604 has 8 photos. Let's continue on with those. Now, that last photo and this photo, looking at the pants and the situation, do you know who took these photos?
I was going to say that's not mine.
Okay.
I don't believe so.
All right, continue. And continue. And is that a lesion on her hand?
That is a lesion on her hand, yes. Left hand.
All right, continue.
Lesion on the forehead.
Continue. Now, are you familiar with this photograph?
Recently, yes.
At the time, did anyone tell you that they were going to take off some of your daughter's clothing to try to check her for lesions?
No.
And the prior two photographs, having seen this one, were they photographs of your daughter in this series?
Yes.
Continue to the next one. Well, first, do you see, you can only see half of her face there. But knowing your daughter, what is her reaction here that she's showing?
It's hard to see her whole face, but looking at her lips, she doesn't seem happy with what's going on here.
All right, next photo. And now she's down to what, a training bra?
That is correct.
So, did you ever give Kathy Beatty or anyone at Johns Hopkins All Children's Hospital permission to strip your daughter and take photos like this?
No.
Next, please. Is that the last?
That's the next one.
Okay. And then did we cover 2603 and that was 2604?
This is 2604 dash 8.
All right. So, make sure we've got them all in. When was the first time you learned that your daughter had had this happen to her?
It was around the time after, I believe, she went to court in December or January. I don't know exactly what month.
Okay. Did it turn out that this was the day she was to go to court?
Yes, it was. She was going to be evaluated by Dr. Duncan.
And again, did anyone call you and ask you about this?
No.
Let's show the remaining photos in 2604. Continue. Continue. Now, hold on there. Go back. Do you notice her hand there?
I noticed her hand and then also the arm. You could see discoloration in it. If you go back one more picture, I believe it shows the arm. See that by the elbow area?
And what did that correspond to with your experience with your daughter?
We were told that's a typical sign of CRPS.
And let's go back to the hand. Next photo. And the next photo. Continue on. Do you know if these were taken in her room or someplace else?
I was somewhere in the hospital.
Continue. See the knuckles? Let's go back a little, and that one too. Does she have a lesion there right below the knuckles?
That is correct.
Are the knuckles red?
Yes.
Tell the jury what that indicates to you, knowing what you know about your daughter's condition.
Another sign of CRPS.
When she had these, did it indicate that she was having a flare-up?
Objection, called foundation.
Overruled.
A flare-up and associated with these lesions, there's extreme pain to the lesion itself.
So when someone would grab her hands in these videos, can you tell the jury the reaction you have seen your daughter have when they touch those lesions?
It would cause extreme pain.
Next photo. Notice the knees.
Yes, I do.
And what does that tell you?
If you didn't know that she had CRPS, you might think she's, they were rubbing against something, but that's a sign of CRPS.
Right. Next photo. And what does that indicate?
That's inward rotation on her feet. That's called dystonia.
Next photo. So here they are pulling up her shirt. Did you ever give them permission to touch your daughter in this way?
No.
Next photo. I can't tell anything about this one. Is there anything we should be looking at?
Not that I see.
Let's continue on.
It's the final photo of the exhibit.
Now, having looked through the photos, can you tell the jury your reaction the first time you saw these?
Okay. I was extremely upset. She's in the hospital. Later I found that it was against her will, that Kathy Beatty stated that that's the only way she's going to go to the courtroom is to get the pictures taken prior to her.
Objection to the hearsay.
It's party admission.
Overruled.
Did Kathy Beatty say anything about that you know about whether Maya would be able to see her mother?
That I don't recall.
We should ask Maya on that one.
Yes, ask Maya.
All right. So they're talking about these symptoms, not these symptoms, but they're talking about, strike that. Did they ever discuss with you their belief that your daughter was suffering from some sort of psychological disorder?
Objection to the foundation, the they.
Let's be a little bit clearer with our pronouns.
Did any of the psychological or psychiatric doctors there tell you that they believed your daughter had some psychological problem?
Yes.
And who were those, do you recall?
I'm very bad with names with doctors.
Let me see if I can. Okay. Did it come to pass that you were trying, well, once you heard this, did you want to talk to them and question them about it?
I tried at one point to talk to the Dr. I'm going to bosh her name, I'm sorry, Kattenstein.
That's it.
I did see her in the hallway. She approached me. She was nervous. She was looking around. She says, I should not be talking to you. I would like to talk to you, but I should not be here. And she's looking around. And she said she has to talk to both sides of both attorneys before she could talk to us.
Well, was your daughter in part under the care of Dr. Katzenstein?
She was, and I still had my patient rights.
And so,
Or not
she ever
patient
tell
rights,
you-
rights for my child, I'm sorry.
did she ever explain in any way, shape, or form why they thought that this was occurring or what reasons they had?
She didn't explain it to me. She was just nervous, looking around. She did provide me with her card with her cell phone number on there. But she instructed that, or it told me that she has to talk to both sides before she could talk to me.
Well, who was the other side? Do you know?
Well, it would be my legal, Deborah Salisbury, and then the hospital side.
Okay. Now, did any of the other physicians, strike that, who brought it up first to say that Maya was somehow faking this?
That'd be a good question for Maya, because Maya was told by many people.
In the hospital?
Yes.
All right. Did it come to your attention that the nurses there were telling her that she did not have this?
Yes.
Did you learn that Maya was having difficulties even speaking to her separate counsel now, having difficulty speaking to her separate counsel?
Yes.
What was the problem there?
Normally, I don't want to get stuck with hearsay here.
Well, you give it a shot. I'm sure they'll let you know.
Yeah. She advised me when she was speaking with her attorney, Kathy Beatty, be outside the room with the door open, right next to the door.
Right. And during the attempted phone calls with Maya and between Maya and your wife, were you witness to or in the room when Ms. Beatty would, not the hospital room, but I'm talking about more at home, when Ms. Beatty would interrupt?
Most of the times, no, I was not. I did hear from Beata, and I also heard from Maya that was an issue.
And what was the problem?
Foundation in person.
Sustain that one.
And so were you having difficulties communicating with Maya, best of your attempts, because of Ms. Beatty?
I had difficulty, but I didn't have as much difficulty as Beata did.
And how is that affecting her, not being able to, or having her attempts to speak with her daughter interfered with?
It destroyed Beata.
So now, you previously testified that Ms. Beatty asked you or suggested to you or asked to you whether you should just divorce Beata?
She asked me if I ever considered it, which was a very odd question, just come up with something like that.
All right. And have you since learned that Ms. Beatty took your daughter to the chapel there at the hospital?
Object to the hearsay, Your Honor.
It's in evidence.
Madam Court Reporter, can I have that question back, please?
Question, all right, and have you since learned that Ms. Beatty took your daughter to the chapel there at the hospital?
It's in Beatty's depot.
Well, I'm not sure where it's coming from, so I'm going to sustain the objection. You can see if you can get it a different way.
Did your daughter ever tell you that Kathy Beatty took her down to the chapel?
Same objection.
No, that's a statement of present condition.
I'm going to overrule that.
Yes, she has.
And did she tell you what the purpose was?
She stated that they went in the chapel and Kathy Beatty would talk to her in there.
Talk to her about what?
Same objection here, sir.
Overruled.
There was one point that she said that she could adopt her, that she could be her mother while she's here at the hospital. Just all different things. Mom's in getting mental health, help, I'm sorry. Just all different things. Stroking her hair, kissing her.
Did Maya complain to you that Miss Beatty was hugging her inappropriately?
Objected here, sir.
Statement of then present.
Can I have that question again, please?
Question, did Maya complain to you that Miss Beatty was hugging her inappropriately?
Okay, I'm going to sustain that one.
Did you understand from Maya that Miss Beatty was making Maya believe some? Strike that. Did it come to your attention that other employees besides Miss Beatty were making similar statements?
Object to the hearsay.
Didn't it?
I agree with Mr. Shapiro on that one.
Now we'll ask Maya. All right. So what you testified to before, just now, about the chapel and the things that she said, did you let Beata know about that?
Yes.
What was the effect on your wife?
She was
when
irate.
To what?
She was irate.
So this was, I think, the photos show towards the end of Maya's stay, and also the record reflects that your wife took her life the evening of when?
It was January 7th, January 8th.
So these photos were taken, were they taken in close approximation to
Very close.
Objection, Your Honor. Foundation, and I would approach on this, rather than speaking objections.
Objection sustained.
During some of your visits, did you see Maya being mistreated?
No.
Did you see the nurses taking any action that you would describe as cold or unusual?
No, there was just incidents where I wasn't allowed to leave a computer, or they wanted her passwords for her social media, things like that. Nothing physical that I could think of. There was a nurse that she liked a lot, but I didn't see anything. You know, I felt that they were cold to me because the situation, like I felt like I was a bad person when I walked in there all the time.
And so now, when you learned of the various things the hospital was doing in terms of the photographs and the video, did that cause you mental distress?
Objection, foundation, predicate.
Overruled.
It sure did.
And can you describe it to the jury why this was so upsetting to you?
It's so upsetting because I have to go home, and then that's happening, and there's nothing you could do. If I snap, I'm going to lose my privileges. It was very difficult for me to hold it in.
Again, object and move to strike based on the time frame.
Now,
Overruled.
did you tell Beata about this?
I did.
Objection, again, hearsay and the time frame again, Your Honor. This is
Obviously, it's from that.
Well, let's try to be better with our pronoun usage.
Did you tell Beata, about what we just talked about when I said this, the photographs that had been taken of her, the video that had been taken of her?
Objection, misstates evidence.
Okay, overruled. You can answer that.
Yes, I did. I did tell her.
And what was her reaction that you saw?
Same objection.
Overruled.
She had the same reaction I had. As a parent, I think any parent would have that reaction.
Did you feel powerless?
Yes, I did.
And how did that translate in terms of your behavior?
My behavior, I was very upset at home, but when I went there, I had to hold it in.
Are you by nature a fairly stoic person?
I'm usually very calm.
You try to hold things in?
Yes, a lot's held in.
How about Beata? Was she that way?
Not as much as me. She would let you know how she feels.
And then when you told her, can you describe for the jury that mental distress that you observed, everything you saw, heard?
Objection, hearsay, predicate, and foundation.
Overruled. You can answer.
I'm sorry, could you repeat it again?
From everything you perceived about your wife, how upset was she when she found out that her daughter was being treated this way?
Same objection, Your Honor.
Overruled.
It was extremely difficult for her. It was taking all the air out of her balloon. I mean, you could see that it was just eating at her. She lost a lot of weight during this time.
Through the course of December, how was Beata doing? Was she stable, not stable, moving down, moving up, what?
Beata was still functioning what she had to do, but it was really difficult for her.
How were you two getting along?
Oh, it drove a wedge between us. I'm trying to, to do both, go to the hospital and then try not to bring it home and tell her everything, where it would hurt her. I'm not intending to hurt her with the way her daughter's being treated, but she needs to know.
Well, did she pump you for information when
She would ask me, and then at times I believe she was talking with the hospital as well, but not getting full answers on treatments and that. So that would interfere and make it worse for her as well, stress-wise.
Were you worried about her mental condition through this period of time?
I was always worried about her. Yeah.
Over this period of time, now we're talking about after you learned about the video 18th and 20th and these photographs, did you have some physical symptoms from this distress?
Objection again to the time frame, predicate, foundation.
I just said it.
Okay. Well, let's be a little bit clear about the time frame, but otherwise overruled.
After you learned of the November 18th to 20th videos and the photographs that were being taken of your daughter and of the manner in which she was being treated overall, Did you have any physical signs of distress?
Same objection, Your Honor.
Yeah, overruled. You can answer that.
Yes, I did.
Tell us what they were.
Number one, anger, loss of sleep, just wasn't myself. Diarrhea. I mean, it takes a lot out of you, the stress.
What happened to your weight?
Same objection, Your Honor, for time frame.
We're talking about this. Are we talking about in the same time frame?
That is correct, I believe.
And then, did you experience in this same time frame we have defined any symptoms of nausea?
I had nausea. Like I said, I had diarrhea. When I get a lot of stress, it's hard for me to digest food, things like that as well. Sleep, lack of sleep, big time.
Tell us about the sleep. Like, how long do you usually sleep without this level of stress? Compare that to what was going on at this time. That is from the period of your daughter going in and after you learned about the video and the photographs.
Later at the end, it was a lot less. I was extremely stressed out. I was concerned for Maya. I was concerned for Beata and Kyle. Knowing Beata was still trying to do research and things like that, she was up more, and sleep and being nervous and things like that was extremely high.
And then there was the evening that Beata took her life.
Yes.
Before we get into that, I'd like you to explain a little bit about the billing that was going on by Johns Hopkins to who was your health insurer at that time?
At that time, I believe it was Aetna Insurance, and that was through Beata's work.
And then did you ever have the opportunity to go over these records to see what they were, obviously, what you were being billed for these services?
Predicate and foundation and time.
Overruled.
At that time, Beata managed the bills, but she would inform me that they were astronomical.
Mr. Anderson, just in the next 10 minutes or so, let's try to find a good breaking point for lunch.
With the court's permission, I'll just end with this Aetna billing. Just a few more questions.
Whatever you want, just within the next 10 minutes.
Right. All right. So when was the first time you had an opportunity to go through that billing, best of your memory?
Well, after she passed, I had to go on to Cobra through her work. And they allowed
Cobra?
me to...
I think everybody knows, but what is Cobra?
Cobra, it's just I was able to stay on that program for a certain time period with the same benefits, but I would have to pay in place of the employer paying most of the premium. So it jumped up significantly.
You remember approximately how much?
I'm guessing it's probably in the area of $1,300. I could be wrong on that.
A month?
That is correct.
And have we put those records in evidence?
Yes, whatever I had and obtained, I gave to you guys.
Okay. So then, did you learn that some of the, or most of the entries there, strike it, how did you learn that most of the entries there were for CRPS?
Objection, foundation, predicate, and the state's evidence.
You already said. Did you review the records to see what exactly you were paying for through Aetna, or what Aetna was paying for you?
After some time, there was some for charges for CRPS during that time period.
And did you ever determine what percentage of those billings were for CRPS.
I don't recall the percentage.
Okay. All right. And so what happened then after or during this period of time, every time that they billed Aetna for a procedure that they did not do, did that go on your deductible?
Objection, argumentative.
Overall.
Yes, it did. And then eventually it was, we met our deductible, unfortunately, with all the bills.
And did you have to pay in after that?
There's a lien still today on
How many?
some bills. I honestly don't know, but it's a significant amount of money.
That you owe and on some contingencies?
Objection, it's both leading the state's evidence.
Sustained.
We'll come up with something on that. So once the deductible was reached, did you have to pay out of your own pocket the co-payments?
Once the deductibles met, no, I don't believe at that time we had to pay unless, if you're talking about a co-pay, something small,
Yes.
I believe we had something, but
All right. Approximately what was a co-pay per visit? Approximately.
I honestly wouldn't even know.
Okay. All right. Well, let's break right.
So lunchtime?
Lunchtime.
Okay. Members of the jury, I'm going to excuse you for lunch. Deputy Coley, I want them back, ready to go at 1:45. So from this moment, you get an hour and a half, okay? Do not discuss this case amongst yourselves. Do no investigation and receive no information. Have a good lunch. See that the jury is out of our presence. Okay, let's work backwards on our time for lunch. When you all come back from lunch, Mr. Anderson, I'm going to want to know what, if anything, you want to do relative to filing your mistrial motion or not on the issue of the sexual abuse claim that I did not allow in.
Yes, Your Honor.
So-
I wanted to wait till the break. So we do, and we asked the court not to, and to withhold, obviously, in light of all the circumstances. But we
Well,
would move.
I want to have that discussion after lunch. So tell me, I need to know how much time you're going to need to.
I'm just going to make the motion and just explain what it is. I won't need more than 5 minutes.
Okay. And are we having any exhibit issues that we need to address?
Let me check. Do we have any exhibit issues we need to address?
We're planning 2 depositions when Mr. Kowalski's done.
How long are those depositions?
One of them is about an hour and 20 minutes, and the other, I don't know, maybe someone just watched Ms. Beatty?
No, we haven't had a chance, I don't think, to watch it. We'll do it over lunch.
It's a little over an hour.
Both are a little over an hour, I'm told.
That's aspirational only because I probably have at least an hour of cross. So,
Well,
anyway.
and on the videos, this is the first time, and as I said before trial, but I want to remind you, you're going to have to tell me time frame. Let's say the video is an hour. I need to know how much is attributable to the plaintiff and how much is attributable to the defendant. And I don't want to have an hour discussion as to how to divide up the hour time. So perhaps.
I'm sorry, didn't mean to interrupt.
Yeah, so make sure you're ready to give me that split.
Okay. I guess we'll try to stopwatch it, but the problem is the speaking objections through it, as the court's no doubt seen, add a lot of time.
Well, we'll know it's an hour and 30 minutes or whatever it is, and I need, to a 5-minute increment, a division of that, the amount that we're going to play for the jury.
Yes, Your Honor.
We'll do it.
Okay. Anything else that we're going to have to do?
Not from the defense, Your Honor.
No, Judge, I don't believe so.
So if we are back here at 1:30. That would give us 15 minutes. Is that going to be enough time to address these issues?
Yes, Your Honor.
I believe so.
I will see everybody at 1:30 then. John is back. Let's talk for a moment about tomorrow. I am told that tomorrow at 2:20 p.m. the federal government is going to be testing the emergency alert system, which means every person's cell phone in this courtroom is going to be going off.
We'll take a break.
The test is apparently starting at 2:20 nationwide, and it will go for 30 minutes.
30 minutes?
What?
My hope is that everybody's cell phone will blare at 2:20, and we can just take a break at 2:18 in the afternoon and be back, 10 or 15 minutes later. But understand that I don't have any control over the nationwide test.
Is that going to blare for 30 minutes? No, it can't.
Well, your cell phone is going to blare for about 15 or 20 seconds, but it might take 30 minutes for everyone's cell phone to blare. And having been in court with jurors present when everyone's phone starts going off, it's not a very happy time. So please arrange yourself so at 2:20 we can take that break.
Yes, John.
Next, Mr. Anderson, do you
Could
have
we go back to tomorrow?
tomorrow?
Mr. Anderson and team have been kind enough to give us their lineup for tomorrow, and I hope the exhibits. There are two witnesses that may require a proffer. There's two lawyers that are on the list, Mr. Zimmerman and Mr. Kelly. We're not aware of what knowledge they have of any of this other than the DCF action. And so we're going to need to have a proffer on what they're doing or what they're going to say in order to do it. We also don't need to do that now, but it needs to be figured into plans.
Your Honor, for the record, neither one of them are going to testify about what happened at the DCF proceedings. They are going to testify about their ability to speak to their client confidentiality and how the hospital interfered with that. I don't anticipate their testimony being very long. I think also they'll testify about the fact that, contrary to certain representations, that Maya loathed Beatty and hated being there, and although there was one or two nurses that were okay to her, most everybody was not nice. So that's the sum total of their testimonies.
And when were you anticipating these witnesses testifying?
Well, Mr. Zimmerman is in Europe, so we are working out times with him. We would hope it would be the end of the day, around 4 o'clock.
Well, if he's in Europe and you want at 4 o'clock, that's probably putting him, 9 p.m., 10 p.m., depending on where in Europe he is?
Yes, I spoke with him about it. And I still have not personally spoken with Mike Kelly, but I'm informed that someone from my staff has.
Well, given what Mr. Anderson just said, do you still think there's going to be a need for a proffer?
I don't think so. But
You do not?
if they're not going to implicate DCF at all, or the dependency action at all, then I don't think a proffer is necessary. But you've heard what I heard.
Okay. Well, no DCF issues?
No, I'm not asking questions that involve DCF.
Okay, well then,
How the minefield turns out is anyone's guess.
what's the next issue?
Plaintiffs move for a mistrial based on the failure to allow the entry of the evidence of Maya Kowalski having been sexually assaulted at Johns Hopkins Children's Hospital. We will follow up with a proffer from Maya Kowalski of exactly what happened. We note that both Jacqueline Henschke and Dr. Katzenstein from Johns Hopkins, Dr. Henschke independently have verified this, and we have an independent witness. Still, we understand the court's position on this. However, since we have I believe we can show that the defense has known about this for a considerable period of time before we ever had voir dire, and if once we get a transcript, we can show that questions similar or about this were asked during the course of the voir dire. I don't know the exact wording, Your Honor, and you were there too, but I believe we went into the extent of battery. That's just from memory, and your court may remember it different, but I remember the subject came up. Now, whether they were asked or not, we'll have to see. If, in fact, there was enough brought up so the court feels comfortable on that, we hope to be offered a rehearing on it. There are other bases, but at this point under the case law, we ask the court to suspend any ruling on that till the end of the case. The parties have spent enormous amounts of time and money. This court has spent enormous amounts of time getting this case to trial, and it would be an abject shame if we had to terminate it after all this work we've done. 5 years, 52 summary judgments this court has heard, and we don't want, at this point, for the court to stop the trial. We want to move forward. We simply want to note for the record on the present second DCA case law the importance of this testimony.
So you're moving but not moving for a mistrial?
I am moving but asking court not to rule until the end of the case. I believe I can do that under the present case law. If I am in error in that, let me know, because I may then withdraw that motion.
The defense objects and believes that the plaintiff has mischaracterized the mistrial rule. We would ask the court to deny the motion for mistrial. I can give the basis, but procedurally, that's not something they can defer until the close of evidence. We would ask that to be ruled on now before this entire tribunal spends 6 more weeks in enormous expense. I can respond further, but if you want to take it one at a time, you can, or I can relay the record.
Now's the time if there's anything you want to say on the issue.
I do want to say one other issue. I will tell this, as an officer of the court, I've spoken with Dr. Katzenstein. The note that she wrote is specifically this, quote, she denied a history of sexual abuse. This is coming from Maya. Quote, she stated one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. I've spoken with Dr. Katzenstein. Her testimony in this court will be that Maya told her that that was from another hospital. That was not at All Children's Hospital. Dr. Katzenstein will testify that there's a very strict protocol at All Children's, and that she specifically would have asked Maya, did that happen here? Because if it did, it would have triggered an investigation. So for the record, All Children's absolutely denies, based on what Dr. Katzenstein's testimony will be, that she was told about some type of an assault, or really what's being described here, how it's being described, inappropriate conduct that occurred at All Children's Hospital. That being noted, in terms of the surprise, I think Your Honor's already laid out nicely, the prejudice in terms of jury selection being at this point in the trial. We would just note that there's no way we could have known about an allegation that the plaintiff themselves said they were completely unaware of. And the note from Dr. Katzenstein does not say that there was something that happened at All Children's that she will disclaim. That's all, Your Honor. Thank you.
Anything else? I know Mr. Hughes was whispering in your ear.
No, really. Nothing else, Your Honor.
Anything in rebuttal?
Yes, Your Honor. Maya Kowalski would be the best witness as to that, and it would be very interesting to cross-examine Dr. Katzenstein, given the absolute obligation, once that was raised, as to anyone, anywhere, by a child to report that. So we will welcome the opportunity to cross-examine Dr. Katzenstein on that. The biggest concern is Dr. Henschke's records, which the defense has had since March of 2022, and which have much more detailed information pinpointing where and how this happened. And so it's still not complete, but it certainly would put any reasonable attorney on notice that this had occurred. We did not, because we were attempting, if the court will recall, to make Dr. Henschke a safe harbor for Maya, so that she could tell Dr. Katzenstein anything that she wanted, so that it would help reduce the stress and strain on her. That did not happen, and through the course of the deposition of Dr. Katzenstein, which was on Zoom, that was never asked. And I confess that we didn't start going over a lot of the records until Dr. Katzenstein was flying in. Had, of course, our client informed us that this was something that was going on, we would have looked again at Dr. Katzenstein's records, and we would have probed more of the records of Dr. Henschke to be able to bring this to the court's attention. Basically, that the defense had greater knowledge at this point, the record I believe shows, than the plaintiffs did, given the plaintiffs, Maya Kowalski's direct denial for 5 years, not denial, but failure. She didn't deny it. She just failed to tell us about it for 5 years. So, frankly, I wasn't on the lookout for it.
Okay, the issue has to do with whether to grant plaintiff's motion for mistrial. It appears the plaintiff is contending that the court made an incorrect ruling on the denial of allowing the newly discovered evidence, if that's the phrase we're going to use, into this trial when that is outside the pleadings and was not disclosed to the court and potentially the defense until after the jury had been sworn and the trial started. The court does not believe it abused its discretion in denying the motion, and I laid out earlier this morning the court's view on that particular issue. I'll reaffirm that ruling, and because there has been no violation to the plaintiff and no prejudice to the plaintiff, at the end of the day, this still was within the ambit of the plaintiff's knowledge. I understand the circumstances may be such that Maya Kowalski didn't recollect this until more recently, but you know, we are where we're at. I don't believe there's been any incorrect ruling, and so I will deny the motion for mistrial.
We understand the court's ruling. Let me continue. We have one more matter.
Next issue.
The court had requested, I think twice, for us to come up with a stipulation as to the lien issue, and if I could pass this up to the court, and we prepared a copy of it for the defense counsel.
Did you give that to Mr. Anderson?
Yeah, he's got it right here.
Oh, he is? Okay.
Is this something that is agreed to?
No,
or?
we haven't seen it.
Yeah, we'd prefer to have some time to look at this and maybe address this after the jury's gone for the day, rather than hold up the jury for the day.
Well, if they haven't agreed to it yet, it's not yet a stipulation.
I understood, Your Honor. The only caveat we would put in the record is that there'd be no objection if this stipulation, well, based on the results of this stipulation, to Jack Kowalski being recalled to address some of this issue.
No objection.
Anything else before?
Just briefly, Judge, they told us I'm sorry, Mr. Anderson, were you not finished?
Yes. We plan to ask Jack Kowalski about the Aetna billing records, which are in evidence. And then there is another email of 2438, and it's a series of messages between Aetna and Beata Kowalski. We're not so much concerned about the Beata Kowalski input, although we believe that should be relevant to under.
You said 2438?
Yes, 2438.
Is this on the list for today?
It was on yesterday.
It was on yesterday's list.
No, I don't have the actual thing because it was not on Jay's list.
What was it on his list?
That's what he's saying. I have to find that list.
Mr. Anderson, Mr. Whitney, could you put up on the screen so we can see?
Yes.
Do that.
I don't have the actual document though.
Need to, the screen's raw.
Oh, screens need to turn on, Your Honor.
Oh, I apologize. Mr. Reyes, you should have it now.
Thank you.
It's kind of hard to read, but can we enlarge that a little bit, Danny?
Yeah, I recall these vaguely, Judge, they're like almost illegible, they're hearsay.
Mr. Reyes, can you make it larger for me, please?
Yes, sir. Just the top third. That's good.
And what's down below what's highlighted?
That's the email that Beata sent. We can show the court.
If it, what's,
12/28/16.
Keep going down. That's good.
Is there a way to enlarge it any more and kind of center it so the court can see this a little better? And me?
I've read it now.
How long is it?
Is that it?
Is it just those 2 pages?
Oh, we'd like pages 3, 003, 008, and 013.
Okay, you've only shown me one page.
And show the court then.
008?
Yeah, 008.
Yeah, can you go to 8?
It's part of a thread.
They're all substantially similar.
And are all these just specific requests by Beata Kowalski for what is the diagnostic code? And then the response is whatever the response is?
Yes, Your Honor.
Yes, Judge. That's the relevance.
Ms. Krause?
It is. No objection.
So,
But it's just those 3 pages though, right?
Yes,
Can I have
Your
the
Honor.
numbers again, please?
Yes, sir.
To the last page?
It's 2438, 003, 008, and 013.
Can we see 013, Judge?
please.
Dan, can you put 013, please?
Same thing, if you can enlarge it, so.
Right. No objection, Judge.
Court receives without objection Exhibit 2438, pages 003, 008, and 013.
I mean, not right now.
Okay.
Anything else, Mr. Anderson, before I go to Ms. Crowell's, because she has an issue?
2017.
That's it.
Yeah,
It's in.
all right. No, Your Honor.
Ms. Crowell's.
Just a request, really. They've listed 3 depositions that they're playing tomorrow. One is Dr. Johnson, who I think is fine, but if they could get the edited versions to us tonight, as opposed to in the morning, it's very difficult to do it on the fly, to compare what they've done. So we need the edited versions tonight. They should be already edited.
I'm looking at Mr. Reyes. I don't know if this is your issue or someone else's issue.
I'm just having it emailed over this very moment. Oh,
The edited version?
the edited version. We are edited as to now
Becca Johnson.
Yeah, Rebecca Johnson, and I thought we had worked it out with Kathy Beatty,
And Dr. Napolitano is done, and then.
Dr.
Beatty,
Napolitano, and who else?
There's 3 issues with Beatty that need to be addressed. Aside from that, that's the only videos that have been edited.
How long would it take you to edit those?
I can do Beatty in 5 or 10 minutes.
During this witness.
As soon as we've gotten those, and we'll email them over, we're 5-10 minutes away from Beatty, but the remainder of them can be shown, and we'll send them over. We're sending
I
them
thought
over
Beatty
now.
was today. I think Ms. Quarles is talking about tomorrow's.
Right. He said, what I heard is they're done Napolitano
Yes.
and Perno.
I believe.
No, unless the reason, never mind. Tomorrow, we've got Dr. Cantu. assuming he
It
gets
seems like
in.
Mr. Reyes and the young lady, and ma'am, I don't know your name. I apologize.
Samantha Lawrence, LAW.
Miss Lawrence? Okay. That Mr. Lawrence and Mr. Reyes seem to know precisely where they are with this. So can you tell us where you are on the ones for tomorrow?
Rebecca Johnson, Dr. Napolitano, and that's for today. We're checking on Perno right now. But for sure, Johnson and Napolitano.
And are they for tomorrow?
Yes.
For tomorrow, they're complete.
And so the defense has received them?
Yes, and we've gone back and forth on Napolitano and Rebecca Johnson.
I'm now looking at the defense team, those who,
We don't recall receiving Napolitano unless it's come in while we've been in court.
I think
you-
it was last week.
it was
because
last
we had
week.
the
You
All right,
objected
we'll
to
double
it.
check. We silly could have missed it.
It was, yeah, there was one objection at the end that had to be removed. and
Okay.
The
All
edited
right.
version was sent over.
Thank you. We'll check on it.
Your Honor, we would prefer this afternoon, looks like we're only gonna get 1 depot plate, if any. We prefer that to be Catherine Beatty. There's 1 or 2 discrepancies as we've been going back and forth over lunch. Mr. Reyes is working on them. We've just asked that Mr. Reyes and whoever from their team step out so we can reconcile this during the next 2 hours of Mr. Kowalski's testimony, so we can start with Beatty after he's complete.
Judge, we've given him, there was one piece of testimony that should have been removed and was inadvertently overlooked that we objected to. And then there were 2 that they objected to, that we pointed out to them were inadvertently left in, and we've given that to him, so I don't know why we need to step out.
Well, I just want to make sure you view it and you get the okay before we play it after Mr. Kowalski. That's all.
I think
So long as we
we
remove
can
those, you're okay?
trust that you're
Okay.
going to remove those 3 things.
All right, we'll remove it and we'll proceed with Beatty.
so Mr. Reyes, did you get the 3 issues that Ms. Quarles was talking about?
Yes, I've got the 3 designations, but there seems to be.
Just remove them.
All right, just remove them.
I think there's a question because one of them starts in the middle of an answer, Judge. It was one where you sustained and overruled part.
There was a precatory phrase in one question. Is
No,
that the one?
came out.
That came out.
Judge. This was their objections to our designations, and you overruled part of it and sustained beginning on 108, and it's in the middle of a question, or answer. I think that's the question. Is that correct, sir?
Yes, there's a partial answer, and then, and when I saw our filing for the designations, they're saying that I need to remove or delete a page and line section when it's not shown as a sustained objection, so.
Okay, we got
can't
that
get
wrong,
that.
but,
Let me talk about it on the break.
yeah, we'll talk about it on a break.
So it does sound like BDs can be played today, if we get there. So let's try to get there. Mr. Kowalski, if you could come on up, let's bring in the jury. And Mr. Kowalski, I will ask you to remind you that you're under oath, but I'll do that in front of the jury.
Yes, sir.
And how long is the BD deposition?
At its current, it's 1 hour and 35 minutes, but it's 2 volumes, so one video will end. The other one.
Okay, everyone, please be seated. Members of the jury, I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And that you have not seen any media coverage of this while you were enjoying your scrumptious lunch. And that you have not been approached by anyone about this case. Is that correct? Okay. Mr. Kowalski, just wanted to remind you, you are still under oath, sir.
Yes.
Mr. Anderson, you may inquire.
May it please the court. Mr. Kowalski, we were on the topic generally of the health insurance. I'd like to show you what's been marked as Exhibit 2017. And for the record, that's the Aetna health insurance records. And we want to start there with page 699er. So that's 2017-699 trial exhibit. All right. Now, have you seen these before, generally?
Some of them, yes.
And best of your knowledge, the entire records and evidence you provided to us?
Yes.
Okay. Let's look at how we read these. Across the top, there's a claim ID. Do you see that?
Yes.
And the date received, what's the date there?
Date received, not the run date, correct?
Correct.
I'm sorry, 10/19/2016, 1/6.
All right. October 9th, 2016. So can you go down there past number of services 1 to charge submitted?
Yes.
Okay. Now let's go down to the diagnostic code. Do you see that?
The POA code?
Yes, right under the number 1 there.
Yes. You want me to say it?
Yes.
No, complex regional pain syndrome. Then an I, comma, unspecified.
All right. And to the left of that, there is a code. Can you read
Diagnosis code?
that? Yes, the diagnosis code.
G as in George, 90.5D as in David.
All right. I'll ask you to then take a look at trial exhibit 2017. Yes, 2017-663. You have it there?
Yes, I do.
And let's enlarge it a little bit so everybody can see. Okay. Now, first, what was the date of this? Date received?
Date received is that supposed to be 08, I would imagine, November 8th, 2016.
All right.
Almost
And-
looks like a D.
I see. And then under the charge submitted, how much?
Charge submitted, $10,679.
Amount paid then?
$5,005, is that 80.24?
All right. And then who submitted it there under provider name?
I
Provide.
object to the foundation in the reading of the record.
On this one, I'm going to rule it.
The provider name is Johns Hopkins All Children's Hospital.
All right. So if you go down there to the POA code, which is down about a third of the way, do you see it there?
Yes,
With
I do.
The diagnosis code. What is the diagnosis code?
Complex regional pain syndrome, and then that's the I other specified site.
Got it. Now, let's go to,
Mr. Anderson, I apologize. What was the exhibit number?
I think that,
2017 is it?
yeah, 2017,
And the page number, sir?
663.
Thank you.
All right, so let's then turn to 2017-726, if we could. Actually, no, I take that back. Let's just go directly to 729. And we're going to do the same thing again, if we could. Mr. Kowalski, once it comes up there, and we'll enlarge that as best we can. All right.
Received date?
Yes.
11/08/2016.
All right. And what was the charge submitted?
$50,071.
All right. And so who was submitting that?
Johns Hopkins All Children's Hospital.
And there's a lesser amount shown actually paid. Is that right?
Yes, $28,039.76.
Now, okay, let's continue on there. The diagnosis code again?
The first one would be complex regional pain syndrome, I of other specified site.
All right. Let's look then to 2017-738. And
Received date?
yep, received date.
December 6, 2016.
And who submitted it?
Johns Hopkins All Children's Hospital.
And charge submitted?
$10,005.
And what is the first diagnosis that they put on there for the purposes of billing this?
Complex regional pain syndrome.
Let's go to 2017-739. And it is about halfway down the page if you start there under date received. Not the top one.
December 6th, 2016, and I believe that's $90,810.
Okay.
$50,853.60 was paid, and that was submitted by Johns Hopkins All Children's Hospital.
And then what was the top code there?
Complex regional pain syndrome, one other specified site.
All right, well, let's go to 2017-741. All right.
Date received?
Yep, start in on it.
December 6th, 2018. Charge submitted, $18,480. Amount paid, $10,348.80. Provider, Johns Hopkins All Children's Hospital. First code is complex regional pain syndrome.
All right. So let's go to the next page, which is 2017-744.
744?
Yes, please. Now, if you go down there to the bottom of it.
Diagnosis code?
What I'm looking for here is the provider name and provider number there at the bottom right. You see that?
Yes.
And who was the provider here?
This is that one. I'm going to mess up on her name. Jennifer Kettenstein?
Right. And what kind of doctor was she?
I believe that was the psychiatrist.
Right.
I could be wrong.
Okay. And then charge submitted?
On the bottom?
Yep.
$255.
And
$108.28 was.
And what was the diagnosis?
Complex regional pain syndrome.
Let's go then to 2017-754. And so who was the provider there from Johns Hopkins? At the bottom right.
Yes, Richard Andrew Elliott.
Now, do you recognize that as one of the doctors that, again, was a psychologist or psychiatrist
Objection.
at Johns Hopkins?
Objection, Ms. Evans.
Overruled.
I think he was the anesthesiologist.
That was right. He was the anesthesiologist. And so how much did he charge?
$255.
All right. And so what are the two diagnoses there?
Well, you have chronic pain syndrome, pain unspecified, complex regional pain syndrome of the lower limb, bilateral,
Okay.
and then complex regional pain syndrome, unspecified.
All right. So then let's go to, and I'm almost done, 2017-767. And let's look at the date received.
Date received is January 5th, 2017.
I'm sorry, Mr. Anderson.
Yeah, it's 767.
Thank you, sir.
And the amount charged?
$78,702. Amount paid was $44,073.12.
And who was the submitting party there?
That was Johns Hopkins All Children's Hospital.
Looking down those lists, can you tell us whether complex regional pain syndrome was one of the
Yes.
codes?
Oh, I'm sorry. Yes.
Now, have you been through the records sufficiently so you can tell the jury whether, if they were to review all of these records, they would find?
Significant amount.
I object, lack of foundation.
Overruled.
There's significant amount of charges for complex regional pain syndrome.
So now, throughout these proceedings, did Johns Hopkins hold out to you and the public that Maya did not have CRPS?
Objection, mischaracterization of the evidence, lack of foundation.
Sustained.
Let me show you in evidence 24308. And specifically, this will be 003, 008, and 013.
Okay.
Okay.
Did you blow that up?
Okay. If we can start there
Okay.
at the bottom. Now, this is from your wife,
Yes.
and the date there is.
I believe it's 12/27/2016.
And what is she asking?
She's looking for the DX codes
DX means
for
that.
this, and is that Bill? It's hard to read.
Do you know whether DX is a medical abbreviation for diagnosis?
Object to the leading letter.
I'm unaware of what DX was. I'm sorry.
Overruled. The answer will stand.
All right. So
I'm sorry.
let's look at the top there. There is a response.
Yes.
All right. And what's the date of the response was sent?
12/28/2016.
Right. And going down, who is it addressed to?
It was billed by Jenny Dolan to the following DX codes, and the DX code below is complex regional pain syndrome, lower limb bilateral, and then also complex regional pain syndrome. I believe that's that I unspecified as well.
So who obtained the codes to allow you to decipher this?
This here would have been Beata.
And what was that effect when you found out that Aetna was charging back your health insurer for complex regional pain syndrome?
Objection, misstates the evidence.
Sustained.
Charging Aetna. What was your reaction when you saw that the number one diagnosis put down by Johns Hopkins was complex regional pain syndrome?
It was alarming to see that because we were told she did not have CRPS.
And through your entire stay there at Johns Hopkins, can you recall them ever coming in and saying anything to the effect of, well, we've confirmed now that she has CRPS, or did they maintain constantly that she was in her head?
Objection to them, primarily. Objection to the hearsay.
We're going to sustain on the first basis.
When, if ever, did any Johns Hopkins doctors come to you and explain or state that she really did have complex regional pain syndrome and it was not a mental issue?
They did not.
Through this period of time, to the best of your knowledge, did the doctors and nurses at Johns Hopkins All Children's Hospital continue to maintain to you that your daughter's problem was all in her head?
That was on the discharge papers that it was fictitious or conversion disorder.
Okay. Do we have that discharge notice up yet? We'll continue on. We'll come back to that. All right. In follow-up to some of the other questions, did anyone at Johns Hopkins ever explain to you why Sally Smith was in a lab coat and could gain, strike it. Did anyone from Johns Hopkins ever discuss with you Sally Smith, Dr. Sally Smith, having access to Maya's medical records on October 8th?
Yeah, objection. Yeah, we need to approach on this one.
You may continue, Mr. Anderson.
Your Honor. You need me to restate?
I know part of it.
Did you ever give Sally Smith, Dr. Sally Smith, any permission to access your child's medical records on October 8th, 2016?
Just to preserve objection on the same basis.
Overruled. No.
Did you ever give Dr. Sally Smith permission to enter your child's room unsupervised?
No.
Do you have that discharge notice yet?
Yeah, it's 100.
Need that. Okay. This is the Johns Hopkins records 1002-0002. We can bring that up. Just the one sign.
It's not that, but you pull one.
Which one?
One. There's one before it. I don't have it.
But it's on the screen. All right, let's go to the page before that, which would be 0001. It's not in the book. All right, we can enlarge this. Have you seen this before? Discharge summary?
Yes, I have.
All right. And so what's the date here?
That would be Friday, January 13th, 2017.
Now, how many days after your wife's death is this?
5 days.
Was one of the theories that your wife was controlling Maya somehow to induce her to fake her symptoms?
Objection, again, mischaracterizes the evidence, also vague as to who.
Sustained.
Was there a claim by the hospital, to the best of your knowledge, of Munchausen by proxy involving your wife?
Yes.
And are you familiar with the term Munchausen by proxy?
Yes.
And does it include, best of your knowledge, a claim of manipulation by a parent over a child?
Yes.
And in this instance, was it directed at your wife, Beata Kowalski?
Yes.
And so, how many days had your wife been, I'm sorry about the term, out of the picture as of January 13th, 2017?
Oh, from January 7th, you said? Or 8th? I'm sorry.
Eighth.
About approximately 5 days.
And so 5 days after is when you got your daughter back?
Yes.
Now, did you receive recommendations from Johns Hopkins about what they suggested should be done with Maya around this time?
But my understanding was they didn't want to release her to me. They wanted her to go somewhere else.
Do you know where they wanted?
I apologize, Mr. Harrison. Again, objection, and I believe this is starting to invade issues.
What issues?
Why don't you come forward? I'm going to sustain the objection.
Let's go down to the bottom of 001. I'm sorry. Yes. So you see the admission diagnosis there?
Yes.
And what does it say the admission diagnosis was?
Fictitious disorder and conversion disorder.
And then over to the right?
over to the right where, I'm
Right,
sorry.
okay, take back.
Oh,
this-
I'm sorry, Munchausen syndrome by proxy.
Right, so this is upon admission back when?
That was January 13th, 2017.
That says for the discharge, right?
Yes.
But the admission diagnosis.
Oh, the admission?
Mhm. She was admitted when?
She was admitted October 7th.
So upon admission, October 7th, do you see anywhere that Munchausen, that a complex regional pain disorder was put down as a diagnosis?
Your Honor, it misstates the record. This is referring to the second admission.
This is a speaking objection again, and I'm just asking what's on a piece of paper.
He's
Are
asking
you,
Yes.
I'm going to sustain the objection.
Right. And so on the discharge diagnosis, what does it say that the discharge diagnosis was?
Where it's in, or it's highlighted?
Yes.
Discharge diagnosis, fictitious disorder, Munchausen syndrome by proxy, conversion disorder.
And is it the same as the admission diagnosis?
Yes.
And down there, do you see a secondary diagnosis?
Atopic dermatitis.
Do you know whether when Johns Hopkins did refer to your child's lesions, that was the way it was stated?
No.
I got it. Yeah. Well, this is. I got to find the page number. See. The 8th page of that exhibit, and that being the discharge summary at 1001. So that would be the 8th page. And it's JHACH 8511 on the bottom. We've got that. All right. So I turn your attention to the documented medications.
Yes.
And is this Aquaphor, was that one of the topical lotions used to treat Maya's lesions?
We did not have that, I believe, in the past. That's what they discharged her with from Johns Hopkins.
All right. And acetaminophen was essentially Tylenol?
I believe so.
But let's go down to prescriptions now. I want you to count, upon discharge from Johns Hopkins, how many medications they had your daughter on.
1, 2. More than 3. I'm sorry. There's, I believe, more than 12 here. I didn't count all of them, but.
And that would be my question, is the amount that they list here as what they're discharging your daughter to take, more than 3.
That is correct.
And then look on the next page, 8512. Did they want a follow-up with Rebecca Johnson? I'm sorry, it's 008512.
Okay, I see it. Yeah. Follow up with Rebecca Johnson, yes.
And who is Rebecca Johnson?
Rebecca Johnson, she worked for Eagles Wings at the time. She's now down in Cape Coral.
And was Rebecca Johnson one of the 2 therapists that you and your family went to find some comfort from the psychological issues of this CRPS?
That is correct. And we ended up going down to Cape Coral to see her as well.
And then down to Agility Fitness, and we've heard from them.
That is correct.
And then Dr. John Wassenauer, the pediatrician.
Correct.
Okay. I want you to describe for the jury, when you finally did get Maya out of the hospital, what was her condition?
Number one, I had to pick her up alone. I wasn't able to bring my attorney with me, so I brought another person to help me. Maya was extremely weak. We put her in the back seat of the vehicle. We used all the stuffed animals she had from the hospital to help prop her up. She was very weak. Kind of remind me of a weeble. You know, she was wobbling. If we made a turn or something, she would fall over. She didn't have the strength.
Was she in better or worse condition than when she checked in?
She was in worse condition, but you should have seen the smile on her face when we were driving over the Skyway Bridge.
A lot of relief from
Yes.
getting out of there. And was her condition to the point where you were worried whether she would survive much longer in Johns Hopkins?
Yes, I was worried.
And before she passed on, was that a concern of your wife, Beata, as well?
That is correct.
Now, since your wife died, since you took Maya out of the hospital, has she continued to exhibit symptoms of CRPS?
Yes,
On more than one occasion?
more than many occasions.
Does she have big relapses and small relapses?
Big and small, yes.
Describe the difference.
Some she'll lay in bed, she'll cry, or she, like today, she's stating her limbs are hurting, but she tolerates pain, you know, and she tries to keep going. She had one in November of 2020, I could be wrong, where she had to be hospitalized. She lost a lot of weight, and she looked very, very, very ill. She was within the hospital for a week. She had to have a feeding tube.
Does she worry sometimes about telling you how she's doing?
Yes, absolutely.
And why is that?
She don't want me to worry because, unfortunately, we cannot get that treatment to where we have an order not to.
Objection.
Sorry.
Straight mischaracterization of evidence. Yeah, and we probably do need to approach on this.
There.
Sorry.
Leaving aside that, did you have concerns of what would happen if Maya or you reported to a physician that you were using ketamine with another physician, say, to help her?
Yes.
And why is that?
number one, her new diagnosis, conversion disorder, fictitious disorder, and also just from the previous experience.
Did you have any concern that if it appeared in her records again, you would go through this again?
Yes.
Was that the main reason then that you held off taking her back for that?
Yes.
So did Maya have to simply rely on physical therapy?
Grin and bear it, yes. Physical therapy.
And tell the jury how hard she worked at that.
Maya was determined. I'm sure you heard from the physical therapist. She's not one to give up. She inherited that from her mother with many things. She was determined. She would do a lot of swimming. She was with Kyle. That she had a partner to make it more fun. And she was determined to get out of that wheelchair, get on crutches, and then eventually crutches to walking. And I'll never forget that day as well. Wonderful.
As we sit here today, does your daughter have CRPS lesions on her legs or ankles?
Yes, she does.
And tell the jury, throughout the time that you were with Beata, did she ever exhibit any mental health problems other than anxiety over the effect of CRPS and then later the Johns Hopkins issues?
No.
One moment, Your Honor. Subject to recall on damages, your witness.
Yes. Good afternoon, sir.
Good afternoon.
I know you've been up there a while, but I'm going to take you back a little bit. So,
No, my new spot.
yeah. Going back to July 3rd, 2015, just so this jury's clear, there was never a physical injury that started Maya's ordeal that put her in the wheelchair, correct?
Not on that date. Like I stated earlier, there was an injury when she was in gymnastics, but we cannot pinpoint it on that.
The jury saw the video of Maya riding her bike on July 3rd in the parade. It's your testimony that that night she had some type of a panic attack over something and immediately experienced global pain. Is that true?
Not true. She didn't have a panic attack. She had an asthma attack.
Okay. So,
And she had some previous to that.
So in terms of what happened that day, once Maya had an asthma attack, she immediately had pain everywhere, not just confined to one limb, correct?
Not right away. She had difficulty breathing and then chest pain, I believe it was, in that record. I could be wrong.
Before you brought her to All Children's Hospital, you applied for Social Security disability for Maya, true?
Objection. Yeah, that's not specific.
Okay, so I'll clarify.
Approach, please.
To clarify the question, sir, after the July 3rd, 2015 incident, but before you brought Maya to All Children's on October 7th, 2016, you had applied for Social Security disability for her, true?
That's a better question, yes.
Okay. Let me talk to you a little bit more about her treatment and try to get the time frame right. You had said that, if I get the sequence of facts right here, that you went to First Sarasota Memorial Hospital after the July 3rd incident, correct?
I believe that's correct.
And then you went to All Children's Hospital, and I think you were telling the jury people threw up their hands and didn't know what was wrong with her, and this was back in July of 2015, correct?
There was a doctor's hospital prior to that.
Okay.
And she was transported.
Right. So the sequence of events, the July 3rd, 2015 incident, doctor's hospital in Sarasota, and because they're not a pediatric hospital, they sent her up to All Children's in July of 2015, correct?
Correct.
Okay. At that July 2015 admission, do you remember what the discharge summary said in terms of Maya's condition and what they were recommending?
No, I don't.
Okay. I'd like to show you what's in evidence joint exhibit 1008-0004. Okay, and on the last paragraph where it starts, the patient was seen. Do you remember, sir, on the second sentence, and this is from the first hospitalization where you said people threw up their hands in the air and said, we don't know what to do. In fact, that you had declined, or Beata had declined, a neurological and psychological examination back in July of 2015. Do you remember that?
No, I don't.
Do you remember in the next sentence that you had requested transfer to an outside hospital? That would be the Lurie's in Chicago. Is that true?
That is true, after she put her arms up in the air.
Well, do you remember that either you or Beata were adamant that there would need to be a PIC line, an IV line put in for the transfer?
I'm unaware of that.
Okay. Do you remember All Children's Hospital telling you that that PIC line would be inappropriate as both an infection and respiratory risk, and it was dangerous? Do you remember that?
Didn't you put one in?
In July of 2015, before you boarded a commercial airline to Chicago to go to Lurie's, do you recall asking for a PIC line then?
I do not.
Okay. Let me ask you about the records up in...
We're reading reports, hospital records now?
I'll ask you about the next one, sir.
Okay.
I actually won't show you this one because it's not in evidence, but let me see if I can understand your testimony. You did not go to Chicago to Lurie's from here, did you?
Beata did. I did not.
Okay. Were you aware when Maya and Beata returned that in Chicago that the discharge summary raised a concern for a psychiatric component to Maya's presentation?
Facts not in evidence. Lurie records are not in evidence.
Overruled. You can answer.
Am I aware of it? No.
Okay. Beata did not tell you when she returned from Chicago that Lurie's Children's Hospital back in July of 2015 raised the concern for a psychiatric component?
Not that I'm aware of.
Did Beata tell you that Lurie's recommended a therapeutic program that combined physical and psychological therapy?
We did that. That was Tampa General.
Okay. Let me ask you about the Tampa General. You were at that admission, correct?
Yes.
Okay.
One of them.
So I'll talk to you specifically about coming from Lurie's. Then you went to Tampa General from July 2015 until August 2015. Is that correct?
Somewhere in that area, yes.
You were aware then that at Tampa General on discharge, one of the discharge diagnoses from Tampa General was psychological factor affecting physical condition.
And that's when Beata received that call from the nurse practitioner, Bonnie Rice, and that's when she was upset about that.
Okay. And so just, we've asked about what you were aware of and what Beata was aware of. Is what you're telling me that you were both aware that when you left Tampa General, that Tampa General back in August of 2015 diagnosed psychological factors affecting Maya's physical condition?
I was not aware until I heard Beata tell me from that phone call with Bonnie Rice.
Were you aware in August, specifically August 27th, 2015, that Tampa General's recommendation was for intensive physical and cognitive therapy following discharge?
At Tampa General?
Correct. When you
I'm unaware of what I know she got the PT, but I don't know if she received anything.
Let me ask it this way, Mr. Kowalski. Is what you're telling me in terms of the specifics of what Maya's diagnosis was and the recommendations from Tampa General something that Beata would know and not you?
Beata knows a lot more than I do.
Okay.
You ask a lot of fathers, I'm sure they don't even know where their kid's pediatrician is.
Well, within a month of leaving Tampa General within those recommendations, you had established with Dr. Kirkpatrick in September, correct?
In September, yes.
Okay. And so while Tampa General recommended rehabilitation with cognitive and physical therapy, and incidentally, they did not recommend ketamine, did they?
Who's that, Tampa General? She didn't get better in Tampa General, just the upper body.
Tampa General did not recommend to you when you left Tampa General that you start ketamine, did they?
No.
And yet a month later, despite their recommendations, respectfully, you were at Dr. Kirkpatrick's office getting treatment for ketamine, true?
We went to Dr. Kirkpatrick, after that, but we still did physical therapy on that, and she went to Eagle Swings.
Okay. You agree, do you not, that there is a psychological component to Maya's condition?
If anybody has any type of injury, there's some sort of psychological effect.
You have heard many times, and you've personally seen, that when Maya's with you, she's completely normal, and that when Beata walked in the room, she's in pain.
That's false. There's times she did it for me as well. That's false.
I need to approach on this issue, Your Honor.
Okay, you may continue, Mr. Shapiro.
Thank you. With the court's permission, I'd like to play clip 6 from an interview that Mr. Kowalski gave with Detective Graham.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she acted completely normal. When Mom would walk in the room, she was instantly in pain.
I heard that many times.
There's no other explanation
Well,
for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work.
And all of a sudden she's bad.
There'll be changes, yes.
So you're at home, your guys are doing well, playing.
No complaints about pain.
No complaints about
pain.
pain.
But then when Mom gets home,
She's in
maybe,
pain.
Mr. Kowalski, do you recall that interview was with Detective Graham on November 17th, 2016?
I do.
Okay. And everything you said to Detective Graham that day was true, correct?
That is true. And then after reviewing medical records in your hospital notes, it states that she did the same thing for me.
In terms of the timeline, did you go to Mexico when Maya was being put into the coma?
We addressed that earlier. I went to my oldest daughter's wedding, and then from there I took my son back to Florida, and then I proceeded back to Mexico.
Were you aware that the risk of death from that coma was 50%?
There's a risk in every procedure.
Well, I understand that, Mr. Kowalski, but respectfully, there's a risk, and then there's a risk that's a coin flip whether your daughter would unfortunately pass. Did you know that the risk of death in Mexico was 50%?
They stated there was a 50% risk, but they also told us nobody ever died from that procedure.
Are you aware of what complications Maya suffered while she was under her coma in Mexico?
We were informed.
Okay. Your wife blogged about those, did she not?
She had a blog.
Okay. And part of her blog was, you've seen the blogs, true?
No, I have not.
Okay. You're aware that your wife was blogging about Maya's care while Maya was in the coma. Is that true?
Yes.
Okay.
I don't know if you ever had a sick person in your family, everybody calling you, and you're repeating the same story over and over. This was a way of communicating to everybody at once.
After you got back from Mexico, you or Beata took Maya to a Dr. Elvin Mendez. Do you recall that?
I do not recall that, but that name does sound really familiar.
Okay. Are you aware?
Objections, not in evidence.
I'm not publishing it.
Well, you can continue.
Are you aware that Dr. Mendez on December 10th, 2015, noted in his record that consideration may be given to possible Munchausen's by proxy?
I heard of that after time.
Okay. My question to you is, did Beata tell you that Dr. Mendez wrote in his record as of December 10th, 2015, that consideration must be given to possible Munchausen by proxy? Were you aware of it then?
Not at that time, it was later on.
Okay. You were, your wife kept notes of Maya's treatment?
She did.
And you were kind enough to turn over. Would you be able to identify her handwriting, Beatas?
I hope so.
Okay. This is not in evidence, but I'm going to ask, I can hand Mr. Kowalski a copy, or we can put it on the screen, whichever you prefer.
Well, if you've got the paper copies, let's use that, but make sure Mr. Anderson sees what you're going to show him first.
We need to approach the court's prior has already ruled on this.
You may proceed, Mr. Shapiro.
May I approach, Your Honor?
You may.
The record will reflect that I've handed Mr. Kowalski what we previously marked as Defense Exhibit 3239-0080. Mr. Kowalski, I'll represent to you as well. This was produced by you to my office in response to a request on September 16th, 2019. My question to you is, do you see in the top right corner some handwriting on this document?
You mean top left?
I apologize, sir. Yes, top left.
Yes, I do.
And is that your wife's handwriting?
It appears to be.
Are you able to read what she wrote?
Looks like Sunday, Monday. Yeah, I could read some of it.
And let me ask you if this is what it says. Sunday, 10/2, Maya hurt her foot in BRP. Is that right?
BRP? Yes.
Okay. And then it says Monday, 10/3, Ket IV, 0 availability in office, or it says 0 availability in office, Ket IV out of desperation. Is that what it says?
That's what it. What was that? Oh, unbearable. Okay, yes.
And it says Ket IV out of desperation, pain was unbearable. Is that right?
Yes.
Okay. I can leave the document with him, or I can take it back at your preference, Your Honor. Those are the only questions on this. You don't recall whether Maya had any skin lesions when she left Tampa General, do you?
No, I don't.
And you don't recall whether she had any skin lesions when she presented to Dr. Kirkpatrick, do you?
That I do not know. That would be in his medical records.
Okay. Maya had not walked from the time of her incident on July 3rd, 2015, until after her discharge from All Children's Hospital in, I think it was August of 2017. Is that right? Sorry. Let me.
Objection.
Yeah, it was a confusing question, so let me just rephrase it. From the time of Maya's incident on July 3rd, 2015, through when you brought her to All Children's Hospital on October 7th, 2016, she had not walked in that period of time. Is that true?
Objection. Misstates the timetable.
I believe she may have walked when she came home. She was weak. She was carried in. She walked a day or so, and then after that, no.
Okay. I wanted to talk to you a little bit about what you described as a relapse in August of 2016. Okay. And this was about the homebound school
Correct.
program. I just want to make sure I understand what you told the jury yesterday. Maya was asked to come to school for an evaluation in 2016. Is that right?
No, that's wrong.
You brought her to school in August 2016?
Yes.
And after being there, Taylor Ranch School said that she had to come back in full-time and canceled homebound. Is that right?
Real quick, there was a fundraiser for the lemonade stand. So she went to that. She was sitting in the library. The person in charge of the homebound seen her in there with the kids. And after that, she was denied homebound.
Okay. After someone from the school observed her at the school at the lemonade stand, they then denied Maya's continued homebound. Is that right?
That is correct. And then we had to hire Jane Wisner.
Okay. You hired a lawyer to appeal that decision. And the jury's already seen the letters from Dr. Wassenauer, and there may be one from Dr. Hanna they'll see as well. But the point being, Mr. Kowalski, there was no physical injury at that time, was there?
Object to the long predicates in these questions.
I'll re-ask the question. When Maya had her relapse in August of 2016, there was no physical injury at that time. Is that true?
No physical. It was caused from stress.
Let me talk to you a little bit about the decision to go to All Children's. You were already up in Tampa on October 6th getting an infusion with Dr. Hannah, correct?
No, Clearwater.
I apologize. You were staying at the Ronald McDonald House attached to All Children's Hospital, correct?
That is correct.
You were already up in St. Pete, Clearwater, getting treatments with Dr. Hannah on October 6th.
Yes, she was with Beata, and I relieved Beata.
The plan was, had she not been admitted to All Children's, she was scheduled for another infusion with Dr. Hannah on October 7th, correct?
That is correct.
You didn't come up here because of a hurricane, did you?
No, she was getting treatment.
Okay. Just if there was any argument earlier in this tribunal or elsewhere that the reason why you were up or brought Maya up to this area from a hurricane or fear of a hurricane, that's not true. It was solely because she was already here getting treatment with Dr. Hannah, correct?
We were here.
Okay.
Or in St. Pete, I should say. In St. Pete. We were here in St. Pete.
Dr. Hannah referred you to All Children's Hospital, correct?
No. I was with Maya, and she was in severe pain. I decided to take her there. I knew she had a treatment the following day, but I knew her pain. And you were the closest facility, and that's what I chose.
When you arrived at All Children's Hospital, were you the parent that signed consent for All Children's?
I was the parent that brought her in.
Did you ever, in writing, revoke consent for treatment?
I didn't know I had that opportunity.
Let me ask you about some of the statements or records upon arrival at All Children's. This is Joint Exhibit 1001-18. And as a predicate, sir, were both you and Beata at the hospital at this point?
Beata arrived approximately an hour later. That sounds about right. It takes about an hour from Venice to get to St. Pete. 9:45, I believe she was there.
Okay. So by 9:50, the first note, it says an ultrasound was canceled because mother insists she will not tolerate it unless she has, meaning Maya, 1,500 milligrams of ketamine, which I am unable to give in the ED. Were you there when that discussion went on?
I was there, but I believe that's incorrect. She was in severe pain. She had her knees up to her chest. That's why the ultrasound was refused at that time. I didn't understand how you're going to take an ultrasound when she's that much in pain.
Beata was asking for 1,500 milligrams of ketamine, true?
She asked for ketamine. I cannot say true on the amount that you have here.
Okay.
She did ask for ketamine.
And
you did give.
Let me ask you about Joint Exhibit 1001-3118. But before we go there, do you know the dose of ketamine that All Children's gave?
Of All Children's?
Correct.
No, I do not.
Okay. Do you know whether it was dramatically less than what Dr. Hannah had given the day before?
That I'm not a doctor, and I don't know everybody's procedures.
Joint Exhibit 1001-3118. Do you recall at the top, this is also on the day of admission, that mom, meaning Beata, insisted that patient, being Maya, was in severe pain and needs to have more propofol. Were you there for that conversation?
I was there, but I don't recall. I know she asked for the ketamine.
You do know that propofol is a general anesthetic, do you not?
I do not know that.
Okay. Let me ask you about Joint Exhibit 1001-0081. Let me ask you, this is also on the day of admission. Let me ask you if you recall this event. In the middle of the paragraph, the language that starts with, I was speaking to mother. I wanted to ask you about the second sentence. She, which would be Maya, had been attempting to take off all of her monitors. I, being Dr.
Objection to reading medical records. Sauce for the goose.
Sure. I'll have you read the highlighted portion, and my question to you, sir, will be this sentence and the next one, if you could highlight it as well, all the way through the word staff. My question to you, sir, is, were you there for this event?
I was there, but you have to, I think there's a big key missing out of this, and it was the blood pressure cuff. The blood pressure cuff was a big issue and causing pain. That she did get agitated, yes, you're right, but there was a component that caused that thrashing.
Okay. Let me ask you about Joint Exhibit 1001-3117, and I'll represent to you this is on the next day, October 8th. Were you there at All Children's Hospital?
Does it say if I was or not? Undetermined if I was there or not.
Okay, and that's part of the reason I'm asking these questions. If you were a witness to some of this treatment, if you knew whether you were there at All Children's on October 8th or not, do you know? I do not know. Okay. Do you have any knowledge of the bottom quote where it says 10/8/2016 about mom insisting the propofol not working? Any knowledge of this event?
I do not have knowledge on that. Sorry.
Okay. And again, well, let me ask you about the next exhibit. This would be earlier in the day on October 8th. Joint Exhibit 1001-2721. And it's the second result specifically I wanted to ask you about because it was in the middle of the day. And you had mentioned earlier that Maya refused to have her blood pressure taken. That's true, correct?
Yes, that's true.
Okay. Do you remember Maya telling the staff, quote, "I'll do it if you sedate me"?
Do you realize the pain of CRPS? This little girl knows her pain. She knows what she could tolerate. She needs something for her pain to get a blood pressure. It sounds so goofy to us, but for her, she's in extreme pain and she needs something for that pain before she could tolerate a blood pressure cuff.
But is this a true statement?
If I said that, I'd be speculating, right? I mean...
Let me ask you about Joint Exhibit 1001-639. And I'll represent to you that this is an anesthesiology note taken on 10/8/2016 under the part anesthesiology note, and I'll ask you to read the part where it starts the second under additional comments. Family has insisted upon intubation with medically induced coma.
Okay.
Okay. Do you remember? It says, which I stated to the father, is not an option because we have Maya.
Objection, reading.
All right, I'll stop. I'll let you read this, Mr. Kowalski.
I want to stop you there for a second. We told the story of Maya's history in the triage and in the emergency room. I don't know where they came up with medical-induced coma. We knew we could not get a medical-induced coma in the United States. We're fully aware of that. So wherever this came from, I don't know. That is incorrect in your records there.
Okay. So in terms of what they've documented here upon your request on that day for a medically induced coma, you dispute it?
I don't agree with that.
Let me ask you about what's in the record at 1001-2711. And in the middle of the page, this is now on October 12th. Were you aware of these statements from Maya that she wanted to go to heaven?
She was in extreme pain. You ask any CRPS person in extreme pain, a lot of them, as we told you before, this is a suicide disease. A lot of them want to go. They cannot tolerate the pain.
Well, I'll ask you about that in a moment, but the next line says, Mom also states, I don't care how much medicine or side effects. I want her comfortable and out of pain. Is that something you believe your wife would have said?
I cannot answer for that.
Okay. Let me ask you about Joint Exhibit 1001-2719. It's the text result in the middle of the page, text 8851, other during CT scan. If you'll take a moment to read that, sir.
I cannot answer for that.
Okay. You can't tell the jury whether or not this is true, whether Beata had told Maya she would get a reward of Valium if she laid still for a CT scan.
Objection, Your Honor. This is triple hearsay, and we've objected to this before.
What was your question?
Can you tell the jury one way or the other whether Beata was using Valium as a reward for Maya?
Yeah, at home?
At asking for this at the hospital.
Oh, at the hospital? I wasn't there. I cannot answer for that. But at home, absolutely not.
Okay. Lower down the page, T892, it says there was a family meeting. I'll let you read it. It says in family meeting, mother stated. I'll let you read it. Let me know when you're done, sir.
I read it.
Do you recall being part of a family meeting where this was stated?
I don't remember this being stated, but yes, I was in a family meeting. You are correct on that. Consult hospice. We were very concerned of losing our daughter.
Mm-hmm. Do you remember the request for consultation for hospice?
I don't recall that. I'm sorry.
Okay.
And I'm not, when you're in that situation, you're very, very overwhelmed. So much going on. I do not recall a lot of that, and I apologize.
Let me ask you next about, we talked a little bit earlier about consent, or what you've told this jury is your lack of consent to stay at All Children's. Okay, so I want to frame for you the time period so it's clear for this jury. You brought Maya to All Children's on the morning of October 7th, 2016, correct?
Yes.
You're aware that by 2:30 in the morning on October 13th, 2016, so a little less than a week later, the state of Florida took custody of Maya, correct?
I wasn't aware at 2:30 in the morning. It was later on the 13th.
I apologize. In fairness to you, you probably found out later that day.
Yes, unfortunately in a bad way.
Okay. The claim that you're making for this jury for false imprisonment, you understand, is from between October 7th and October 13th.
I do now.
Okay. Let me ask you about Joint Exhibit 100154. Okay. Actually, let me instead ask you about 1001-630. I'll represent to you, this is a pain management note by a doctor named Dr. Jenny Dolan, and this is on October 9th, so the third day that you're there, and I'm going to ask you to read at the bottom, not the bottom, but about halfway down where it says, today, Dr. Dolan, Dr. Tepa Sanchez, and specifically the last part where it says, today is day 3 of ketamine and Precedex infusion, and all the way through the end. And let me know when you've finished reading it, sir.
Got it.
This record reflects that you and Beata agreed with this plan of care, true?
We had no choice.
Sir, you agreed with the plan of care being offered by the hospital, true?
We had two choices.
Well, let me ask you about the next record, sir. This is Joint Exhibit 1001-620. Actually, let me ask you about 1001-620, yes. This is a pain management note now on October 11th, 2 days before DCF took custody.
Okay.
Do you remember? And I'm going to ask you about the part where it says anesthesiology note. Take a moment to read it, please, sir.
Okay.
The note is accurate. You would agree that you had a chance to discuss the plan of care with Dr. Elliott from the pain management team. Your questions were answered and you understood and verbalized this plan of care, true?
I do remember talking to Dr. Elliott, but I don't recall what was discussed at that time. So I cannot say yes or no on that. I'm sorry.
You're not disputing what this note says, are you?
And I'm not saying that it's true.
Okay. Well, let me ask you about Joint Exhibit 1001-2026. And just the first sentence at the top, where it says actions taken.
Mm-hmm.
You can go ahead and read the first sentence. And I'll, for frame of reference, I'll represent to you, this is October 11th.
Okay.
And if you want to highlight it, Clay, SW contacted by medical team. Parents have agreed to stay. That's true as of that date, is it not, sir?
At that time.
Okay. Let me ask you about Joint Exhibit 1001/76.
What about the concern that mother was going to change her mind?
Right. Let's talk about that.
Let's do it.
On October 11th, 2016, you and Mrs. Kowalski at that moment agreed to stay at All Children's.
We had no choice.
Sir, there's nowhere in this record anywhere that says the parents are asking to go home.
Isn't that funny?
You noted in the record, you're not disputing that you told the medical team at All Children's that you were agreeing to stay. The concern was that Beata might change her mind, but you were agreeing to stay as of October 11th, true?
Remember that meeting we had? We were told if we left, we'd be arrested.
Let's talk about that. I'm going to show you what's in evidence as Trial Exhibit 2408-1739. Uh, 2408-1739. Do you have that? Let's go to 1738 first, just so we can lay the predicate. This is an email that Beata, your wife, wrote to herself and copied you on October 12th, 2016 at 9:27 p.m. Do you see that?
Yes.
Okay, and just for verification, at the top, that is her email address, correct?
Yes, it is.
On the second page, let's go to 2408-1739.
Is this in evidence?
You moved it in, I thought they moved it in today.
Is this in evidence?
You put it in evidence this morning, sir.
Which one?
That's a double page.
Let me see.
The clerk says this one's in evidence.
Is or is not?
I'm sorry?
Is.
Is.
Okay, Clay, you can put it back up, 2408-1739.
Okay.
Let's talk about halfway down the page. It says Tuesday, 10/11, late afternoon. The same woman from CPS. Incidentally, that's Sally Smith, correct?
I do not know.
Okay. Well, let me ask you about this. She received a complaint that we wanted to take Maya AMA, that's against medical advice, and take her home. That's a lie. That's what Beata wrote. True?
Not at first. She wanted to go to Nemours.
Sir.
Or she wanted to go to Dr. Hannah for treatment.
On Tuesday, October 11th, 2 days before the state took custody of your daughter, your wife sent you an email and copied herself that specifically said that she was disclaiming, she was disputing the allegation that you and her wanted to take Maya out of the hospital.
And to take her home. She wasn't going to take her home.
She was not, she agreed to stay at All Children's Hospital as of October 11th. She was disputing the allegation in an email to you that she was trying to leave against medical advice. That's what this says, does it not?
That's your interpretation.
Okay. Let me ask you about Joint Exhibit 1001-73. This is the next day on October 12th.
Okay.
Under the interim history at the top, I'm going to ask you to read where it says they reviewed all of the patient's medical records to the, that's fine, you can leave it there, but what I'm focusing you on is halfway down where it says they reviewed until the end of the paragraph.
Who is they, first of all? I'm sorry.
They is you. Okay. At the end it says, this was discussed with the mother who's in agreement with the plan.
Objection, again, reading the record.
This, let me, I'll back up. It says, this was discussed with the mother. The mother agreed to proceed and the patient will require go lightly clean out. At the end it says, this was discussed with the mother who is in agreement with the plan of care. Isn't that true?
Yes and no. We were told if we left, we would be arrested. So we had to follow your guide.
You can't tell this jury who told you were going to get arrested, true?
No, it was in the meeting, and it was somebody within that meeting, one of your staff,
After All Children's, well, let me ask you this. You were asked some questions about visitation. After Maya had was taken into custody by the state of Florida, you understood, sir, visitation at All Children's could only happen pursuant to DCF approval. True?
It had to be supervised, is what we were told.
On October 16th, 2016, you specifically responded to a request to DCF where they asked you, who do you want on your approved visitor list? True?
There was a list for supervisors, and then there was nothing in reference to like the priest and things like that. No.
I'll ask you about the priest in a moment. But do you recall, sir, that on October 16, 2016, you wrote a letter to the child protective investigator with the state of Florida? Her name was Lindsay Massacre.
Yes, I do remember that. Social security numbers on there?
Yes.
Yes.
Because DCF required all visitors to go into All Children's Hospital to undergo a background check, correct?
Correct.
And they asked you, can you please provide us, meaning DCF, with a list of people that you would like to visit Maya?
Yes.
And then DCF was going to run background checks, correct?
That's what they were supposed to do. And then my brother, Bob Reines, he called. And they said the hospital will not allow him because he's a family member. The hospital will not allow it.
But you don't know, as you sit here today, whether that denial was because DCF had not approved him versus All Children's not getting word from DCF whether he'd been approved, do you?
This is hearsay, but he could contest to it.
Okay.
He has a letter, and he also spoke with her, and they said the hospital is controlling this, and they should not be doing it.
All of those decisions on who could come and go at the hospital after October 13th, to your understanding, was under the jurisdiction of DCF approval, true?
I just told you it wasn't.
Well, let me ask you about, and just, this is not in evidence yet, but I would ask Clay if you can show him only.
Well, no.
Sorry. Well, let me ask you a question first. Let me lay the predicate. Do you remember that on October 27th, 2016, you wrote a letter complaining about the church people coming to Maya's room who gained access to her room without your approval?
Not without my approval. What happened is, I believe it was Tori Nellis. She stated that there was some visitors, not only the church people, but there was somebody else that came in and gave a gift to my child, and then also the young lady that runs the Ronald McDonald House. She said, if these people come in anymore, I'm going to lose my visitation privileges. I was highly concerned, and I did not know about the church people. I had nothing to do with that. So yes, I did write a letter to my lawyer, Deborah Salisbury.
Because you were working with Tony Niehaus, was with who?
Tori.
Tori was with who, sir?
One of the third party, whatever, Safe Coalition or whatever, I don't know.
With the DCF Safe Coalition group, true?
Somebody like that.
And your complaint was that you didn't understand how they were able to access Maya's room without your permission, true?
I was concerned not only for them, but the other people that went in there as well. I did not want to lose my privileges.
You didn't authorize them to come to Maya's room either, did you, sir?
I don't have that authority.
Let me ask you about, you were asked by your counsel about some transfer diagnoses, okay?
Yes.
You're not denying to this jury that as of November, after Maya was sheltered by order of the state, in early November, you and your wife had the opportunity to consent for Maya being transferred out of All Children's Hospital, but you and Beata refused.
That is correct.
Let me ask you about one of the other documents on that issue as well. Well, let me...
And that wasn't you and Beata. Beata refused. I remember that.
Okay. But just so this is clear, in November, Maya could have left All Children's if Beata had said yes.
She could have, but we weren't going to do it under that diagnosis.
The diagnosis code that had already been made at Lurie Children's, Tampa General, and at Dr. Menda's office, true?
Objection. Those are facts, not evidence. Misstates the evidence, and if we're going to have him comment on...
Sustained. And Mr. Shapiro, the jury's been seated for over an hour and 30 minutes.
Now's a good time for a break, sir.
Now's a good time. Now, members of the jury, this is going to be your last break of the day, hopefully. Let's try to keep this to 10 minutes. Let's do not discuss this case amongst yourselves. Do not do any investigation. Receive no information.
All rise. Jurors exit.
Jury is out of our presence. Let's talk scheduling for just a moment.
Well, I have a motion, Your Honor.
Let's talk. What's your motion?
Judge, we objected and we're moving for a curative instruction because nowhere in those records does it say Munchausen by proxy. All it says is conversion disorder. It simply means that they believed that Maya believed, but there was that there was pain, but there was no organic. There's a huge difference between Munchausen by proxy, which is a criminal act, and conversion disorder. And if they can show me in any of those records where it actually says Munchausen by proxy as diagnosis, let's see it. He said it was Lurie's and...
What am I looking at? The memorial?
This is a record from Dr. Menda's.
That's not TGH, that's not Lurie, that's not a diagnosis. It's not a diagnosis.
Do you have a document from either TGH or Lurie's that says Munchausen by proxy.
I believe my question was conversion order or Munchausen by proxy.
Okay. Answer the question. Do you have a document from Lurie's or Tampa General that says Munchausen by proxy?
Not Munchausen, but conversion disorder. Factitious disorder. Factitious disorder.
No, it's not practice.
Factitious disorder.
Folks,
Sorry.
what I would recommend is get some language, and then we'll talk about it. But, you know, I am going to need to see whatever record or records are from Lurie's and Tampa General that underlie the question. So
Can we have the question read back so that we can craft an instruction? That's a request, Your Honor.
Go to the restroom.
I really want to go to the restroom myself. So, yes, you can go. And I don't know.
It was the last question. Cross-examination.
Perhaps after everyone uses the restroom, the court reporter would be so kind to help you all out with that particular question.
Thank you.
Let's talk schedule for a moment. Mr. Shapiro, how much, I know you said an hour, but I know Mr. Anderson said that direct was only going to be an hour, so.
30 to 45 minutes.
Okay, which puts us to 4:15-ish. Do we have a witness or a deposition that's an hour or less?
I don't know.
That's ready to go.
Looking at it, it's more than an hour, 35, 45, I think.
That's
an hour 20.
Our depositions are over an hour.
My question is there a deposition that is ready to play that is 1 hour or less?
No, Your Honor.
So effectively, we're going to finish with this witness and then have no other witnesses today, it sounds like.
Sounds like.
Okay, let's take less than 10 minutes for a break.
being printed.
Well, Mr. Hughes,
Everyone quit on me. I'm trying this one solo.
there you go. Come on down.
No, I don't. I think people are probably still really good.
Mr. Shapiro here.
That had already been made at Lurie Children's, Tampa General, and at Dr. Mendez's office true, and we had the objection.
Wasn't a reference to
It was a reference to Munchausen. That's what Dr. Mendez's records get used for.
My implication from the question was 3 prior institutions had already put in the records that there was a psychiatric diagnosis to this illness, with the implication being that the plaintiff's point in this case is we weren't going to agree to any transfer that contains something referencing a psychiatric diagnosis. The rebuttal is it's already in the records. We weren't the first ones to put it in there. Your signing this doesn't indicate that there's anything new. That was the intent of the question, Your Honor. But I didn't specifically say Munchausen by proxy is in all 3 of the records.
Remind me, the Lee Memorial
Is Munchausen.
was Maya an inpatient there?
She went to see her allergist, and during the appointment, he said suspicion for Munchausen's needs to be considered.
And that's the difference.
He's also a pediatrician as well. Allergist, immunologist, pediatrician.
The Lee Memorial doesn't seem like an admission then.
Well, I don't think I represented it was an admission.
The problem is, Your Honor, the term diagnosis. There is a huge difference between a doctor saying consideration must be given or thoughts may be carried. There are 7 different theories that they were trying to figure out. The question as posed puts it as a certainty that Lurie's, Tampa General, and then Menendez here all diagnosed Maya with Munchausen by proxy. Now, leaving aside for a moment the question of whether anybody there was qualified to do so and whether there's a report in saying that, which there isn't, by any psychologist or any psychiatrist, the fact is that what they're trying to do is get in something through the back door that they cannot get in through the front door because they don't have a single expert that says that Maya Kowalski had Munchausen by proxy because they gave up their CME, and without that, no psychologist or psychiatrist is going to get up there and say that. So right now we're in a situation where the jury thinks that this is an ongoing diagnosis. And so we ask the court to instruct the jury that until shown otherwise in the record of a diagnosis, that there is no diagnosis of Munchausen by proxy at any time, diagnosis of Munchausen by proxy at any time before October 7th stay at Johns Hopkins. And that is the truth.
The question that the court reporter read did not reference Munchausen by proxy.
But, Your Honor, in the lead up to that question, he had presented the Lee Memorial Health record and Dr. Mendez's record, and the only suspicion in there was Munchausen by proxy. So the question built in that lead up of the Lee Memorial Record and Munchausen by proxy, and that was the insinuation.
And not only that, Judge, it is very important to consider here that no one diagnosed conversion before this. There wasn't a psychologist or psychiatrist that went in and said, I've done a differential diagnosis and this child definitely has conversion. What all of them say is the same thing. Consideration must be given. One of the thoughts is possibilities. It's all like that. And so what the defense has here now is an inability to get that before the jury directly. And the unavoidable conclusion of the jury from listening to the first question and then this one following up is, and it's a technique, I know it, but it confuses and conflates the issues between conversion and Munchausen by proxy. And that is simply not fair and it's simply not the truth.
Anything else from the defense?
Two things, Judge. First of all, Tampa General did in fact say diagnose.
Let's hear it.
Psychological factor affecting physical condition, conversion disorder versus factitious disorder versus other. The folks at Lurie's said something similar about a psychogenic disorder. He didn't say Munchausen by proxy. What I suggest we do is to say that the last question should be disregarded and let's start over. And let's be more clear. That's what needs to happen.
No, this point needs to be made because it's going to come up over and over and over again in this trial. And that is that they do not have, and the court just heard, there's a lot of dancing around that, but nobody diagnoses it. Show me where a doctor says after interviewing Maya and after consideration of the record, we have determined, a psychologist or psychiatrist has determined that Maya Kowalski is a diagnosed conversion disorder or a factitious disorder or a Munchausen by proxy. It's not there.
Well, the only thing I would respond to that is if we're saying in this courtroom that only a psychiatrist or psychologist can make this diagnosis, then they had Dr. Chopra come in as pain management and refute the diagnosis. But that aside, it's right here on the Tampa General discharge paperwork done by Dr. Paul Kornberg, who is a pediatric physiatrist.
Let me see that, please.
Physiatrist is your first clue.
You're certainly welcome when you cross your was.
3047-0010. I am not inclined at this time to interject myself based on that last question. So I'm going to overrule your request for any sort of instruction with respect to that last question. I certainly don't want the defense to create an impression, though, that the records don't bear out. So let's just be very cognizant.
Yes, Your Honor.
Well,
okay.
Add that to the motion. We're going to get into it, and I think the court should enter some form of direction to counsel or order about this. Until they can show it, they shouldn't be coming in here and trying to mislead the jury over this. And that's exactly what's going on.
Anything else?
Not from the defense, Your Honor.
I understand.
Let's bring in the jury.
Can we make sure that this is in the record?
I'll write on it and hand it to the clerk. Okay, everyone, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
And that no one approached you about this case. Is that correct?
Correct.
And you didn't see any media coverage?
No.
Okay, correct. Mr. Shapiro, you may continue.
Mr. Kowalski, just going back to the decision to stay at All Children's back on October 11th, so 2 days before shelter, you do admit there was a meeting with the doctors where Beata wanted to take Maya out, but you said, hold on, time out, and you asked the doctors, what time frame are you talking about? And when they explained, you said that's doable. And your wife wasn't happy with what you said, but you were upset that the hospital didn't write that down. Is that true?
Objection, compound question, multiple.
Sustained.
Okay, let me break it down. You agree there was a meeting with the folks at All Children's and you and Beata on October 11th, correct?
Yes.
And you agree during that meeting, Beata suggested taking Maya out of the hospital, but you said, hold on, time out. True?
True. And because we had no choice. They gave us word we're going to be arrested.
Okay.
So it's like, calm down, Beata. We have to do something here. So.
Well, that's not what you said. What you said when the hospital told you on October 11th what the plan was, you told them that's doable. True?
We had no choice to be.
Your Honor, if I may approach.
You may.
Mr. Kowalski, to clarify,
Yes.
again, on October 11th, you were at a meeting where the doctors told you the time frame of how long they wanted Maya to stay, correct?
I don't know the time frame.
Well, you told the doctors, after they told you on October 11th, they wanted to keep Maya, you said that's doable, correct?
There was some argument there, so.
Well, you were upset when you found out that that conversation with you giving consent on October 11th to stay was not documented in the record, true?
I'm getting confused here now. Say that question again, please.
After you gave your consent at this meeting for Maya to stay at All Children's on October 11th, when All Children's told you the plan of how long they wanted there, and you said that's doable, when you found out that that conversation of you giving consent wasn't in the record, you were upset by that, true?
Objection, compound.
Overruled.
Vague.
I was upset or Beata upset? I didn't understand what.
The conversation where you gave consent to stay on October 11th, you were upset that that conversation of your consent wasn't recorded in the record on October 11th, true?
I don't know if it was the consent. What was I talking about earlier? That was not. It was about being arrested. That was not in the report. That's what I said before.
Your Honor, I'd like to play for impeachment clip 1 of the audio.
When I replied to her,
At this time.
Okay.
it was in reference to being arrested.
Sir, there was nothing. Let me ask you this. Do you remember when you sat down for an interview with Detective Graham?
I do not. Oh, Detective Graham? Yes, I do.
On that interview with Detective Graham was on November 17th, 2016, correct?
I would have to look at the date, but somewhere in that area.
I'll represent to you.
Okay.
It was, and Detective Graham was one of the investigators with Sarasota County, correct?
I'm aware of her.
Okay. Do you recall having a conversation with Detective Graham where she asked you about whether you were supportive of keeping Maya at the hospital?
I would have to see that, but there was something, I'm supportive of getting Maya better, I remember, yes.
Okay. Well, did you not tell Detective Graham that you were at a meeting with the doctors one day and Beata wanted to take Maya out, sign her out, and you said, hold on, time out?
Objection. This is reading in the...
Sustained.
Okay. Do you remember telling Detective Graham that you were in support of Maya staying at the hospital as of October?
Same thing.
They overruled on that one.
Yeah, I'm unaware of that, to be honest with you, but I know things were talked about, but I do not recall that part.
Well, let me just ask you this while the jury's here. Are you disputing that you gave consent for Maya to stay in the hospital on October 11th after having a conversation with the medical doctors where you told them that's doable? Are you disputing that?
Like I said, sir, that we were under certain things we had to follow, I do not recall that part.
Okay. You're not disputing, are you, that on October 11th that you gave consent for Maya
I'm
to
not
stay?
saying yes or no.
Objection. Let's ask and answer the third time.
You can finish, Mr. Kowalski, your answer.
Okay, yeah, that I'm unaware right now. I'm sorry.
Well, even as of November 17th, 2016, you were receptive to keeping Maya at all children's. True?
She was under state custody at that time, and then we refused the transport because of the coding.
Wasn't my question to you, sir. Even after state custody, on November 17th, 2016, you were receptive to keeping Maya at all children's hospital.
Do you have something to show me to help back that up? I don't know where you're going with this.
Okay, I'd be happy to play that
Yeah,
for
please.
you, sir. Clip 4, please. Well, sorry.
Wait a second. Are you asked, is this for refreshing the recollection? 'Cause if so, just show him the transcript.
Which depot was this from?
This is, I didn't ask for my apologies.
There's 5 depots, so which
No,
one?
this is from your interview with Detective.
Oh, okay. That's what it says there.
Well, I understand that's what it says, sir. It's true, though, is it not?
Well, I can't, it's there, so.
Respectfully, Mr. Kowalski, you told Detective Graham while Maya was sheltered at All Children's Hospital that you were receptive to keeping there even as of November, true?
That's what it says, but that interview was extremely, very, very difficult to get through. She was, you heard the tape.
You didn't lie?
Let him finish, please.
Sorry, go ahead, sir.
I was under a lot of stress. I didn't know where she was going with that. You know, but I do not recall that, but that's what's in the writing. I must have said it, yes.
Okay. So what's clear to this jury, admit that you told Detective Graham on November 17th, 2016, that you were receptive, even at that point, to keeping Maya at all children's. You're not disputing that, are you?
I'm not
That's
disputing.
irrelevant. The decision already been made. I move to strike.
Overruled.
Let me ask you about some of the bills that you were asked about.
Yes.
When did you first review the bills from All Children's?
The bills would have been after Beata's death, I would imagine.
Okay.
Because she's the one that handled the bills.
So just to be clear, the bills that you reviewed from All Children's that your counsel walked you through, you would have reviewed after your wife's death, true?
Yes, I didn't, it was, I had no idea where she kept all that, and it took some time.
Okay. At the time you reviewed them, did you believe the CRPS codes were true and accurate?
On the billing,
Yes.
it's state CRPS on there.
Let me ask you a little bit more about that. And Clay, it's Joint Exhibit 2017-663. You might be able to enlarge it for us.
Thank you.
Okay. This bill that you were shown, you see that the services rendered included for endoscopy, true?
Yes.
They included for nutrition.
Yes.
There are, by my count, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 diagnoses codes that were submitted as part of this bill. True?
Yes.
Among those were CRPS and child neglect or abandonment, among others. True?
I see that.
Sir, can you tell this jury what percentage of the $5,980 was paid for CRPS?
I don't see where the percentage would be.
Well, it doesn't say it.
Okay.
And I'm not trying to trap you, but the allegation that All Children's billed solely for CRPS treatment, that's not what that says on this bill.
When that question was given to me, I believe he asked what was if that diagnosis was on there, or what do you see on top?
Okay. All Children's Hospital was paid for the bed while your daughter was being sheltered there. Are you aware of that?
The bed? You said?
Correct.
Objection, that's irrelevant on that point.
Okay. Are you aware, sir, can you tell this jury at all what percentage of the $5,980 Aetna reimbursed was for child neglect versus complex regional pain syndrome versus a throat infection versus immunoglobulin versus constipation versus abdominal pain, etc.?
That I could not.
You can take that down, Clay. No one at All Children's Hospital ever told you that Sally Smith was an employee of All Children's, true?
No, and nobody told me that she wasn't.
All Children's never told you that Sally Smith was their employee, correct?
No, but she was wearing the same lab coat.
I'm asking you, so that's a no, correct?
I said no.
Okay. And in fact, your wife knew who Sally Smith worked for, right?
I cannot speak for that.
One moment, please. We could do joint exhibit or trial exhibit 24081739. And it's in the about 2/3 of the way down the page, it says Tuesday, 10/11 Eve, I had another supersized visit. This was the email we showed earlier that Beata wrote to you. True?
Where does it say it went to me?
It says, do you want to see the date of the email again?
Please.
Okay, Clay, let's go to the first page, 1738. So I'll represent to you, this was...
Yeah, I see it.
Okay, so let's go to the next page, 2408-1739. Tuesday, 11 Eve, I had another supersized visit from MD Dr. Smith, who was sent by CPS to investigate this possible child and abuse and neglect case. That's what Beata wrote to you.
Okay.
Okay. Let me ask you about sir, and I apologize for having to raise this. You did have plans to have Beata move out, true?
Yes, that's true.
Okay. You had prepared divorce papers?
No. It was a legal separation.
Okay. You told Detective Graham that when Maya was released from the hospital, you would have Beata move out, true?
That was the plan.
And divorce papers were prepared.
We were going to do a legal separation.
I'm going to be as sensitive and brief as I can on this topic, sir. The hearing on Friday, it was Friday, January 6, 2017, right?
Yes.
That you talked earlier, Beata was very upset about being separated from Maya for now almost 3 months, true?
She was suffering. Anybody that would be removed from their daughter would be like that.
Okay. The 3-month separation of Maya from Beata was what was causing her this emotional heartache, true?
Most of it.
That night, you do recall Beata left with a gun, true?
That was my thought, but that was untrue after time.
Okay. You reported to the police that night that Beata had left with your gun.
I reported Beata missing and potentially, well, I said the gun's missing out of the safe, but it was in the house.
Okay. You did not believe she was suicidal that night, did you?
I was very worried about Beata. I called her family, but I was concerned when the gun was missing, but it ended up finding the gun a long time after. She never took the gun.
But on that night of December 6th, you were not concerned that Beata was an immediate suicide risk, were you?
I was concerned that she was missing. I was concerned about her health. I called her family after she was denied in court. Her brother did fly in, but she did come home.
So that's a no. You were not worried about an immediate
I was worried about her. I told you I was always worried about her.
I wasn't asking if you were worried about your wife, sir, respectfully. I was asking if you were worried that she was at imminent risk of suicide.
Well, when I didn't find a gun, I was very concerned, and I called the police right away.
Beata never expressed suicidal ideation to you at any time, true?
She never mentioned suicide whatsoever.
And then the next day, which would be the 7th, now Saturday, January 7th, I think you said you and Kyle had gone out to a party. Is that right?
We went to a neighbor's house, a birthday party. Beata was going to go with. She had a migraine headache. That was the day after she was missing, and she came home that night. She stated she had a migraine headache. She was in bed. She did get up to wrap the present for the child. we went to the birthday party, and when we came home, the door was closed where she was sleeping. So Kyle and I, sat on the couch, we watched TV. Kyle fell asleep on the couch, and then I shut the TV off and went into my bed. At that time, she was sleeping with Kyle. That was like her little security blanket. That's all she had, was that little guy. So that night, her brother, like I said, I called because I was concerned about her.
Yeah, and so just to make sure I understand the question, when you came back, you didn't check on her because you did not think she was suicidal at that moment, did you?
No, she stated she had a migraine before we left, and I let her sleep.
Okay. So, and again, just so the jury understands, at no point during this process did you believe that your wife was at imminent risk of suicide, true?
I was always concerned about her.
I'm
But
not
yes,
asking you
yes,
for
it's
consent.
true. I was always concerned about that. With all that was going on, yes.
But Beata never expressed any suicidal ideation to you in November, December, or January, true?
November, December, January. There was a report from the hospital that she, in your records or in Sally Smith's records, that somebody within the medical.
Sir, I'm asking you about report to you.
Can he please be allowed to answer the question, Your Honor?
It's non-responsive to my question. My question was very simple.
I agree. So why don't you ask your next question?
Okay. My question to you, sir, was this. Did Beata ever express any suicidal ideation to you in November 2016, December 2016, or January 2017?
She never told me that she was going to take her life, verbally.
The jury earlier saw one of the suicide notes. Do you know why Beata said, I give rights of my parental rights of Maya and Kyle to my sister and brother in Chicago?
No, I do not know.
Let me ask you a little bit about Maya after she got out of All Children's. We had a chance to talk to, at least my partner, Mr. Hunter, did, in November 2019, to give you an idea of time frame.
First depo.
Yes, sir.
Okay.
At that point, so now we are a little over 2 years after she got out of All Children's Hospital. Other than allergy medications, Maya was not on any medication, correct?
Not that I'm aware of. I would have to review that.
Okay. She had not seen anyone for asthma in over 2 years, true, by that point?
That's true, and hopefully, like we said, ketamine and hopefully the hyperbaric chamber did help for that.
Okay. Well, to be clear, after she got out of All Children's Hospital in January of 2017, she's never received any ketamine, has she?
No.
And she's never gone to hyperbaric medicine, has she?
No.
In fact, as early as 2018, you were able to scuba dive with her.
She scuba dived, but with her arms.
Okay. Well, she was back in school the next following year.
Yes, on crutches.
And she became president of her class, true?
That is true.
She was waking up at 4 a.m. Running in the morning?
Running?
She was exercising
Not running,
at 4
she
a.m.
exercising.
Okay. She, as of that point, at least when you talk to my partner, Mr. Hunter, you did not see any signs of CRPS in her at that time. True?
At that time.
Okay. And again, when we talked to you in October of 2020, you saw no signs of CRPS in her at that time either. True?
No, but unfortunately there are signs now.
Okay. Well, let me ask you, Maya has been able to get a job working at Cracker Barrel?
She worked there. She waited tables, and she had somebody carry the heavy load.
She got back to ice skating?
For a short time, yes.
She has no physical limitations right now. True?
I wouldn't say true. She knows her physical limitations.
She was back in phys ed class.
The what? I'm sorry.
Physical education class. She was able to get back into physical education class without restrictions. True?
True, but she had problems running.
And again, in that period of time, within 2 years after she left All Children's, from your observations as her father, you did not see any signs of CRPS, correct?
It never went away, just so you know. There was pain here and there. It's not like it was a clean slate. So I would say untrue on that.
Okay, well, let me ask you about that. When you were asked on November 6, 2019, what signs or symptoms do you see of CRPS in her today? You said, I don't see signs, no evident signs. She's not complaining of pain. Her muscles are built up. There's no lesions. I don't see nothing right now.
That is correct. And I don't know if you heard earlier, she hides a lot from telling me as well.
One moment, Your Honor. Just a couple more questions, sir. The
famous
yeah,
one.
True. The photographs that we saw earlier
yes.
of your daughter, Beata had not seen those before she died, correct?
I wouldn't say that's correct. She would have seen some of them, yes.
No, okay, so just to be very clear, the photographs that were taken the day that Maya was being brought to court for the DCF dependency hearing, Beata had not seen those before she passed away, correct?
No, but she heard about it.
Well, you had not.
I have not seen them as well.
Okay. You had not seen the photos and she had not seen the photos, true?
Correct.
One moment now. Those are the questions I have. Thank you, sir.
Thank you.
Redirect.
So those medical records had a lot of direct quotes in them, didn't they?
Medical records.
The Johns Hopkins records? They were trying to say what you were saying?
No, I mentioned that before. Yes.
And they kept bringing out what would be considered sort of negative information, right?
Objectively leading, Your Honor.
Overruled.
Yes, and like I say, there was several things missing, such as lesions or dystonia, things like that.
Well, right. These are the same people who stopped documenting symptoms after a certain period of time. Is that right?
Objection, leading, and argumentative.
Sustained on that one.
What, if anything, did they do about those lesions and other symptoms after about, I don't know, October 13th or 14th?
They went from lesions to self-inflicting wounds.
So these same people have got all kinds of direct quotes, right? Isn't that true? And they've got a lot of assertions about where you did, what you did, right?
Objection, leading, and argumentative.
Right now, it's just a statement. I haven't heard a question, but it does sound a lot like leading.
Right. Well, let me ask you something, Jack. Through all of the records that you have seen back from TGH and back from Lurie's and back from the other doctors, did any of them put up a system of direct quotes and denials and you said this is and they believe that?
Objection leaving vague and argumentative.
Did,
Okay, I didn't understand the question, so I'm going to sustain on vagueness.
was this the first time somebody had put into the medical records all of these types of allegations consistently against you?
Objection, again, vague, argumentative.
That one's overruled. You can answer that.
That all the hospitals did the same as
No,
what they did?
I'm asking you whether this was the first time, whether Johns Hopkins did it. Was this the first hospital that had ever put all this kind of stuff into your record?
Oh, yes. Yeah, there's quite a bit of stuff in there.
So from this perspective, were you relying on them to be the treating physicians at this point? Is that right? Johns Hopkins was supposed to be treating your daughter.
Yes.
They were not supposed to be prosecuting your family, were they?
Objection, move to strike.
I'm going to overrule that question.
I'm sorry, say it again.
They were not supposed to be trying to prosecute your family.
Absolutely not, no.
All of this stuff, correct me if I'm wrong, all of these things they put in there were after they had taken the position with the outside world that Maya was making it up and Beata was essentially a criminal.
Objection.
Is that right?
Argumentative misstates the evidence.
Sustained.
Wasn't this all after allegations of Munchausen by proxy and conversion disorder had been raised?
Same objection.
Overruled on that.
Yes.
So when you go through all of those records and compare them to the last hospital records, do you come away with the feeling that they were actually trying to help you or build a case against you?
Objection leading.
Alternative. I didn't hear you ruling.
Sustained.
What, if anything, did it appear Johns Hopkins was trying to do in those records to you?
Objection, again, argumentative misstates the evidence and lack of foundation calls for legal.
I'm overruling that one.
My feeling, they were painting a picture that we're doing something wrong.
And they were supposed to be your daughter's doctors?
Yes.
How many times in your life had you had doctors put all of these things in your records just randomly?
Objection, vague, and argumentative. That's all these things.
Sustained.
How many times prior to Johns Hopkins had any doctors consistently put negative after negative after negative, you said this, you said that, comments in your record?
Objection, same objection.
Okay. Well, you can answer it this last time, but Mr. Anderson, you need to move on.
I'm about
You
to.
have more than amply made your point.
I understand.
So go ahead and
I can
answer it, and then we need to move on.
That's the first time.
So was Johns Hopkins, to your view, trying to get your daughter well and get you out of there?
Calls for speculation, objection.
From his perspective.
You haven't finished the question, but it also sounded like it was going to be a compound question, so let's try to rephrase the question.
Did Johns Hopkins ever come to you at any point after they first told you on the 9th that you couldn't leave and tell you, it's okay now, you can leave?
That we could leave? No.
No, that you could leave.
Was there an objection?
No, Your Honor.
Okay, no.
And so were you operating under the assumption throughout this period of time that if you took your daughter, stepped out the door to get out of there, you would be either by security to the police or to the police end up in, well, custody?
Objection, the leading, Your Honor.
Overruled on that one.
That's what we were worried about.
I want to talk for a moment about any statements to this Detective Graham. Let's take the jury to what happened there. So, what's the first time you saw this detective?
I went to visit Maya for a visitation at the hospital. That was through Kathy Beatty at the time. I had to go through the hospital social worker for visitation. When I arrived, I went upstairs to get Maya, and she wanted to go down to the cafeteria to get a piece of cake or mashed potatoes. I don't recall what she wanted, but the door opened, and Kathy Beatty was there with a Sarasota County Sheriff's investigator, female.
Now, before this time, had you had any conversations with or involvement with the police over this?
With Graham, no.
So somebody called Graham to get her over there, from the best of your knowledge?
I'm sure it was coordinated because they knew exactly where I was.
And Ms. Beatty directed her up there, is that true?
They met us at the elevator doors downstairs.
All right. So you're there to see your daughter.
Yes.
Tell the jury what happened after that.
So they wanted to speak with me, and I advised them I was just going to feed Maya. So they allowed me to go have lunch with Maya. Then I brought Maya back upstairs, and I informed her I'll be back in a little bit. Well, it was a long time. Detective Graham brought me inside a room. And
Hang on. When she brought you inside the room, was she armed, to the best of your knowledge?
I don't recall seeing a gun.
Did it turn out later she was?
I don't.
Objection, Your Honor, speculation.
Sustained.
And so, did you know you were being recorded?
No, not at all.
She did not explain that to you?
No, she, at one point, she said she had to look out the window and pay her parking meter or something, and she reached in her purse, so obviously maybe just changing the tape or whatever.
In her questioning, did she seem like she wanted you to testify against your wife?
Oh, yes, it was like a big wedge.
Mm-hmm.
Yep.
You ever heard of flipping a witness?
Yes.
Objection, speculation.
Or a suspect?
Overruled.
You ever
Yes.
heard of, and so her questioning in there, did she or did she not warn you before any of this questioning that if you weren't going to cooperate, if you aren't going to help, that you were going to spend time in jail?
Objection.
That's on the tape.
Leading and speculative.
Well, I'm going to sustain the leading, overrule on speculation.
What did she tell you about what was going to happen if you didn't turn on your wife?
She stated that she put other people in jail for many, many years and basically do the same thing to me.
So what was your choice here?
Cooperate.
And what happens if you didn't cooperate?
Object, speculation.
Overruled.
That I didn't know. That was scary.
Well, had she already told you she was going to?
Yes, yeah, that was burnt into me right away.
Well, then your choices were what? To either testify against your wife or, from your perspective, go to jail?
Objection, argumentative, speculative.
And
Overruled.
you can answer.
Yes.
And so throughout this process, did she suggest, as we've heard, the answers to the questions in the question? You know what leading questions are. You've heard that here.
Yes.
In all of these things, did she suggest how you should answer in the question?
Yes. And then there was times where, just she had so much from the other side about all these high dosages and this drug is so dangerous. And, how dare, I don't know the exact words, so don't quote me on them, but it's basically how dare you for even doing what you did by going to Mexico, things like that.
Wait. She came in loaded with information from Johns Hopkins?
Yes.
Objection, leading, Your Honor.
Where, if any, if you're aware, I'll rephrase, where, to the best of your knowledge, would she get all of this information about your medical history?
Objection, speculation.
He knows.
Do you know?
I would assume that it came from the hospital.
I'm going to sustain the objection.
All right. Was there anyone else other than the hospital at that point who had all of that information?
No.
Logically, who was the only entity or person who could supply that information to the detective?
Objection, again, lack of foundation, speculation.
That's the predicate. It was a predicate. Never mind. So, what did you think you had to do there in order to see Maya again?
I had to cooperate.
If you wanted to take your daughter home, what did you have to do?
Oh, this was something that was discussed with the attorneys. Like I stated earlier, I had an attorney. I don't know if it was at that time. I had an attorney, Beata had an attorney, and the children had an attorney.
So she questioned you without counsel. Were your attorney there when she was questioning you?
No.
Objection, again, to the leading.
Was you? So, can you tell the jury whether you were questioned without an attorney?
I was questioned without an attorney.
Did you have any help then, in case she said inappropriate things, to call her out on it?
No, not at all.
And so did she imply to you that if you weren't going to say yes to a lot of things, that you were going to have a great deal of problems down the road?
Yes.
And is that why you said the things you said?
I did, but then I defended myself on a lot of them. At the end, where she didn't record as well, going down the hallway, I said my wife would never do something like that.
So you told her that?
I did.
Didn't you tell her that on multiple occasions in
Yes.
that recording?
Yes.
And what did she do once you said that? Did she
Go to the next.
But wait, once you said that, did she relent and stop asking you leading questions, or did she continue trying to press you into saying negative things about
Just
your wife?
kept.
Objection, the leading, the argument.
That's alternative.
And sustain the leading on that one.
Did she tell the jury what, if anything, she did in terms of accepting the fact that you had told her repeatedly that Beata would never do this?
That she just repeated the question again and again type thing.
On certain occasions, did she repeat the question on multiple times?
I don't know how many times or whatever, but some were, yes.
At the hospital, during the first part of the time you were there, when Sally Smith walked in, as you testified, in a white lab coat, were you relying on Johns Hopkins in terms of not letting people wander around their hospital with a lab coat on?
Objection, the leading, Your Honor.
Sustained.
What, if anything, did you rely on the hospital for in terms of keeping people with a white lab coat and the emblem on it out of your daughter's room?
Objection to the relevance.
Overruled.
What did I rely on?
No.
I'm sorry.
Did you rely on the hospital in that regard to keep people out?
Oh, yes, yes.
And so did you start to discuss things with Dr. Smith thinking that she was another doctor there?
I didn't even know her name at that time. She never introduced herself. She just came in and just started asking questions. So, yes, I thought she was a doctor for Johns Hopkins because she came in alone. She was the only one in the room with Maya and I.
So no one introduced her?
No.
Did any hospital person correct that misassumption?
No.
And did you learn later that she was, in fact, closely aligned with the hospital?
Objection, mischaracterizes the evidence.
Overruled on that one.
That she was in with the hospital? Yes.
So now, in this case, and you've been following it. Excuse me. How many times have you been deposed in this case?
5 times.
How many times has Maya been deposed?
5 times. Kyle won, I believe.
And you have stayed in touch with who were deposing and who were not deposing. You followed the case, in other words.
Yes.
And have you heard whether any psychologist or psychiatrist prior to Johns Hopkins on October 7th ever diagnosed Maya with some type of fictitious disorder?
No.
prior to October 7th, did any psychiatrist or psychologist diagnose a Munchausen by proxy situation?
I never heard of that, no.
From your knowledge of CRPS, how unusual is it to have people at first question and consider these types of diagnosis, conversion disorder?
I wasn't really educated on that, but a lot of them are diagnosed with that, fictitious or conversion at first, because they didn't get properly diagnosed with CRPS. But in Maya's instance, she was diagnosed with CRPS, after Tampa General.
You've been asked on several occasions whether during certain times, particularly, I think October 11th, on October 11th, then, how many days was it until the state actually entered an order to take your daughter? Was it on the 14th?
The 13th, I was told to leave.
So by October 11th, you were pretty much through with your week there?
Yes.
And so when Beata started to, well, let me put it this way. Was your wife shy about stating her opinion to the Johns Hopkins doctors?
No.
And were you concerned that if Beata continued to press them, they would keep Maya longer?
My personal feeling, yes.
And so, in terms of approach, did you try to present a more relaxed and not quite as intense approach than your wife?
Yes.
Now, by was it your impression, based on everything that happened to you, that the reason for your losing your daughter was because of the use of ketamine? Losing your daughter to the state was because of the use of ketamine?
Yes.
So after you got her back, tell the jury just how interested you were in trying ketamine anymore.
Well, I was instructed not to, but we've seen great results with it. And
so, continue.
There's times, we wish we were able to get her treated. And now I'm seeing her, getting a little downhill here. So I'm very concerned.
But have you remained concerned that if it gets out to another doctor that maybe doesn't know you as well, that something might happen?
Sure. Absolutely.
And from your knowledge, and how old are you now?
62.
Sorry, Dad.
But I feel like 80 after today.
But has it been your experience that once something gets into your medical records, it tends to stay in your medical records? It's
stuck there. Yeah.
And throughout this period of time, then, did it appear to you that Johns Hopkins had prejudged you,
Objection
you and your wife?
For legal conclusion.
Prejudged.
And speculation.
I can rephrase.
Yeah, prejudge, I don't understand that.
Got it.
Sustained.
Well, in reviewing the records to Tampa General, did you read where Johns Hopkins had sent over a, if you will, transfer report?
Did Tampa General send one over?
No. Did Johns Hopkins send one over to Tampa General to start this out?
We went from Lurie's to Tampa General.
I got it.
Okay.
But do you know if...
that I would be unaware of. That would have been Beata.
Fair enough. All right. So Maya tried quite a number of her old activities as she got a little better.
Yes.
Did they last?
Some.
And why didn't they last?
It was too much pain.
And what about memories of her mom? Strike it. Who introduced her to these various activities?
Well, Mom, Beata, and Kyle, they did ice skating. At first, it was the two kids, and Mom was sitting on a cold bench in the ice rink. So she decided to start ice skating. Then that was up in Chicago area. And then she did the same thing here. Instead of sitting there, while she was doing her treatments, different patients in different locations, if she went by Ellington, she would take her lunch and skate.
Well, from what you saw, did Maya have a difficult time doing activities that she used to share with her mom?
It brings back a lot of memories, yes.
And were you pleased he was at least trying to do these things?
Yes. Oh, yes.
But was it typical that when she tried an event, a sport, a hobby that had been introduced to her and supported by her mom, it didn't last very long?
Yeah, and I see that with the piano as well right now, too.
Is she playing piano much anymore?
Not much.
She play a lot before your wife died?
It was every day, and in fact, she did it in the hospital as well. She enjoyed it at that time.
So she doesn't do that anymore?
Not much.
She tried ice skating. Does she do that anymore?
No.
Of course, never got back into gymnastics.
No, and her workouts are very limited right now.
So many of the activities that she used to enjoy, can you tell the jury whether they're now no longer there or limited?
Object to the leading.
Overrule that objection.
A lot of them are gone.
Are you aware that she quit Cracker Barrel?
She did, yes.
Are you aware she quit Cracker Barrel after a matter of a couple weeks?
Yes, she had a dizzy spell, several dizzy spells there. And like I stated, she didn't carry the food there. She had one of the people that clean up or somebody from the kitchen carry the food.
All right. Now let me ask you about a note that was put in front of you with Beata's handwriting that said, IV ketamine, desperate.
Yes.
Can you tell the jury how the IV ketamine was administered? Was it administered through the arm or was it mixed with something?
Yeah, this is a little confusing. Originally, after the treatments, she would get some take-home, I don't want to say take-home ketamine. She had pre-filled syringes without a needle, and it was given orally. And these were made up at King's Pharmacy in Palm Harbor, Florida. So after her treatments at Dr. Hannah's, we would have to go pick up that prescription, and these were for to give at home. It was difficult after a treatment to go to King's Pharmacy and pick it up because you have the child in the car and she just got out of the treatment, so she's tired in that. But we did that.
Well, how did you administer it? Did you mix it with something?
That one was mixed. I don't know if there was a flavoring in it at that time. But then she also had ketamine ointment for her lesions, to rub on the lesions. And then after time, the cost of those pre-filled ketamines for the oral, I believe they were pretty expensive. So at one point, they went from that to ketamine IV. It was a vial, and then you pulled the ketamine out of there, mixed it with Gatorade, and then gave it by mouth, oral. But it was confusing because now you got a IV prescription for ketamine. And that would last a while, I believe, because it was bigger or something like that.
Will you please tell the jury whether you ever saw, heard, smelled, tasted anything in any way, heard from Maya, anywhere else, that Beata was giving Maya IV ketamine as an IV at home?
No.
And when Maya came in that first day, do you dispute many of the things that they put in those records?
Objection, vague.
I'm about to.
Sustained.
Do you dispute the inference from what they're saying that Maya was thrashing around needlessly? Was there purpose behind that?
I justified that earlier. Yeah, I stated she was thrashing, but it most likely because of the blood pressure. And it's like putting gasoline on a person and lighting them on fire. I'm sure if you try to take their blood pressure, they're not going to cooperate with you at that time. I hate to use that analogy, but
You know, it's interesting. On the photographs we do have of Maya in the video, you know, she doesn't seem to be that bad. Did you make a habit of videoing her or photographing her when she was curled up in bed on a bad day?
personally, I hate it too. It tore me up. And just seeing some of the pictures today of her little legs and her trying to lift them up, I don't want to ever, I cannot wait till this is over with to get rid of all that.
One moment, Your Honor. On the amounts, finally, on the amounts involved in and the number of entries on those Aetna billing forms, are you worried so much about the fact that it's the percentage or amount, or the fact that Johns Hopkins was telling Aetna and apparently privately saying she had CRPS, while in public and in discharge notices saying that it was Munchausen by proxy?
Objection, leading, and misstates.
What, if anything, was your concern?
I sustain the objection.
What, if anything, was your concern about them putting CRPS in the bills, billing Aetna for CRPS, while things like that, discharge, were saying Munchausen by proxy?
Objection, leading, and argumentative again.
I ask what?
Overruled on that one.
My concern was they're billing for it, but they didn't treat Maya for it, which she definitely needed treatment for CRPS.
Mr. Shapiro, any further questions?
Very briefly, you're the only one.
Checks in the mail.
And Mr. Kowalski, just to be clear, when you met with Detective Graham, everything you told her was true, correct?
Like I said, she led me to answer some questions, but I did not lie.
That's my question to you. When you met with law enforcement, were you truthful with them?
I was truthful with her,
Thank you.
but I was led to certain things.
Well, sir, whether you were led there or not, were your answers to the detective truthful or not?
Yes.
Okay, thank you.
Mr. Anderson, anything further?
Was the fact that somebody had called the sheriff's department to get her down there of concern to you?
Very concerning.
Did you believe at the time you were giving those answers you were under duress and being threatened?
Objection, it's beyond the scope, it's also argumentative.
Overruled.
I stated that earlier. Yes, I was.
No further questions.
Nothing further, Your Honor, thank you.
Members of the jury, do any of you have any questions for Mr. Kowalski?
Sorry.
They wrote a novel.
Be here.
No.
Okay, members of the jury, I'm going to ask that you step out because it'll go faster if I don't have that white noise machine on. So this is actually to speed things up. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All rise for the next thing.
Jury's out of our presence. I'm going to ask that Mr. Kowalski step outside so he doesn't hear the questions ahead of time, since I don't have the white noise machine on. I do want the lawyers to stay up here because this way you can physically look at Okay, please be seated. Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that correct? And no one approached you about this case. Is that correct? And you have not seen any media coverage. Is that correct? And just to let you know, when you walked out and I turned off the white noise machine, I asked Mr. Kowalski to step outside, so he did not hear me going over the questions with the jurors. So just wanted to let you know. And there's, I will tell you, 9 sheets of paper. 8 pages are full sheets. I got 1 page that's not a full sheet, so. Perhaps in the future we can just do a full sheet. Okay, Mr. Kowalski. Yes, sir. I'm just going to start reading questions, and I will say to the jury, I'm going to be able to ask most of them. There's a couple that I'm not going to be able to, but almost all of them I'm able to ask. Okay. Did you file a legal separation from your wife at the advice of legal counsel to get Maya home?
Glad you brought that up. Yes. It was advised by the child's attorney to get a legal separation. That way Maya could come home and be out of the hospital. But, I'm sorry, it wasn't the children's attorney. It was one of Beata's or mine. And the child's attorney advised not to, because the problem there, now mom wouldn't see Kyle. She wouldn't have no kids to see. But she agreed to move out of the house to have that happen. But it was the advice of the children's attorney not to do that, because now she would be without Kyle.
When you checked into the hospital, did the hospital registration explain your rights and responsibilities, or just ask you to sign the consent form?
It was more of signing. Maya was in severe pain. There was no, they didn't explain anything at that time.
Okay. And there's a question on that sheet that I'm not going to be able to ask that last question. Mr. Kowalski, this is in regards to the hospital, or the hospital wanted passwords of Maya's social media accounts. Was this requested verbally or in writing?
They called me.
Okay. Do you recall who requested a name, a known name?
I do have it. I believe it was Child Life that wanted it, and they stated that they wanted to set up a computer for Skype. But Maya had her own computer there already, so I didn't understand why they couldn't use that one. But they wanted Maya's passwords for all her social media and that. And my recommendation was to just go ahead and use a new password and just give it to us. That'd be a lot easier.
Well, I think you were anticipating the next question. Were passwords given to the hospital?
No.
Okay. Also, was Maya allowed to use social media while in the care of the hospital?
No, she was allowed to use a computer for school. This, I think Jackie Dietert mentioned that. It was the first time the school did something like that, Skype. And then it was probably a good thing for them, a good test, because not too much longer COVID was here and everybody was learning from home. But
did the hospital keep Maya from communicating or posting via social media?
I do not believe she did any social media there at that time. That I honestly couldn't answer that one fully.
Okay. The same juror, the next page, I'm not going to be able to ask those questions. Maya was discharged with 3 to 4 diagnoses by Johns Hopkins All Children's Hospital, and none were CRPS. Is that correct?
That is correct.
Next question. When, if at all, was Maya ever examined and given a diagnosis of CRPS? RPS, the date and the doctor name, please?
That was Dr. Anthony Kirkpatrick in Tampa, and that was after the Tampa General, so I would say, I'm guessing around August. I could be wrong on the date or the month.
Okay. The next series of questions. You are stating that the detective, after identifying herself and you agreeing to be interviewed, did not, 1, place a recording device in plain view, like on the table you were sitting at. I guess, is that correct?
That is correct. It was not in view.
Is it correct that she did not ask if she can record the interview?
That is correct. She did not.
Is it correct she did not start recording and first, on the record, identify herself, title, the date, time, location, and your name as being interviewed?
I didn't hear that. I don't believe so.
Thank you. Now we're going to the next juror's questions. I have to say, I appreciate y'all have much better handwriting than me, but my handwriting is horrible, so at least I'm able to read y'all's, so thank you. When you testified that Maya was not having withdrawal, how would pain reaction differ from withdrawal?
What I believe the question was with the withdrawal that was from the medication. She did have pain, though. She was always in pain, and like I said, it's not a constant level of pain. It could be high and it could be low. But when we were discussing withdrawal, that was in reference to ketamine. I never seen a withdrawal from ketamine.
What did you observe that helped you know the complaints were pain versus withdrawal?
Her complaints?
Yes, her being Maya's complaints.
The pain, you could see her guard, and then, her facial expressions. A withdrawal, I would imagine more shaking, things like that, like a seizure, but you could see the pain. And I know her pain, so I knew the difference, and I never witnessed a withdrawal.
Next question. When Maya had her issues on July 4th, it seems that lack of motor function and pain reaction seems like a significant development. The record showed treatment took place a few days later. When did pain climax on July 4th?
She had pain, and they first believed it was from all the steroids she received. But then later in July, I believe, July 20th, that's when we really started seeing more signs with the pain.
Again, you contemplated the next question.
I'm good at it.
How long between episode to ER treatment?
I believe there's one before the 17th, but there was one in between, I believe. I could be wrong, but I'm almost positive. But we see more pain and more problems as it went on.
If there was a delay of more than a couple hours, why?
I don't understand that one.
Okay. I'm sure the lawyers can follow up. Maya's room, when it moved, did Maya get moved often? If so, how often?
Maya did get moved, and I read in my notes just recently, she asked that question, and the nurse stated after 30 days you get moved to another room. I don't know if that's true or not, but I just read that today in my notes.
How many floors was she moved to during her stay?
I know she went from the first floor, and then the main most of the time was on the 7th floor. I could be wrong. There could be another floor involved I honestly do not remember. But all the moves to rooms was basically on the one floor of, I believe it was 7th.
And did Miss Beatty follow her through the floors?
Yes, she did.
Next question, and for the juror, I'm not going to be able to ask that next question on your list, but the following one, in your experience as a fire expert, are parents usually a trustworthy source of information during an emergency or a hindrance to EMT assessment?
We utilize the people as much as possible. If they were, there's great resource, medical, and then also fire incidents. If you have somebody in a building trapped or whatever, they may tell you exactly where they're at and how to get in there. It'd save a lot of time. We don't have this where like a football team where you could take a timeout and figure everything out. You try to get information right away and act on it. They could be a problem too, where they're trying to tell you everything to do. And as a manager, all the fire officers went through a lot of management classes. They could be a great resource or they could be a problem. And if they're a problem, you should just kind of remove them from the area so you could do your job.
Did Beata supply dosage information to her blog?
That I don't know. I never really followed the blog.
Okay. How frequently was she updating it?
That I don't know.
Okay. So you wouldn't be able to know how specific?
No, sir.
Okay. Or a police source?
The what source?
It just says police source.
Police source?
Yeah,
I honestly don't understand that.
Had you met the officer who investigated the suicide prior to the suicide?
No.
Okay. Was the local, quote, force, end quote, aware of your career?
I'm sure they were. Yeah, they do ask you your occupation and everything. In the garage, I do have my old fire code in there, so I'm sure they've seen that. But I believe they do ask you what your occupation was.
Okay. Next question. You stated you did not want your daughter to take opioids. Did you request alternative medicine the first time the opioids were prescribed?
I don't know when the first opiates were prescribed, but we looked at the hyperbaric treatment, and that was without any medication. We thought that would be a good route to go. Unfortunately, it was out of pocket, but at that point, we didn't really care. We cared about Maya more than anything. And I meant to ask the doctor about if that helps the liver too, but I'll have to find that out someday.
Well, I'm going to go ahead and ask this, although I wasn't quite sure if, based on your answer, but if the previous answer was yes, what were the options and why did you decide against the alternative medicine?
Oh, yeah, I wasn't the one doing most of the research, but I really don't have an answer for that one.
You stated most communication went through Beata.
That is correct.
Would you read through the medical notes throughout the duration of Maya's illness to ensure you received accurate information and to ensure that there was a clear understanding of communication between Beata and the medical staff?
I did not review them in full. She would let me know. She dummied it down for me. I do not know a lot of these terms or treatments, but I had 100% trust in her.
If your brother was not approved for visitation at Johns Hopkins All Children's Hospital, how was he able to drive Maya to the Sarasota courthouse for Dr. Duncan's evaluation?
I'm from a family of 8. It was my other brother that drove Maya to the courthouse. It was not Bob. That was through the court.
During the time of the surveillance video at Johns Hopkins, do you know if medical orders were placed that required Maya to have assistance getting out of bed because of safety concerns?
I'm unaware of that.
Page 8. At any time has Johns Hopkins All Children's Hospital staff, and I guess this is if you know, at any time has Johns Hopkins All Children's Hospital staff been trained on CRPS, how to treat, and when did that training take place?
That I do not know.
And for this juror, I cannot ask the next question. The next question, Kathy Beatty, does Kathy Beatty work at Johns Hopkins All Children's Hospital or CPS or DCF? And is she still working there?
I believe she was an employee of the hospital and she's no longer working there.
And the last page, the page that isn't the full page. It's missing its friend. Okay. Was an assessment or investigation ever conducted on the family to either confirm or rule out the Munchausen allegation?
All family members, we had to go for a forensic psych evaluation. That was through Dr. Duncan. And I believe that's what they were trying to use that to rule it out. And I believe we heard Dr. Duncan with her findings.
And then the next question is, if so, by who?
Dr. Duncan.
Okay. Members of the jury, that concludes the questions that were given to me. We're at 5:25. I see we've got one more. Let me ask you this. I'm sure the plaintiffs and the defense are going to have follow-up questions. We're at 5:25.
I don't, Your Honor, if that helps for timekeeping, but it's up to you.
Okay. Do you want to finish this witness, which might be 5, 10, 15, 20 minutes, or do you want to leave for the day? Okay, so what I'm going to do, I was just handed another question, but for the sake of time, I'm going to let Mr. Anderson ask his questions. Then we'll see if Mr. Shapiro has any questions. And then we'll go back to see if there's any further questions in addition to this question.
Jack, you were asked about whether the hospital had any training in CRPS. Were you told that they did not have a pain clinic, and that was why they wanted to transfer you to Nemours?
Objection, hearsay.
Overruled.
At that time, I know they did not have a CRPS program. I know I could be wrong, but I believe it was Dr. Elliott saying that they're in the future gonna have one. But at that time, I believe there was not.
Was the excuse to transfer you that they did not have a pain clinic or CRPS program when you all came in?
Is it true?
Yes.
That is true. At that time, they did not, according to Dr. Elliott.
All right. And I'm trying to read the questions too. You were asked about, I think, I have a question for the court. We'll take it up in a moment. On the 4th of July, there was a question asked about how soon you got treatment after Maya had the event on the 4th of July. Did you take her to the ER immediately?
Yes, Beata took her to, I believe that one was Sarasota Memorial, and that's when they only had their main campus. So it was in downtown Sarasota.
During the time you were there, how many rooms did she end up going through? And if you recall from
I'm going to guess 3 to 4.
When you were on the inspection, did you point out 5 or more?
Most likely.
And was it true that during the times that you visited her, you were less than 30 days between visits and she would be in different rooms?
Objection, again, leaving a lack of foundation.
Overruled. You can answer.
There's times I'm sure it was less than 30 days, yes. If you did the math, yes, it would be.
I think what the jury wants to know was that did that appear, that whole move every 30 days appear true to you or a excuse for moving her 4 or 5 different rooms?
Objection, foundation, argument.
Overruled, you can answer.
I'm sorry, can you repeat that?
Sure. I think what the jurors are interested in knowing is whether that moving her to a different floor every 30 days was, to you, did you take that as a true reason, or was that an excuse based on what you saw?
I don't think it was a true reason. I would believe it would be an inconvenience for them to move everything every 30 days.
So in your experience in visiting her, did you go to different rooms within a 30-day period?
Yes.
All right. And you'd been asked a question about them being trained in CRPS. I think we've already covered that. One more. Let me see. Through the time that Maya took, had the ketamine infusions, did you learn or see whether it affected her liver or not? Did her liver functions remain normal throughout all of that?
Yeah. This objection is beyond the scope of the questions presented.
No, it's
You can
about.
answer.
I know it affected it, but it would come down. I am not a doctor, and I think the best place to find that is maybe in their Dr. Hannah, Dr. Kirkpatrick, or Cantu's medical records. But I know it wasn't a big concern.
So was it actually during the infusion that they would have some variance, and then afterward nothing?
I believe.
I'm sorry, Mr. Kowalski. Again, it's leading and it's lack of foundation based on the last answer.
Overruled.
Yeah, I believe it was a short term during, but I personally don't know exactly.
Fair enough. You were asked about the decision, not the decision, but the option of filing for legal separation. Was that because you no longer loved Beata, or was it a tactical decision to try to get Maya out of that hospital?
It was nothing about not loving my wife. It was about getting Maya out, and Beata was 100% compliant with that.
And throughout this entire period of time, despite all of the tension, did you continue to love your wife?
100%.
Are you finished, Mr. Anderson?
I'm sorry.
Yes, sir.
Okay. Mr. Shapiro, did you
I
have?
don't have questions. Thank you, Your Honor.
So no questions?
No questions.
Members of the jury, do you all have any further questions? I know there's one, but is there any other questions from anyone? So can I have the attorneys up here for just this one? Okay, Mr. Kowalski, after being released from Johns Hopkins All Children's Hospital in January, I know the question says 2016, but I think it's 2017 is what the juror meant. So after being released from the hospital in January of 2017, has Maya ever been re-diagnosed with CRPS, or are those the 3 or 4 diagnoses from the hospital or the last?
Once, I believe with Dr. Chopra, he stated once you have it, you always have it. She was never re-diagnosed. She did do a follow-up with Dr. Anthony Kirkpatrick with no treatments, but he did see improvement in her condition, but he sees that there is still CRPS.
Any follow-up?
Jack, the November 2020 admission.
Yes, that was at Arnold Palmer Hospital.
Was there not a diagnosis on that?
Yes, I'm sorry, I completely forgot about that one. And that was, we were in the hospital for a week on that one.
Defense.
No other questions, Your Honor.
Members of the jury, any other questions? I see you're all packing up, so what we're going to do is we're going to call it a day. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We will meet at the regular time tomorrow. Yes, I'm aware there's a national emergency alert that all our cell phones are going to be going off. And we're going to put all the cell phones right in your box. No, we'll take care of it. So with that, if you could just follow Deputy Coley out, have a great evening.
All rise for the second segment.
You're free to get off the hot seat there. Let me just add this up, because I know you're going to ask. Okay, by my count, the plaintiffs. Okay, the plaintiffs consumed 3 hours, 25 minutes. The defense consumed 1 hour, 40 minutes. So the plaintiff's running total is 20 hours, 35 minutes. The defense's running total is 6 hours, 35 minutes. Are there any issues we absolutely have to deal with today before we leave, or are we finished for the day?
I am sad to report that, well, Nick just informed me, we got a text or a call from Dr. Newberger's wife, and he is in the hospital. Does he say critical care or just in the hospital or what?
They're trying to diagnose, I don't know that. That's other than that.
But he's still in the hospital?
Yes.
So we may end up, the court's in diligence, having to play that depot.
Well, thank you for letting us know. It wasn't going to happen tomorrow anyway, so everyone's aware now. So we'll deal with that. Is there anything that we have to deal with tonight?
Not
No,
that
you're-
we're aware of.
Not from the defense. Your Honor.
Okay. Are we comfortable coming at 8:30 as opposed to 8:15 tomorrow?
Yes, Your Honor.
Yes, I am.
I would like to try to resolve that limiting instruction while the jury still remembers they had a witness.
Well, if we have time tomorrow, just muscle your way to the front of the line, Mr. Altenberg.
Okay.
Okay, we'll be in recess until 8:30 tomorrow morning.